Okay, good morning, everyone. We have quite a crowd. Let's call to order this hearing of the Assessment Appeals Board for October 8th, 2018. Welcome. I'll first ask Mr. Vlahakis to call roll.
Board Member Crow.
Present.
Board Member Curtis.
Present.
Board Member Stern.
Present. Okay, thank you. Next, I'll ask everyone to please stand. We'll salute the flag. After the flag salute, if you would please remain standing if you intend to provide testimony today and be sworn in. Okay, ready? Begin.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Great, and please do remain standing if you intend to provide any testimony today.
Thank you. I'll now place all of you under oath. Please raise your right arm. When I complete stating your oath, please say I do. You and each of you do solemnly affirm that the testimony you're about to give in the matters now pending before this board will be the truth, the whole truth, and nothing but the truth. Thank you. You may now be seated.
Okay, great. We have a long agenda today, and so I'll thank everyone in advance for your patience. And we'll start by going through agenda review, which allows our clerk, Mr. Vlahakis, to put several items in one motion so that we can be expedient with our time.
Yes, the agenda review for October 8th, the clerk of the board requests approval of the agenda review by the Assessment Appeals Board. The agenda review consists of the following agenda items. Item numbers 24 through 28, 29, 31 through 36, and 45 through 52. Application numbers 16-11177 through 16-11181, 16-11576, 17-10974 through 17-10979, and 17-11373 through 17-11380. The applicant is ROIC California LLC. We're going to remove those from the agenda due to submission of a withdrawal. Next is item number 81. Application number 17-10414. Applicant is Norman and Elva Brower Trust. We're going to continue that to December 3rd, 2018, pending receipt of original stipulation. Item number 90. Application number 17-10904. Applicant Mohammed Aldebeki, denied due to lack of appearance. Item number 91 through 98. Application number 17-10923 through 17-10930. Applicant CIT Bank N.A. Continue to December 3rd, 2018, pending receipt of an original stipulation. Item number 99. Application number 17/10956. Applicant Golden State Enterprises LLC. Removed from the agenda due to submission of a withdrawal. Item number 100, application number 17-10963. Applicant Hanako F. Utsuki Trust, Paul J. Ryder, successor trustee, continue to December 3rd, 2018, pending receipt of an original stipulation. Item number 101, application number 17-10981. Applicant Simi Valley, California Senior Living Owner, LLC, removed from the agenda due to the submission of a withdrawal. Item number 103, application number 17-11032, applicant Winco Foods, LLC, continue to December 3rd, 2018, pending receipt of original stipulation. Item numbers 116 through 120, application number 17-11140 through 17/11144, applicant Raintree Ventura Colony, LLC, removed from the agenda due to submission of a withdrawal. That completes the agenda review. I recommend approval as read.
Okay. Thanks, Mr. Vlahakis. Are there any questions or comments from the board?
I have none.
Okay, so I will look for a motion to approve.
So moved. I'll second that motion.
By Mr. Curtis and seconded by Mr. Crow. And the motion carries. We'll go next to public comments. This is a time for anyone to make a comment on an item not on our agenda today. So this would be a time to come forward. Okay, don't see anyone coming for public comments and also board comments. Okay. Moving right along, we'll now go through the remaining items on the agenda. We'll determine the status of each and then come back and conduct hearings for any applications that are moving forward. So we'll start with items 8 through 15, applications 16, 11086 through 93. Applicant is Target Corporation.
If you'd please come forward. And
Come on forward to the podium.
Mr. Stir, I note for the record, handling in this action, we'll also be discussing 16 through 23, also for Target Corporation. They are all related.
Okay, great. Good morning.
Good morning.
Could you please state your name for the record?
My name is Christine Boyce-Claire.
Okay, and are you ready to move forward today with your application?
We are actually requesting a postponement.
Okay.
Not sure how many months ahead we do that, but we would look for maybe 3 to 4 months.
Okay, thank you. Do we have any comments from the assessor? Good morning.
Good morning, board members, council. Christopher Horn for the assessor's office. The assessor doesn't object to the applicant being granted a continuance. From what I understand, they want to provide more data to us. I believe one of the items is an appraisal, which they have to commission, and I don't know how long it's going to take for that to happen. Also, there's outstanding data at the moment. We've requested invoices, which I believe are still outstanding, along with other items that are reflected on our 441D letters, and we can get a copy. We can get copies to you with regards to those and highlight the specific items that can be passed on to us along with the future appraisal.
That would be ideal.
Okay, thanks, Mr. Horn. And Mr. Vlahakis, are there any suggested dates?
This does include 2016 applications, some of the oldest we still have on file. Therefore, we'd prefer not to go too far out, but because of the massive amount of cases and the pending appraisal, I would possibly suggest March 4th, 2019. If the parties aren't going to delay too much further from there, does everyone? I guess it depends if everyone thinks they can be ready by March 4th, including the discussed appraisal.
Okay, well, I'll go to the applicant first. It's March 4th.
I believe that would be perfectly acceptable to us.
Okay.
The assessor has no problem with March 4th. One of the concerns that we have with regards to something that is sort of hanging out there in purgatory at the moment, said appraisal typically from this agent has a tendency to come in around, I don't know, 5,000 to 6,000 pages.
That is correct.
So getting something to us a week before, 2 weeks before is not feasible. We would like at least a 45, if not 60-day minimum requirement that any appraisal be received, I guess, shortly after the first of the year. Is that feasible?
I would assume so. We can also send it to you via, we don't need to send it in paper. We can send it via file transfer. If that would be acceptable, we can send that as soon as we receive it.
That's fine. It's not the format. It's more the volume and the time it takes to review said document.
I would think after the first of the year would be fine.
Okay, and so, Mr. Horn, 45 or 60 days?
Let's go 60 just to be safe. So that would put it at, we'll say January 4th. The document needs to be received with a March 4th continuation date.
Okay, and it sounds like that is acceptable to the
That is
applicant?
acceptable to
Okay.
us.
Are there any questions or comments from the board? Okay, so I believe we're looking for a motion to continue this to March 4th with a provision that the applicant's information be submitted to the assessor by January 4th.
So moved. Second.
Okay, moved by Mr. Crow, seconded by Mr. Curtis, and motion carries. So-
Thank you so much.
Okay, thank you. I believe we have items 53 through 76, is that right?
There are some in between there, but I was going to suggest we skip
Oh, 34 through 40.
that agent has a flat tire and he'll be here in about an hour. So if we could jump to 53 through
Okay.
76 and trail everything before that till later.
Okay, so we'll trail items 37 through 44, I believe. Okay, so 53 through 76, applications 17-11075 through 84, and 17-11086, 17-11088 through 1100. Applicant is Ralph's Grocery Company.
First, Mr. Chair, I'll note for the record, we did get a withdrawal on some of these, and so because they're a little patchwork, I decided to read them in at this time. Application numbers 17-11075, 17/11077, 17/11090, 17/11091, and 17/11092 for Ralph's Grocery Co. have been withdrawn. I would need a motion to accept the withdrawal at this time.
Okay. Do we need to take action on a withdrawal?
Previous council would advise me that you do. I
Okay.
don't know about our new council. I would recommend, just to keep it clean, a motion
Okay.
to accept the withdrawal at this time.
Are there any questions from the board?
I have none.
Okay, so then we'll look for a motion to approve the withdrawal of applications ending in 7577, 90, 91, and 92.
So moved. I will second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow, and motion carries.
Right. And
Okay.
so now we have the remainder to discuss.
Great, good morning.
Good morning.
Could you please state your name for the record?
John Boyle, Nucleus Tax Group,
Okay.
agent for the applicant.
And Mr. Boyle, are you prepared to move forward today?
We are actually requesting to a postponement of the applications that remain on calendar for Ralph's. We've been in communication with the assessor's office and had some discussions on these. If the board is agreeable, we'd like a short continuance on these to allow us time to discuss the matters and hopefully come to a resolution on these remaining matters.
Okay. And any comments from the assessor?
The assessor has no qualms about agreeing to a continuance on these.
Okay.
Pardon the interruption, sorry. On a related matter, we did have one request on one of the applications to make an amendment, to application 17-11076. I'm not sure if you'd want to handle that particular issue prior to addressing a postponement or not. And,
Okay, why don't we address that issue first, and then the continuance, possible continuance after that. Before we get to that, are there any questions so far or comments from the board related to the continuance, proposed continuance? Okay. So,
The suggested date on the continuance would be January 14th, 2019.
okay. That date acceptable
That's
to the
absolutely
applicant?
acceptable,
And for the assessor?
January 14th works.
Great. Okay, so before we get to that, there was an application ending in 7/6, is that right?
That is correct.
And I'm gathering the file on that as we
Okay.
speak.
No rush.
The sorry. And while I am bringing this up, I was just made aware of this morning before the hearing started, and so I don't have a copy of the application, but I'm trying to bring it up on the screens for everybody to see. So we're and I'll see it. If I understand, Mr. Boyle, you're wishing the application to apply to a different parcel number. Is that correct?
Well, we're actually asking to amend the application. The subject property, our client is Ralph's. They lease a grocery store space inside of a retail center. It's an economic unit. The center is always sold as an economic unit. It's always been transferred as an economic unit. Shared parking, et cetera, typical of a retail center. We filed on parcel number 18900100540. And we would also like to include the adjacent parcel 590, again, part of the same center, part of the shared parking, that includes the improvements of the Ralphs. So it's an economic unit issue. And the other applications that we've requested a postponement on have a similar issue. Not all retail centers have separate parcels for each tenant. Some have one parcel for 50 tenants, and you have to do an allocation. So it's the same valuation theory. In this case, we filed on parcel ending 540, when in fact we probably should have filed on every parcel within the center. This is the first year we've taken these applications over from a prior agent. We had, as I think the clerk would note, some issues where we'd filed on all parcels in a center. Another applicant representing the landlord filed on all the same parcels. We had a duplication issue, and certain applications were withdrawn. But it's an economic unit issue, and we didn't file on, in this case, another parcel 5 ending 590, that would be part of this economic unit for our client.
Okay, thank you. Mr. Vlahakis, do you need a minute to?
I might not be able to get a copy of it up. I'm having technical difficulties. As he described it, though, is what I'm seeing. The application on file is for the parcel ending in 540. And it's for 637 West Channel Islands Boulevard. Under normal, one of the minimum requirements of a valid application is that you specify the parcel number and property address that it applies to. And therefore, amending it to be for a different parcel number would generally not be allowable in our opinion, in the clerk's opinion. So my recommendation would be to not allow this request. We may need to, I don't know if council needs time to evaluate that position or not. But
Okay. Just for clarification, Mr. Boyle, is it an additional parcel number, not switching from one
Correct.
to
We're not
another?
trying to switch. We're trying to add an additional parcel, which is part of the economic unit that is the
Understand.
same retail center that has always been an economic unit. We're not trying to switch.
Understood.
to clarify, they are at separate mailing addresses, correct?
Yes, within any retail center, there are separate mailing addresses regardless of if there's one parcel or 20. If you've got a retail center with one parcel where you'll have a Target, a Ralph's, a Vons, and 20 inlines, they're all going to have separate addresses regardless
Right.
of whether or not there's a separate parcel. The address and parcel are different matters entirely.
Any comments from the assessor?
Mr. Boyle, the parcels that you're attempting to add, they're not owned by Ralph's, they're owned by another agency or another individual or corporation or whatever?
Sure. When it comes to ownership, just as a point of clarification, Ralph's does not typically own their stores. They're subject to leases, so they don't own the real property. So in a similar application that we had on the agenda, there was an issue where we had in fact, different agents filing applications on the same retail center for the same date. And there was an issue where the other agent had not withdrawn applications, so the clerk was going to have us argue the cases on the same day because of the economic unit issue, specifically because it had to be addressed as an economic unit. We are taking the same point. But hopefully, does that answer your question?
It does to some extent. Does Ralph's have a vested interest in, do they pay taxes for the other unit?
Yes, in their leases, they typically pay a pro rata share of CAM charges, which include the parking and other maintenance for the overall center. So they pay as a percentage of the center, not just on their parcel. And that's typical in a major lease. Because, again, it's part of the economic unit, right? When you have a parking lot, and I wish I could show you, I have an aerial of the center, but you've got retail, and then you've got parking in the middle, and they're different parcels. So there's not partitioned parking for Ralph's and for, the Ross or whatever the thing is. So they pay their pro rata share of the CAMs for the entire center, not just on their parcel.
Do you have authorization today for that other client?
The authorization on file covers Ralph's.
And
As lessee, they would be an eligible applicant as an act affected party, but I'm saying we're still not eligible to,
I'm sorry.
an additional application definitely would not be permitted as it's outside the deadline to appeal.
right, and we're not asking to file an additional application. We're asking to amend to include.
So, and an application may not include more than one parcel number. So we wouldn't be able to include a second parcel number on this application.
I do believe the Urban Taxation Code, and I can cite the section if need be, allows for an applicant to amend an application.
But you're asking for it to be for a different parcel number.
We're asking to add an
Right.
additional parcel number to.
Right, which is also not allowed. You can only have one property per application.
One parcel?
One parcel number.
One parcel, one property per application.
Even under the same economic unit, if there's
Right,
one
and
parcel?
it says if the entire economic unit was not appealed, the board still has to consider the value for the entire economic unit at the hearing, but cannot make a reduction on the unappealed parcel. So while the board would still be hearing evidence of that parcel as part of the hearing as required, because an application was not filed, the board would not be able to reduce that specific parcel even if the presentation of the economic unit valuation warranted a reduction on that parcel.
And to be clear, we are not requesting that any improvement value be adjusted for any tenant other than
Understood.
Ralph's we represent.
Okay, so Mr. Vlahakis, you're saying only one parcel number per application, right?
Correct.
And that
add
you
one.
can't, the time to file a new application has passed, right?
That's correct. This is a 2017 year. This was filed September 15th, 2017.
Got it.
So we're over a year past this filing period.
Okay. Any questions, comments from the board on this? Okay. Based on that statement, any comments from the assessor?
The
In terms of
only,
multiple parcel numbers on one application?
the clerk of the board seems to have a firm handle on this, and I'm going to defer to his judgment because this is an application administrative issue, and that's his call.
Okay.
Is there a point of inquiry?
Yes.
Has Mr. Vlahakis, I apologize for pronunciation.
That's fine.
Has your office in the past, you have not approved or allowed, I should say the board would approve, but in your experience in the past, have applications been amended to address issues of this nature that have allowed additional parcels to be included in an application post?
We've never had more than one parcel in an application unless they have the exact same street address. An example of that would be a house that's on two lots. But as far as adding additional parcels, we've had requests and the board has never approved such a request. The only time the parcel has been permitted to be changed is when the parcel did not match the address written on the application and it was clear that it was a typo. In this situation, it's, as you're stating, it's not necessarily a typo. You just want to appeal the additional property.
Parcel.
Okay. So based on that information, to the board, my understanding is that we don't have the authority to approve the amendment to include multiple parcel numbers on the same application, and so that would have to be denied. Is there any comments to the
believe-
contrary?
Pardon the interruption.
Go ahead.
Just to make sure, and I want you to make whatever call that your board thinks is appropriate, but it is within your power to allow this change. Unless, again, Mr. Hawkins, would you like anything to the contrary? But I believe it is within the board's power to make that, approve that request, should they deem it appropriate. Is that fair to say?
I would disagree. At this time, we didn't have enough notice to do a full analysis and provide legal citations, so the standard answer for this type of situation is that the board could not amend. because I have not had the pleasure to prepare more than the 15 minutes this morning. So
No,
if it's in question, I'd recommend we continue the hearing to allow time for fully vetted research if there's any doubt
Okay.
on this. But
And we're agreeable to that, too. If more time's needed, or you'd
Understood.
like more information from the taxpayer, we're happy to provide it.
So before we continue, Ms. Gardner, do you have any comments now at this time on the question?
Not at this time. I think I understand the question.
Okay, so why don't we then wait for more information to the board before we take action on that request to amend that application, and then take action on the request to continue all of the others with, well, I guess including this one, number 76, and then with that issue out there yet to be resolved?
Perfect.
Mr. Vlahakis, is that something you can help us with in terms of making sure that we have that as a trailing issue?
you would like to resolve the amendment question later today? Is that what you mean by trail?
Not necessarily today, whenever we get the information. So what I mean is that we would move forward with the continuance to January 14th.
Yes.
And then we would request that Ms. Gardner give us information for a future, whenever, that's available, for us to make the decision on whether item 76 can be amended before that date,
Okay.
That's what I'm going to ask.
unless the
No, I think we're agreeable to
wants
that.
to.
Yeah, I'm just trying to, anytime there's an amendment, there could be a mandatory 45-day extension of the of the hearing. And so, let's see, 12/3. The soonest we could get this back before your board is December 3rd, which would mean, unless parties waive their rights, we couldn't hold the subsequent hearing until January 17th, which would make so maybe if we push the other hearing out a little further to March instead of January, then that'll allow us to come back with a 45-day buffer on the amendment. Unless either that, or we can address the amendment on December 3rd and keep the full hearing on January 14th, as long as all the parties agree to waive their 45-day continuance period after the amendment. I don't know if the parties are prepared for that at this time.
My guess is that we could get the answer back before that deadline, which might allow for the 14th date to be valid. Does that sound?
My concern would be your board's ability to approve that. I don't have you back to approve this until December 3rd, which is, if you approve the request on December 3rd and they don't waive the 45 days, then we can't hear the hearing until after January 17th.
That's something we could approve via email? Or do we have to be in
I would refer that to council. I don't believe so, but
Okay, how about the March date in terms of a continuance?
It's fine. And if the waiver is an issue, we're not concerned about that.
The assessor believes that the March date would be better because this allows the board and council greater flexibility. So if a validity hearing needs to happen, it can be set for the 14th. Does that work for clerk of the board?
March 4th, I think, was the date?
So if we continue to March 4th, 2019, that'll allow us to take care of all the housekeeping items in between there.
Okay, and so are there any other questions from the board, comments? So we're looking at a continuance to March 4th. Sounds like that's okay with the assessor and the applicant?
And just to clarify, we're talking about a March 4th date for all applications?
Correct.
For postponement? Great. Just to clarify. Thank you.
And then with the note that we will hear back in terms of information on whether the board has the authority to approve the request for the amendment. Okay, so looking for a motion, hopefully to that effect.
So moved. I will second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow, and motion carries. So sounds like we're all on the same page at least. Okay,
One more vote, please.
thank you.
And this agent has one more application since he's already up here. It's on your last page.
137.
Yes, 137.
I'm sorry, which
Oh,
item?
so I was recommending we jump to his other item since he's already up here,
Which-
137.
Oh, 137, thank you. Okay, so application 17-11412, applicant is Donahue Schreiber Realty Group, LP. Okay, Mr. Boyle, are you prepared to move forward with this one?
In this application as well, we are requesting a reset to a future date. We've exchanged information with the appraiser, Mr. Skora. This is a business personal property matter that I believe will be fairly simple to resolve outside of a hearing. So I think a little bit more time will allow for that, and we're open to the assessor's request on a date for that.
Okay,
We provided additional information, sorry to interrupt. We provided some additional information to the appraiser on this matter that should be very helpful in understanding the matter at hand.
okay. Do you have a preference between the January or March dates?
We can go with the same March date if that works for all parties.
I was going to say, let's just go with the March date. It just makes
Okay.
things more streamlined.
Absolutely.
Any questions, comments from the board? Okay, so we'll look for a motion to continue item 137 to March 14th. Is that right?
Fourth.
4th.
Or, yes.
So moved. I'll second that motion.
Moved by Mr. Curtis, seconded by Mr. Crow, and motion carries. Great, thank you.
Thank you, Mr. Rockets. Thank you, Mr. Hall. Present.
And I think we have items 78 through 80 next, is that right?
77.
Oh, you're right, 77. Okay, application 16-11575, applicant Kirpal and Sukhbir Dhaliwal.
Yes, sir.
Morning.
Morning.
Could you please state your name for the record?
Kirpal Singh Dhaliwal.
Okay, and Mr. Dhaliwal, are you prepared to move forward today?
Yes, sir.
Okay. Any comments from the assessor?
The assessor is also ready to move forward. This is a change in ownership issue, and I'm estimating 30 to 45 minutes for the assessor's presentation.
Okay, thanks. And Mr. Dhaliwal, do you have an estimate about how long your presentation might take?
That should be fine, but basically it's on the ownership issue, it's four brothers. Previously, they were on the title, they were joint tenants, and we changed it to, I have a document, quitclaim deed, that
Okay.
it should be changed to tenants in common.
Okay,
And that's the document that was presented to the assessor's office.
okay. So what we'll do then is come back, we'll go through the rest of the items on the agenda to determine the status of each, and then we'll come back and hopefully hear yours first.
Okay.
Chair Stern, the assessor would like to make an additional comment. Today, we're doing a change in ownership issue. There will be a valuation hearing that will be set later on
Okay,
at the conclusion of this.
okay. Okay, so we'll,
And also for the record, the applicant has requested and paid for findings of fact.
great.
But basically, the ownership is same. The only thing was that, for the technical reasons, it was changed from joint tenants to tenants in common.
Okay,
And,
thank you. We'll review all the information and get to that shortly.
All right.
Okay, so you can just stay here, and we'll come back to you hopefully soon.
Okay.
Thank you. Okay, now I believe items 78 through 80.
That is correct.
Applications 17-10065 through 67. Applicant is CHPCE Thousand Oaks LLC. Morning.
Morning.
Could you state your name for the record, please?
Robert Slavin, agent for the applicant.
Okay, welcome back, Mr. Slavin.
Thank you.
Are you prepared to move forward today?
No, we are requesting a postponement continuance. We met recently with the assessor at the site. Assessor has some more questions, and we need to get some additional information for the assessor.
Okay. And in terms of a proposed continuance date, it sounds like we have a March and a January available, or do either sound better than the other?
Probably March.
Okay. And any comments from the assessor?
The assessor has no problem with the March date. We would like the data that we requested. Can we get that in 30 days, do you believe? Okay.
Give it to you today.
You have it?
No, I'd say I'd give it to you
you
today.
did.
It's a matter,
Okay.
company's located on the East Coast.
Oh, are they?
It's a matter of getting their archive records.
Okay.
So that's
How long, can you get the data to us by, within 60 days?
I will certainly tell the taxpayer.
That there's a proviso that we're requesting data. Okay, let's say a minimum of 60 days prior to the March 4th hearing. So let's say data by January 4th. How's that?
That's reasonable.
Okay. Any comments from the board?
You want that included in part as the motion?
Please.
Okay, so we'll look for a continuance of items 78 through 80 to March 4th with a condition of information from the applicant being submitted not later than January 4th. And Mr. Crow, you would move? Moved by Mr. Crow.
Second.
Okay, moved by Mr. Crow, seconded by Mr. Curtis, and motion carries.
And if you don't mind jumping, we have another 2 applications for this agent.
Okay.
134 on the last page, second to last page.
Okay, item 134, application 17-11406. Applicant is Nicholson Carmelita Trust. And prepared to move forward today with this one?
No, Mr. Chairman. We'd like to request another continuance on this case. Ownership is 4 sisters, and we're trying to get a little direction. I think we have an agreement with the assessor as to what needs to be done.
Okay.
Better to have 3 or 4 on the same side as opposed to 2 and 2.
Okay. And January or March?
Probably March.
Okay. Any comments from the assessor?
The assessor has no problem with March 4th. It is for this application and the subsequent 2, they are changing ownership issues. The agent knows where we stand. I believe we have the information that we need should this have to go forward. If they want to provide any additional information not already provided, then let's have a proviso of January 4th.
No, that's reasonable.
Okay.
Okay, any questions from the board? Okay, we'll look for a motion to continue item 134 to March 4th with a condition that any requested info of the applicant be submitted by January 4th.
So moved. I will second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow, and motion carries. And was there one other?
Yes, the next item, 135 and 136.
Okay, items 135 and 136, applications 17-11407 and 08, applicant Rancho Avida LLC.
Yeah, same issue, same parties.
Okay.
This is their LLC, and the March agenda would be appropriate.
Okay,
March agenda works for the assessor as well. Same proviso, any new data regarding the change of ownership by January 4th.
Great.
any comments from the board? Okay, we'll look for a motion to continue to March 4th with the same condition that information be submitted by the applicant by January 4th.
So moved. I will second that motion.
Moved by Mr. Curtis, seconded by Mr. Crow, and motion carries.
Thank you.
Okay, thank you.
82 is where we're bounced
Okay.
back to now.
Great. Okay, item 82, application 17-10596. Applicant is Marin Corporate Center LLC. Morning.
Good morning.
Could you please state your name for the record?
Kenton Schubel, Ryan LLC for the applicant.
Let me swear this witness in real quick.
Okay.
You solemnly affirm that the testimony you're about to give in the matters now pending before this board will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
It's Mr. Schubel, is that correct?
That's correct.
Okay, welcome back.
Thank you.
Are you prepared to move forward today?
Yes, I am.
Okay. And any comments from the assessor?
The assessor is also ready to move forward. We estimate 30 to 45 minutes for our presentation.
Okay. And Mr. Schubel, any estimate of time for your presentation?
15 to 20 minutes.
Okay. Great. So we'll come back to you shortly.
Thank you.
Real quick, is either party requesting findings of fact?
Applicant is not.
The assessor is not.
Okay.
Okay. And Mr. Chairman, Mr. Schubel's cases are the ones we skipped over on page 1 because he was running late.
Flat tire?
No, it turns out that the change in the weather causes the monitors reading the pressure to tell you that you're.
Well, we're glad you're here.
Thank you.
So if we could take care of his other stuff real quick, that's jumping up to item 30.
37 through 44?
Yeah, 30 and 37 through 44 are Mr. Schubel's.
Okay. Was number 30 on the agenda review for withdrawal?
It should not have been. No, right around it was withdrawn. We had a lot of piecemeal witdraws all over. Those
Okay.
were from a different tax agent, not from Mr. Schubel.
Okay, so then for items 30 and 37 through 44, is that correct?
Correct.
Applications 17-10864 and 17-11358 through 65. Applicant for both is ROIC California LLC. Mr. Schubel, are you prepared to move forward with those today?
No, not with this one.
Okay.
I can explain. What we have here is it's a base year case, even though it goes back to 09, but it's because it was worked untimely by the assessor, and then each of the years behind it, protective Prop 8. The case was prepared by someone else in my office who's no longer with us, but it was given to the assessor who has reviewed it. And I believe the base year case has been postponed from today's agenda by the assessor, but I am speaking with our appraiser, and we likely could get a resolution of this going forward.
So looking for a continuance?
Yes.
Okay. Any comments from the assessor?
The assessor has no objection to a continuance.
Okay.
Our recommended date would be January 14th.
Okay. So Mr. Schubel, January 14th?
That's
Okay.
fine.
Okay. And for the assessor?
The assessor agrees to January 14th. If there's okay. There has been some information that's been provided to the assessor. I believe the assigned appraiser has a 441D letter requesting more information. We would like that within 30 days from today.
Not a problem. We'll provide.
Okay. Any questions from the board? Okay, we'll look for a motion to continue to January 14th with the condition that any additional application or applicant's information be submitted within 30 days of today.
So moved. Second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow.
Thank you.
I tried to push my button, but I don't know if it worked.
It's technical difficulties. It's okay. I've corrected it.
I'm a yes.
Mark, for the record, board member Stern voted yes.
Okay, great. And motion carries. So let's see.
Jumping around again. We're back at 83 and 84, and I think that's the last of the jumping around.
We'll see. Okay, items 83 and 84, looks like same applicant. Applications 17-10667 and 17-11484. Applicant is VMD Aviation LLC.
Mr. Flannery, if you want to come forward.
Good morning.
Good morning. Could you state your name for the record, please?
Michael Flannery.
Okay, good morning, Mr. Flannery. Are you prepared to move forward today?
I believe I am. I just had one question.
Okay.
I went into the assessor's office last Monday, and I think verbally they had come up with an assessment but I wanted to get a copy of what their recommendation was, and I was told they were too busy preparing for this hearing to see me. And so I called the office and asked them to send me a copy of it so I could determine what the taxes are they want from me, and I didn't get a response.
Okay.
So if I understand what they're asking me to pay, I'm ready to go forward.
Okay. Any comments from the assessor? Sounds like, is there a pending stipulation maybe?
No, Mr. Flannery did show up last week. I informed him that we were in the middle of case prep. The request that he may have made for our position, our values, was not made to me. So I don't know if that request fell through the cracks, and if it did, it's unfortunate. We're prepared to move forward. If he would like to talk to Mr. Azcora, Mr. Azcora can inform him of our position and the values that we're recommending. And if I need clarification, if you agree with the values that Mr. Azcora is recommending, does that mean you would be willing to stipulate, or are you want to know in advance prior to moving forward?
Well, before the hearing, I believe it was in June, I met with your representative from your office, and he explained to me he was going to make an adjustment, and then he called me and told me the adjustment, but I never saw anything in writing, and that was last June, and I don't remember the exact number.
Okay.
If I took 2 minutes to show me what that number is, I'd be more than happy to go forward.
How's this? How about we trail these two items, let the representative from the assessor's office talk to Mr. Flannery, and then we can come back and decide whether or not these are moving forward.
How's that sound?
How long will that take?
Mr. Azcora is right there. As soon as you leave the podium, you two can start talking.
I just need to see a number. So,
Okay, why don't we trail the item and let you two talk, and we'll come back to it shortly.
okay. Thank you very much.
Okay. Any questions from the board on that?
No.
Before we? Okay, so we'll come back to items 83 and 84. So next, item 85, application 17-10682. Applicant is Thomas Harkins.
And we did get an authorization of agent today authorizing Michael Stanley, who I believe is here, to request a continuance on behalf of this taxpayer. So while it's not noted, we did receive a authorization this morning.
Okay. Good morning.
Good morning, sir.
Could you please state your name for the record?
Yeah, Michael Stanley, representing Mr. Thomas Hawkins.
Okay, thanks, Mr. Stanley. And it sounds like there's a continuance that's...
Yes, requesting a continuance, sir.
Okay. Any comments from the assessor?
The assessor has no objection to another continuance. Mr. Harkins was here last in June. We asked for information. None has been provided to date. And what was it? It was last Friday. I spoke with the applicant, and he said he was in the process of putting everything together. So I think we're finally at that point where data might actually get to the assessor's office. If continuance date of January, March, whatever the clerk recommends is fine. We just would like the data within 30 days.
Yes, sir.
I believe this applicant called me this morning, and I don't know if I got all the details right because I was so busy, but I believe he said Mr. Harkins is not available in January. Is that correct?
Right, that's correct.
So I mentioned possibility of the December 3rd hearing. And
Yes, he said
for
December
that, I told him I was not sure if the assessor would agree to that. He also indicated he's available for March 4th. Is that
Yes.
correct? So preferred date would be December 3rd, but also available March 4th, depending on the assessor's input on that.
Okay, so Mr. Stanley, December 3rd is acceptable?
Yes, sir.
Okay, and to the assessor?
The assessor is open to December 3rd, but again, really wants to emphasize that Mr. Harkins needs to provide data because we're closing or tightening the window. It would be in his best interest to get this information to us sooner than later for review.
Mr. Horn, that you'd request to have the information by?
30 days.
Okay. And Mr. Stanley, can the applicant?
Yes, he should have them.
Okay. Great. Any questions from the board? Okay, so we'll look for a motion to continue item 85 to December 3rd with a condition that requested information of the applicant be submitted within 30 days of today.
So move.
I'll second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow, and motion carries. Thank you.
Thank you, sir.
Okay.
Okay.
I think we have item 86 next. Okay, application 17-10727. Applicant is Etzinger Aviation LLC. Morning.
Good morning.
Could you please state your name for the record?
Stephen Maloney.
Okay. And Mr. Maloney, are you prepared to move forward today?
I am.
Okay, thank you. Any comments from the assessor?
The assessor is also ready to move forward. We estimate 30, 45 minutes.
Okay. Any guess on the time of your presentation, Mr. Maloney?
15 minutes.
Okay.
And before we move on, the applicant indicated he is not requesting findings of fact, and the assessor, you're not requesting findings of fact either, is that correct?
That is correct.
Okay, so we'll come back to you as soon as we can.
Thank you.
Okay, thanks.
Just a second, you're the next item. But I might not need you to speak, but we'll. 487, I believe a stipulation has been submitted and routed to the board. So if there's no questions on that, the recommended action would be to approve.
Okay, so item 87, application 17-10729, Doheny Leasing, Inc. This is one of the two stipulations that we reviewed before the hearing. So unless there are any questions, we'll ask for a motion to approve.
So moved.
I'll second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow, and motion carries. That was for 87. Great, thank you.
The next two items are running late because of car trouble, so let's trail 88 and 89. 102 is next. And 102 is the other stipulation that you were routed this morning. And so the recommended action would be to approve.
It's not on the agenda, so I'll just read from the stipulation. It goes from 99 to 109, which is fine.
Wait. Sorry, I'm on page 4, the second item.
Oh, I guess it doesn't go on. It goes 99.
Done a typo.
Looks like we have two 109s, but no.
Well, sorry, I have 102.
Yeah.
I'm a little.
There's just one item that's out of order. It goes from 99, 109, and then back to 101. But that's fine.
It's on the red copy.
Okay, sorry about that. That might have been an issue. So we're on second item on page 4.
Page 4. Got it. Application 17-11024, and this again is a stipulation that we reviewed, the other of the two that we reviewed just before the hearing. Applicant LGP Hillcrest JVT LLC. Any questions, comments? Okay, so we'll look for a motion to to approve this stipulation?
So moved.
Second.
Okay, moved by Mr. Curtis, seconded by Mr. Crow, and motion carries.
There we go.
We have 104 next. Okay. Item 104, application 17-11034. Applicant is MSWP The Palms LLC. Morning.
Good morning.
Could you please state your name for the record?
Keith Jameson, agent for the applicant.
Okay. Welcome, Mr. Jameson.
Thank you.
Are you prepared to move forward today?
Not today. Came to request a reschedule. We have a site tour with the assessor on Wednesday and feel like we can resolve issues fairly shortly with the assessor.
Mr. Horn?
We have no issues with the continuance being granted. Do you prefer January 14th? I think January 14th will be more than enough time. That's
fine.
With the application, it's an exemption issue, which the board doesn't have jurisdiction to hear. We have the site check set up. I understand the applicant's or the agent's position to continue and keep the application open. We're hoping that the tour of the facility will end up clarifying our position and or remedying any allocation issues that seem to be the issue.
It's a square footage issue right now, so we'll be able to figure that out on Wednesday.
Great. So January 14th, okay with both parties? Okay.
Yes. Yeah, the 14th.
Any questions from the board?
Mr. Horn, do you have all the information you will need?
Because of the situation, this is more of a visual, Mr. Crow. We have to, there's a question about occupied square footage and what percentage would end up being exempt. So that's why we're going out in the field.
Okay, we'll look for a motion to continue to January 14th.
So moved.
I will second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow, and motion carries.
Thank you.
Thank you. Next up, I think we have item 105, and that is application 17-11040. Applicant is Site Server, Inc.
I guess wrong.
Hi.
Morning.
Good morning. How are you?
Great, how are you?
Excellent.
Good. Could you state your name, please?
Sure. Mark McDonald.
Okay, welcome, Mr. McDonald. Are you prepared to move forward today?
Yeah, I am.
Okay. Any comments from the assessor?
The assessor is prepared to move forward. We, as 105 and 106 are the same applicant. We estimate 30 to 45 minutes for the first one and probably 30 minutes for the second.
Okay, Mr. McDonald, any guess on time for your presentation?
If I could add a comment on that, if there's a way, is Mr. Afrain or Mr. Acorza Afrain here or no?
Mr. Acorza is here.
Okay. Is there a way we could trail this? I could talk to him. We'd submitted in different documentation back in August 25th of 2017, again August 30th of 2017, and then as recent as September 28th. That I didn't get any response to. I'd like to just talk to them and see if what else they're looking for. This, I think, in my opinion, should be very, very simple.
Okay.
And then the next one, 106, that one may need to be postponed. I got some information to them. It's information I had sent previously, but close to 4 months ago, but they couldn't accept a Dropbox link.
Okay.
And so I sent that again last week, but I don't know if they've had time to review that. Have you had sufficient time?
I haven't seen it. I think if we trail both of these
That'd be
items,
great.
Mr. Azcora will be able to talk to you about site server.
Okay.
And then Ms. DePoyen is somewhere around here.
Okay.
And she'll be able to talk to you about the Dropbox information.
Okay, that'd be great.
Okay, before we do that, any questions, comments from the board? Okay, so then we will trail items 105 and 106, allow you to have a conversation with the assessor's representative and come back to you.
Great, thank you.
Okay. Next up is 107, application 17-11043. Applicant is Armand Legaspi.
Good morning.
Good morning.
Arnold Legaspi for Armand Legaspi.
Okay, and Mr. Legaspi, you prepared to move forward today?
No, I'm requesting a postponement. A site visit was just made last week. I'd like to review the findings.
Okay, thank you. And any comments from the assessor?
The assessor has no objection to a continuance. The assigned appraiser, Mr. Denham, is in the audience and is happy to discuss his position with the applicant. And do you want January 14th or?
Fine.
Okay.
And is that with the assessor, January 14th?
Yes.
Acceptable? Okay.
Yes.
And Mr. Vlahakis, I assume that's still okay? Any questions from the board?
No.
Okay, so we'll look for a continuance of, a motion to continue for item 107 to January 14th.
So moved.
I will second that motion.
Okay, moved by Mr. Curtis and seconded by Mr. Crow. Was there a second item that we were just talking about, or no? Just 107?
Correct, just
Okay.
107.
Okay, great.
Thank you.
Thank you.
One more, oh, there we go. All right. You're good?
Yes, thank you. Next up, items 108 through 113. Applications 17-11062 through 17-11067. Applicant is F. Oliveira Ranch Company. Morning.
Morning. Stephen Davis, attorney for the applicant.
Morning, Mr. Davis. Are you prepared to move forward today?
Not today. We have previously requested a postponement. I was just engaged last week. I have reached out to Ms. Rovtar. It seems that both parties need information from the other. I have engaged an appraiser, so we're moving on it right away, but today we cannot proceed.
And do you have a preference between a January or March date?
I think the March date will work best. Thank you.
Mr. Horn?
The assessor agrees with the March date as well. Mr. Davis and I had a conversation pre-hearing. We both understand that there are questions about one about the data and also whether or not there is any issue at all. We're hoping that the March date will allow for both sides to be able to not only exchange information but also clarify their position.
Okay. Any questions from the board? Okay, so we'll look for a continuance to March 4th for items 108 through 113.
So moved.
I'll second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow, and motion carries.
All right. Thank you very much.
Okay, thank you.
114 and 115 is a second tax agent with car trouble. He's still not here yet, so I'd recommend we jump to 121 through 132.
Okay. So 114, 115, we will come back to. And 121 through 132 applications, 17-11278 through 83 and 17-11320 through 25. Applicant Arnold Ranch LLC and CRC Oxnard LLC.
And I'm Gary Arnold, the manager for both LLCs.
Morning, Mr. Arnold. How are you?
Fine, thank you.
Great.
And this is a large reduction stipulation agreement that was emailed to your board last Thursday. Reductions over $5 million are placed on your board's agenda for any questions that might come up. So if you've had a chance to examine this, you can approve or whatever the board desires at this time.
And this was one of the stipulations that was emailed to us ahead of time?
That's correct. It was it's a standalone PDF as part of the distribution email last week.
Great. Any questions from the board?
I have none.
Nope.
Okay, we'll look for a motion to approve the stipulation.
So moved.
I will second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow, and motion carries.
Okay, thank you.
Thank you.
Appreciate it.
Next is item 133. Application 17-11394. Applicant is G&M Gapco LLC.
Morning.
Morning. Could you state your name, please, for the record?
Jeff Kamens, agent for the applicant.
Morning, Mr. Kamens. Are you prepared to move forward today?
No, we've engaged the services of an appraiser and need some time to ascertain whether we do want to go forward with the case after we review the appraisal.
Great. Any comments from the assessor?
The assessor has no problem with a continuance. I think due to the fact that you've engaged an appraiser, I believe a March date would be best. And are you of the opinion that you'll be able to get this appraisal to the assessor by January 4th?
Yes.
Okay. So let's do a proviso of
60 days prior to the
60 days prior to the.
Okay, Mr. Kamens, is March 4th acceptable?
Yes, it is.
Okay. Any questions or comments from the board?
The assessor, did you need any more information or just the appraisal?
This is a base year value transfer, and I'm of the opinion that the appraisal will capture not only the business property but also the real property. So that appraisal should be all inclusive. If there's anything minimal, then we'll clean that up around the time the appraisal arrives. So no, short answer at the moment. No. Sorry.
I was rewinding that in my head.
Yeah.
No. Okay, great.
Thank you.
So we'll look for a motion to continue to March 4th.
So moved.
The proviso.
And that
With the proviso that the information is given to the appraisal is given to the assessor 60 days before the hearing date.
Okay. Moved by Mr. Curtis and seconded by Mr. Crow, I believe.
Yes.
Okay, and motion carries.
Thank you.
Thanks. Okay, that should take us to the last group of items on the agenda. 138 through 139, applications 17-11450 and 17-11460. Applicant is KDF Park Glen LP. Morning.
Good morning. I'm a representative of the SSC Limited Partnership. I
Great.
work for the managing general partner of the partnership.
Great, and could you state your name for the record, please?
Vasilios Salamandrakis.
Okay. And Mr. Salamandrakis, are you prepared to move forward today?
Yes, I am.
Great. And any comments from the assessor?
The assessor is also ready for hearing. We're estimating 30 to 45 minutes, and we are requesting findings of fact.
Okay. And any estimate of the applicant's presentation time?
5 minutes or less.
Oh, okay. Okay, so we will come back to your item as soon as we can. Hard to tell exactly how long that'll be, but we will we'll give updates, as often as we can. So there are several items we've trailed. Mr. Vlahakis, do you have one that you'd like to pick first?
Well, I don't see anyone that
There were some
trailed
car
back in
troubles.
the room.
Should we go to the car troubles first, or?
I don't think
Which
still,
one?
Mr. Gangloff, are you present? Oh, you are. Okay, come forward. I'll come to the podium. I'll swear you in real quick. Yeah. You solemnly affirm that the testimony you're about to give in the matters now pending before this board will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Okay. We've skipped over your items, so let's see. That is starting with 88 and 89. Okay.
88 and 89?
Yes. So he's got 4 items total: 88, 89, 114, and 115.
Okay. So first, we'll go to 88 and 89, applications 17-10874 and 17-11108. The applicants are Howling California Properties, Inc. and Howling Nurseries, Oxnard, Inc. Good morning.
Yeah, and then we're just trying to get a postponement for this. The consultant who's working on it has been on medical leave for about 3 weeks now, so he hasn't been able to make it here or get any information.
Okay.
Just to clarify, are you Rick Gangloff?
Richard Gangloff.
Richard Gangloff? Okay,
Yes.
Thank you.
Okay. Any comments from the assessor?
The assessor has no issue with agreeing to a continuance. There is data that's still out there. You mentioned your consultant
Gilbert Arceva
is still putting everything together. When do you think that would be the?
He gets back from medical leave next week, so I can talk to him, and then I don't think he needs that much time, maybe a 60-day postponement.
Let's do January 14th,
Okay.
and then data. I'm sorry, you said he was coming back when?
Next week.
Next week. Do you think he'd be able to get us the data within 30 days?
Yes.
Okay. Proviso of 30 days for data, and then January 14th.
Okay.
Sounds good.
And are there any questions from the board? Okay, so we'll look for a motion to continue January 14th with the condition that the applicant submit requested data by within 30 days of today.
So moved.
I will second that motion.
Okay, moved by Mr. Curtis and seconded by Mr. Crow. And the motion carries. So that one,
One more vote.
Mr. Gangloff, goes to January 14th.
Okay, and just to clarify, that covered 88 and 89. Is that correct?
Yes.
Okay, thank you. So then now we're at 114.
Okay. Item 114, is this related to item 115 other than the same representative, Mr. Vlahakis? Or
It's my understanding they're no related. It's
Okay.
just the same representative.
Got it. So application 17-11114, applicant is Super Center Concepts, Inc.
And then we just want a postponement on that as well, just waiting for production numbers to come in.
Okay. Any comments from the assessor?
January 14th, I think, would be appropriate. We'll keep everything grouped together and proviso of data within 30 days.
Okay. Any comments from the board?
To the assessor, 30 days from today.
Sorry, 30 days from today. I'm sorry about that. Yes, sir. Thank you.
No questions.
Okay, so we'll look for motion to continue to January 14th with information from the applicant to be submitted within 30 days of today.
So moved.
I'll second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow, and motion carries. And then we'll go to item 115, application 17-11115, applicant Bloom Energy 2009.
We're just doing a postponement on that as well.
Okay, and January 14th,
Yeah, that's fine.
Mr. Horn?
January 14th, data within 30 days of today. I believe there are a few items that are still hanging out there with regards to the business property in question.
Okay, any questions from the board? Okay, we'll look for the same motion as the last, for continue to the January 14th. information submitted by the applicant within 30 days.
So moved.
I'll second that motion.
Thank you for your time.
Okay, thank you. Moved by Mr. Curtis, seconded by Mr. Crow, and motion carries.
Okay, on our other trailed items, I don't see Mr. McDonald back. If you're in the lobby and can hear this, or Mr. Flannery. Neither of them are coming in. I don't know if we want to start hearing our first item and come back to them after we do that. Or if we just want to take a 5-minute recess and
Yeah,
figure
let's
that out after
let's do that. We'll take a 5-minute recess and then come back and we'll hear our first item, whichever that is.
Which is the first item?
If we're going based on order, that would be 77 Kirpal and Shakur Dhaliwal. I apologize for the mispronunciation. If we're going in order, that would be the first one.
Okay.
So we'll hear you in 5 minutes.
And board members, both Mr. McDonald and Mr. Flannery are at the assessor's counter talking to representatives. So that's the reason for their lack of presence in the room at the moment.
Got it. And Mr. Dhaliwal, you can bring your information and either present from the podium in the middle, or you can use this desk area to your right. Okay.
All right. So
Yes. Okay. We're back in session a few minutes after 11, and we'll first get an update from an item that we trailed, items 83 and 84, VMD Aviation LLC. Mr. Vlahakis, do you have an update?
Yes, I believe Mr. Flannery wishes to move forward on the 2017 year, which is item number 83, and he wishes to reschedule item number 84, which is the 2016 year.
Okay. And Mr. Flannery, does that sound accurate? Great. Okay. And any comments from the assessor?
The assessor has no problems with doing that. I believe the applicant said he filed a 2018 appeal, so I don't know if the clerk of the board is going to schedule a date.
At the request of the applicant, I will try to consolidate them. I checked beforehand and did not see any such appeal on file, but if it was filed on the very last day, it's possible it's still awaiting data entry, but I'll do what I can to schedule that for the same date that we continue the 2016 year to.
So it comes down to Mr. Flannery, what date do you request? January or March?
It would have to be March because I'm always in Hawaii in January.
Oh, that's a shame.
That's
I'm
good.
sorry to hear that. Okay.
Well, maybe one day when you're as old as I am, you'll be there too.
March works for the assessor and might also work for the clerk of the board as well.
Yes.
Okay. So any
So
questions?
you're going to
from-
give me something to.
Your
I'll get a
confirmation
notice.
here is your agreement, but you will get a letter that
Confirmation.
says the 2016 application has been rescheduled to March 4th, and if I can put 18 on that date, you will get a separate letter saying 2018 is scheduled for that date.
Thank you very much.
Okay, so we're just talking about item 84 right now, and need unless there are any questions from the board, looking for a motion to continue to March 4th.
So moved.
I'll second that motion.
Okay, and then just to clarify from both parties, we're moving forward today with item 83, application 17-10667.
That is correct. It is the 2017-2018 evaluation. I believe Mr. Flannery requested findings of fact. Is that correct?
Yes.
Yes, he's paid for it. I have the payment here on my desk.
Okay, so it looks like your hearing will be the second that we hear, and just depending on the timing of the one that we're about to go into, could be anytime in the near future, so
Okay.
stay with us.
Sometime today.
Sorry, I need one more vote on the continuance.
I'm sorry.
Is it not?
Oh, it's not working.
Okay, I'm just going to assume everyone says yes.
Now it worked.
There you go.
Mr. Chair, I believe Mr. Flanagan would be third. The applicants in the box are number one, and then Marin would be number two. Item number
82, right above it is.
Got it. Okay.
Okay.
Great.
And we don't have the other applicant that we trailed back in the room yet, so I just recommend we get into the first case.
So
Okay.
you want me to sit down, right?
Yeah, and then we'll see how things progress and give you an update.
Thank you very much.
Okay. So we're hearing now item 77, application 16-11575, applicant Kirpal and Sukhbir Dhaliwal. And let's see, we'll need to review the application for a moment. So it looks like this is a single-family home that is not owner-occupied, and type of application is related to change in ownership. Is that correct, Mr. Vlahakis?
Yeah, this one, I remember we had some issue when the amendment request was made because it was so complicated. Mr. Ekema could probably explain better. On August 31st, 2016, there was a change in ownership assessment and a new construction assessment made. I believe the assessor indicated wish to bifurcate this. Therefore, if everyone agrees to bifurcate, we would only be hearing the August 31st, 2016 legal issue regarding whether or not a change in ownership occurred.
And is that the assessor's?
Yes, Travis Ekema with the Ventura County Assessor. There was a change. The assessor's contention is there was a change of ownership on August 31st, 2016, in which a supplemental notice was issued. Upon a change of ownership, we reassessed not just the land, but any improvements on the property. At that time, the improvements were in partial complete stage, so they were set on a base year. So what the clerk of the board is saying correct, that there's a change of ownership issue that we'll handle here. If the board determines there was a change of ownership, then the case should be continued on to hear the valuation issue. Of course, the board says there's no change of ownership, there wouldn't be a valuation issue.
Got it. Okay.
To the assessor, were both applications the same exact day?
There's only one application. It was one event. It's just there are actually two facts that are being appealed. The first fact is there was no change of ownership. The second fact is that if there was a change of ownership, they're disputing the valuation put on the property for the change of ownership event. And I believe the clerk or the chairman stated correctly, it is a single-family residence that's non-owner occupied, so the burden of proof would be with the applicant to begin and close the hearing.
Okay.
You mentioned something about there was new construction.
Yes, so this will go more into the valuation component of the property, but there is in progress a single-family residence that was being constructed at that time on August 31st, 2016. So the structure itself was not fully complete. It was in progress of being completed or constructed. However, whenever there's a change of ownership, even if the new construction is partially complete, it would be set on a base year value. Then any additional new construction added on after that date would then be the new construction valuation that we would do to the property.
Okay, so thank you. So to our applicant, what we'll be hearing today is the change in ownership issue.
First of all, ownership issue is not the issue at this moment for us because it's all in the family. We are four brothers, and it's a joint family. And four brothers are going to live together in that dwelling. And that, as I mentioned before, it's a basically a legality issue that how it is owned, whether it's a joint tenants or tenants in common.
Okay, so before we,
it's the family of four brothers that owns it.
okay, so let me just interrupt you for 1 second. Are you? Sounds like that issue has to be worked out before discussing anything else. So, are you prepared to present whatever information you have related to that? Okay. So then, what we'll do is start with the applicant presenting any information that you have. The board will hear it. The assessor and the board will have a chance to ask you questions. Then we'll hear the assessor's presentation, and you'll have a chance to ask questions on their presentation. So do you have any information that you'd like to submit for us to consider
I
related?
have two, because first of all, my background, I'm a mechanical engineer by profession, and I'm also a California general contractor in the state of California. And I built this house myself with giving the contracts to the sub-trades. And this house, I have the actual costs for each trade that I spent on this house.
Okay.
That is one base for the cost of construction approach for the evaluation of the property. Secondly, I had hired an independent appraiser to do the appraisal,
Okay.
to present it to the county assessor's office.
Sorry to interrupt you again. Before we get to the issues related to construction and value, we need to assess the or discuss the issue of whether or not there was a change of ownership before talking about that. So do you have any information that you would like to present related to whether it's in writing or verbally?
This is the document that was presented. That's page number 2 on that set.
On the
that
application.
was presented.
Oh, okay, so here it is.
Signed by.
Applied yet because it had a bunch of cost information. So.
Okay, so what we will focus on with the packet of information, which we will call Applicant's Exhibit 1, we'll focus first just on
the
ownership issue. So it looks like the second page shows a quitclaim deed, is that correct?
Yes, sir.
And so any information that you just presented to us or any additional testimony you'd like to make related to just the change of ownership or not, whatever your position is, let's do that now.
Okay.
And then we'll take any other issues afterward.
Yeah.
So go ahead whenever you're ready.
So these are all the 4 brothers and 2 of their wives that they signed this quitclaim deed from joint tenants to tenants in common. And that's the document that shows.
Okay.
That was presented to the assessor's office for the ownership.
Okay, and so your testimony is that there was not, you don't believe that there was a change of ownership, just a change in the form?
There wasn't. In fact, actually, the only thing was the technicality, because my attorney told me that if it is joint tenants, that what he explained me, I'm not really good at law, and he explained me that if it's a joint tenants, if someone dies, one of the brothers, the interest of the property goes to the rest of the brothers or the rest of the tenants. But he said that it will be in your family interest for all the brothers that it should be 25% of each brother. And that's why they technically, he told me it will be called tenants in common.
Okay.
That's why we made this document.
Okay, thank you. And is there any other information
No,
that
sir.
you'd like to discuss related to the change in ownership?
Not
Or
right now.
that issue?
If they ask for any other documentation, because all the family is all together, and we can present any kind of documentation.
Okay. So then let's go next to any questions from the assessor to the applicant related to that information.
Yes, Travis Ekema with the Ventura County Assessor. You did provide the assessor does get recordings from the recorder's office whenever there's a document recorded. So we did have the quitclaim deed in our office. However, this event happened previously to the event that we did the change of ownership for. So there's a subsequent deed that we'll have in our packet to provide to you, in which the 4 brothers granted to the single brother Kirpal Dawaliwal. And so that is what triggered the 75% change of ownership. So are you aware there's a subsequent document?
Yes, yes, sir. That was for the purpose of getting the loan.
Okay.
And that's why, because they gave me this, because the bank told us that you qualify for the loan, and they don't. And that's why they did it. That was in the family, and that was recorded by the bank.
Okay, so I guess that's what I want to get clear. You understand the change of ownership that we're discussing today did not occur on this quitclaim deed. It occurred on that deed in which, correct me if I'm wrong, Kirpal Dhaliwal is the 100% title owner to the property, correct? If someone did,
According to that document, it might be because whatever the bank asked us to do, that's what we did.
yes. And that's why I just wanted to try to get clarification. Title to the property is 100% in Kirpal Dhaliwal right now, correct?
Yes, sir.
Is there any future plans in the future to change title again?
Yes, sir.
And what are those plans?
It will be again the same, the tenants in common, 25% of each brother.
Okay. And then the assessor also has a couple questions. I did get some information regarding some tax returns for 2015, 2016, trying to establish who held beneficial ownership in the property. We did receive tax returns for, I believe, 3 of the 4 brothers, and that indicated there was a beneficial interest in the property in 2015 and 2016. But I requested if we could get the tax returns for 2017 to make sure that they still had a beneficial interest in the property. But I believed at that time, or this was just last week, the tax returns still have not been prepared for 2017.
Yeah, because our CPA files the tax returns with the businesses, and usually our deadline is 15th of October.
Okay,
And
so-
still, they haven't prepared it.
Okay. And so today you have no tax returns for 2017 to
Not-
present as evidence to the board, correct?
Not today.
Okay. And so the only evidence you have is your testimony today that there was no change of ownership, but no actual evidence.
No.
Okay. The one last question I have, we do have quite a few different documents here. Are there any documents that you have that show all the brothers signing on for any of these contracts? I do see there was a contract for electrical work for the Dhaliwal residence, and it was signed by yourself. But are there any other documents that would support
No,
the brothers
I
signing
am
on
the
the
only
contracts?
one signing most of the documents. I kind of represent the family. And that's why, and if you look at the 16 or 15 tax returns, there will be the farm income from that property filed by the other 2 brothers also. And that shows that they are also claiming the ownership of that property. It might be in the county records, it might be only me owning the 100%. But basically it is in their tax returns, if you have those tax returns of the rest of the brothers, they have the farm income shown there.
But we don't have those tax returns to show to the board today, correct? For 2017.
Did you have those tax returns? You said that you have tax returns from 15
Yeah,
and
so
16?
the assessor doesn't dispute that the brothers had ownership in 2015 and 2016. The issue at discussion today is whether a change of ownership happened on August 31st of 2016. And that would reflect in the 2017 tax return
Okay.
because they were no longer on title to the property. So, but I just had one further question. Brothers are brothers, but is there any written agreement that you have today to produce to the board to show evidence that all the brothers have an ownership interest in this property?
No, sir.
Any affidavits signed under penalty of
No, I
perjury?
didn't bring that, but I can provide that because it's all in the family. And also by 15, I can also provide the tax returns.
Unfortunately, we're at hearing today, and today is the day we needed the evidence, and that's why I've been requesting this information for the last couple months, trying to get this to establish whether or not there's been a change. I believe the applicants answered all the assessor's questions. We'll present more evidence with our side of the hearing. Thank you.
Thank you.
Okay, thank you. Are there any questions from the board to the applicant?
So the recorded deed to get the loan is in your name, is that correct?
Yes, sir.
Okay, any other questions from the board? Okay.
I'm sorry, what's the property address that we're talking about?
It's 6901 Worth Way,
Okay.
Camarillo.
I just want to make sure. And the house is 17,000 square feet?
Yes, sir.
All right, thank you.
Okay, any other questions from the board to the applicant? No, okay. Now we'll hear the assessor's presentation.
For ease here, the assessor, there's two exhibits, but I just placed it in one packet. There's Exhibit A, which is the main assessor's presentation. Exhibit B, which I believe is the last 3 pages of the packet, is the grant deed in which the assessor determined there was a 75% change of ownership. Let's begin on page 3 with our introduction here. I believe we've established the application and the parcel numbers under appeal and the date the change of ownership occurred. So give you a brief overview, on August 31st, 2016, Kirpal Dhaliwal acquired 100% interest in the subject property pursuant to a grant deed recorded. Mr. Dhaliwal previously had a 25% interest in the subject property. Therefore, the assessor determined there was a 75% change in ownership pursuant to Revenue and Taxation Code 60. We can skip page 4 because that was regarding the burden of proof, and I believe we established the burden of proof is with the applicant here. There's also, in page 5, there are rebuttable presumptions regarding ownership interest. In particularly, Rule 462.200 B states that when more than one person's name appears on a deed, there is a rebuttable presumption that all persons listed on that deed have an ownership interest in the property unless an exclusion applies. To overcome the presumption, consideration may be given, but not limited to, the following factors: an existence of a written document executed prior to or at the time of the conveyance in which all parties agree that one or more parties do not have an equitable ownership interest in the property. And then number 2, any monetary contribution of each party. The best evidence would exist of any factor shall be either adjudicated of the existence of the factor reflected in the final judicial order or judgment. Proof may also be by declarations under penalty of perjury or affidavits accompanied by such written evidence as may be reasonably available, such as written agreements, canceled checks, insurance policies, and tax returns. That's why the assessor asked the applicant if there was any written agreements prior to this, asked for the tax returns to verify beneficial ownership of the property, and so forth. There was also an annotation that further supported the presumption of the law, as well as the assessor handbook. And the standard that's in the law is clear and convincing evidence. And it states that the presumption may be rebutted by clear and convincing evidence to the contrary. Clear and convincing evidence is proof that's explicit, unequivocal, so clear as to leave no doubt, and sufficiently strong to command the unhesitating assent of every reasonable mind. So basically, if title is in your name, you're presumed to be beneficial owner of that property. Someone would need to provide clear and convincing evidence to state otherwise. And that's why that presumption's in the law. On page 6 is the evidence code that talks about the presumptions affecting the burden of proof that, of course, apply to title to property. And again, it says the owner legal title of the property is presumed to be the owner of the full beneficial title. This presumption, again, might be rebutted only by clear and convincing proof. So the evidence code is where the rule was established for property taxes. Also, the assessor provided the Rule 462.260 regarding the date of change of ownership. So where there's a transfer by a deed or other document, the date of recordation shall be rebuttably presumed to be the change of ownership. So the next item is regarding the grant deed, which, like I said, is in our Exhibit B, but I put the details here for you to review. But where each of the brothers who held a 25% interest in the property, along 2 of the brothers had their wives on title, with 25% granted just to Kirpal Dhaliwal, married man as a sole and separate property. And the legal description was a parcel 15 there. On page 7, the documents that were received from the applicant, as I stated, we requested some documents to see if we could overcome the presumption working with the applicant. We asked for the tax returns. We received tax returns for 3 of the 4 brothers for 2015 and 2016, but not receive any tax returns for 2017 or the missing brother. We also provided some bank statements for June and July and August of this year with the name Sukhbir K. Diwaliwal, DBA Sukhbir Diwaliwal Ranch. I didn't receive any partnership agreements, no written agreements that stated that any of the parties who belonged to that or whatsoever. So with the information the assessor had with the deed presumption, the assessor believes that the clear and convincing standard was not met, and so therefore the presumption can't be overcome with the evidence the assessor received. So we would request the Assessment Appeals Board to sustain the change of ownership due to the title change of the subject property that occurred on August 31st, 2016 for a 75% change in ownership. Thank you.
Okay, thank you. So we'll next go to questions from the applicant to the assessor based on what they just presented. And again, this is just a time for questions to clarify what was presented. You'll still, Mr. Dhaliwal, have an opportunity at the end of the hearing to summarize your position on anything. So if you have any questions, go ahead.
No, sir, because basically, as I mentioned before, that it was all in the family, and we are a joint family living together. And just for loan purposes, that's what it was done. And other than that, ownership is not the issue at this moment. The issue is the taxes, property taxes. And that's what we are disputing for.
Okay. Okay, let's go to any questions from the board to the assessor.
Has there been any filing on behalf of the applicant to transfer partial ownership back to the brothers?
I believe the applicant stated in an email that their intention is to do that, yet, however, the assessor hasn't received or seen it written up, or there's nothing been recorded to date. The last recorded document the assessor is aware of is the August 31st, 2016 grant deed regarding title changes. There might be other documents recorded that don't deal with title changes that the assessor typically doesn't review.
Now, when that changed, if they do record that, will that constitute another change of ownership that will have to be?
Yes, with the presumption under the law that there would be another change of ownership. We do typically see where people do stuff for financing purposes, and that's why the assessor requests verifying documents about beneficial ownership. People are sometimes added to title who are not, they don't live in the property, they do not contribute any money to the property, but we request to that documentation to substantiate that claim, or we ask for written affidavits from the parties declaring that they have no ownership interest in the property, they do not live there whatsoever. We have not received any information from the applicant in this case. Like I said, we've received the 2015 and 2016 tax returns for 3 of the 4 brothers, and they did indicate there was income for some avocado and lemon trees that are on the property, because if you see through the appraisal, it's a very large property. So there is a residential component as well as an agricultural component to the property.
Mr. Curtis, any questions? Okay, I had 2 quick questions. Number 1, were there any discussions with the applicant prior to today's hearing about the fact that, had they executed a document, maybe they could
usually
be having to go through this?
Yeah, Mr. Stern, typically, the rule has suggestions on how to overcome the presumption. So I don't tell them, well, if you just write this up, then it'll all go away. I explained to the applicant that we need clear and convincing evidence to substantiate their claim that there is no change in ownership. So we did go back and forth on emails regarding that. I believe there has been some confusion regarding what triggered the reassessment here, and that was the issue with the amendment of the application, thinking that we were supplementing for new construction completed, but we were not at that time. We were supplementing for the change of ownership issue. So it can get very confusing. However, like I said, the deed presumption is a high hurdle under the law, and there's a reason why it's there. If the assessor received evidence otherwise, we would be willing to look at it to determine that no change of ownership occurred. Luckily for the applicant, change of ownership determinations typically can be reviewed in the future. However, if the board orders that there's a change of ownership, we won't be able to look at it again. But a lot of times we might have an event that occurred previously, say in 2004, that didn't go in front of the appeals board, and we did do a change of ownership. But later on, we received substantial information to establish that there was no change of ownership. We would reverse our determination, and likewise the other way. If we determined there was a change of ownership that was either unrecorded or we, in error, said there was no change of ownership, we could establish that base year, and of course issue escapes accordingly.
That was my other question.
Yes.
Is if they, after today's date, execute whatever form, document, deed, reverting to the prior ownership, if that's something that reverts the base year value, or is that an option?
The assessor prefers not to give legal advice, but I can speak to what Mr. Stern, what you're speaking of, or Chairman Stern, is a rescission deed. And so a rescission deed is usually put in place where all the parties agree to restore the property to where it was previously to the deed. County Council probably could speak to this, but basically they have a contract and they can cancel that contract to restore ownership. So typically if the assessor accepts the rescission, we would restore the base year going forward. However, the applicant has a very unique set of circumstances regarding their property. The assessments under the LCA or the Williamson Act, so there's restricted values, and the restricted valuation has changed due to the fact that they have built a single-family residence. So the base year, I believe, was previously established in 2007 or 2008, and to many of us are aware of the markets in this area, that was near the peak. So I'm not sure if there would be any benefit, but that's something we could look into for the applicant, though.
Thank you. Any other questions from the board to the assessor? Okay, so just on this issue of ownership, we'll have closing summaries. We'll start with the assessor, and then we'll end with the applicant on any information you'd like to cover again.
Thank you, Chairman Stern. As the assessor stated, the assessor received a deed. The presumption under the law says that the beneficial ownership is with the title owner. The assessor tried to request additional information, tried to verify that beneficial ownership did not change. We received some evidence, but again, it did not meet that clear and convincing standard. That's the legal hurdle that the assessor would need to overcome. So the assessor, again, would request that the Assessment Appeal Board sustain the change of ownership determination and continue the case for a valuation component. Thank you.
Okay. And any closing summary or information you'd like to share again?
No, sir.
Okay. So then for the change in ownership portion of the hearing only, we will close the public testimony, and then we do have findings of fact. Is that correct on this one? So I think what might be appropriate to do is to have our deliberations in closed session allow for information related to the issue, the findings of fact to be completed, which means we won't be able to give you a decision right now. But we will deliberate either today or a near date, depending on what the rest of our day looks like. And then Mr. Vlahakis can send a minute order, or you can check in at any time. Is that right, Mr. Vlahakis, related to a decision?
Yes, I would be able to provide an update on if your board has reached a decision or not and what the board's decision is when you decide to check in.
And so then my understanding is that, go ahead.
The improvement, is there an issue there?
So I think,
Based on the improvement?
yeah, I think related to the improvements in the valuation, maybe that's something that is that something that cannot be considered until after this issue is resolved?
I think the reason
Redo
would
that
be is if your board determined there was no change in ownership, that would not be an issue, versus if your board determines that is a
Right.
change in ownership, then that's something that has to be addressed. Is that correct, Mr.? Yeah. So it would be an unnecessary hearing if your board reverses the change in ownership.
Any comments on that from anyone? Procedurally?
So how would we hear that if?
I guess we would continue that to a future date.
I'd recommend continuing it, and I'm sure the applicant would agree to withdraw that issue if you end up reverting their value, because there would be nothing to address. The second hearing would be unnecessary, so recommendation would be to continue the hearing on valuation to some later date. I guess if January 14th, if that would be enough time for the board to make their decision.
Okay, so then back to the applicant. We'll make a decision based on the change of ownership issue soon. And it sounds like it may make sense to continue the request to review the valuation and construction to January 14th. Is that something that's acceptable to you?
Should be okay, sir.
Okay. And to the assessor, are you okay with a continuance of the construction portion, if necessary, to January 14th?
Yes, the assessor is in agreement with that. We'll await the board's decision with regards to this issue.
Okay. Any other comments from the board on the issue? Okay, so then, again, we'll deliberate on the change in ownership issue, and then we'll look for a motion to continue the construction and valuation portion, if needed, to January 14th.
So moved.
I'll second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow, and the motion carries. And then, Mr. Vlahakis, do we need to relate it to findings of fact? I guess we haven't made a decision yet, right?
Yeah, you've tied up all the ends you need to tie up
Okay.
for the record right now.
Okay. Thank you.
Thank you.
Okay.
Can you keep that copy of what?
Yes.
Thank you. Okay. And then I thought Mr. McDonald came back into the room. Do we know status update on?
With regards to Mr. McDonald, site server will be moving forward.
Okay, then we can come back to that one later.
And then
Okay, I just wonder if he was just waiting to continue and then leave, that's.
No, he'll be continuing the second one, which is new construction.
Okay.
Because he agreed to a site check.
Okay, so it looks like then next on our list will be item 83, back to Mr. Flannery, is that correct?
As the chair, you can go in whatever order you would like. If we are going in agenda order, 82 would be next, but if you prefer to hear 83, we can do that.
I'm sorry. So 82, okay. So that would be Mr.
Schubel?
Marine Corporate Center. Right, okay.
Thank you.
Okay, great. Thank you.
That's correct.
Let's see, so we've got, this one is another one. Maybe, I can, is the phone that I have for your cell phone? Okay, I'll give you a call when we're starting on the, whatever I called you on last. I'm gonna give you your cell phone number. So I'll do, when we're wrapping before here, I'll give you a call to say, hey, you're on appointment, I'll say, hey, we're gonna be back from lunch, and whatever, so I'll let you know.
Thank you all.
Just let us know whenever you're ready.
I think we're all set. This is a appeal of commercial property in Thousand Oaks. It is a decline in value appeal for 2018, and therefore the applicant would have the burden of proof.
Okay, great. So we're hearing item 82, application 17-10596, applicant Marin Corporate Center LLC. And the applicant's presentation will be first, but if we could just get a quick overview of the application from the assessor for a second, then we'll go ahead with the applicant's presentation.
Good morning, board members, county council. Steve Bates with the Ventura County Assessor's Office.
Morning.
Morning. Subject property being appraised today is for 2017-18. It's a major office building in Thousand Oaks located at 501 and 509 Marin Street. This is a decline in value appeal as of 1/1/17. The burden of proof rests with the applicant.
Okay, great. Thank you, Mr. Bates. So, Mr. Schubel, whenever you're ready, go ahead. We have a packet from the applicant. We'll call applicant's Exhibit 1.
Thank you, Mr. Chair, members of the board. Applicants 1. Okay. If I may, refer the board to page 2 of applicants 1, titled Summary of Salient Facts, just to familiarize ourselves with the property. As Mr. Bates said, it's
Is your mic on?
I have a green light. Can you not hear me?
Okay. Yeah.
Maybe closer. No, it doesn't move.
Okay.
Try and speak into it more. Okay. So the subject property is an office building located at 501 and 509 Marin Street in Thousand Oaks. It's two-story Class C office buildings built in 1986. The aggregate net rentable area is 50,025 square feet. It's situated on a plot of land of 4.45 acres. And as Mr. Clerk stated, this is a 2017 Prop 8 application. The assessed value of the property currently as of the lien date is $10 million, allocated 5.4 to the land and 4.6 to the buildings. Because the subject property is a commercial property that earns income, the applicant's exhibit takes an income approach to property, which, if I may refer the board to page 5 of applicants 1. A review of the subject rent rolls looking for leases that were relatively or reasonably timely to the January 1, 2017 lien date was conducted. From that review, 3 leases were selected, and I'll review them briefly. They're shown there. In Suite 123, there's a Center for Autism and Related Disorders that has a 64-month lease commencing September of 2016 for the suite area of 2,002 square feet. It has a face rent of $23.40. However, the lease does include 4 months of free rent, so that the effective rent is $21.
Mr. Schubel, sorry to interrupt you. Are we on page 5 right now?
Yes.
Okay.
I'm sorry.
Just want to make sure we're all literally on the same page.
Okay.
Go ahead.
Sure. So because of the 4 months of free rent, the first listing there for Center of Autism and Related Disorders has an effective rent of $21.94, or $1.83. Then second listed there is the Thousand Oaks Hospice Incorporated. It's a 37-month lease for a smaller suite, 566 square feet, commencing April 1st of 2016. The lease has a face rate of $21.60, but it also includes 1 month of free rent, so that the effective rent is $21.02, or $1.75 per square foot monthly. And then lastly, in suite, I'm not sure if that's right, 21, Deborah Goldblatt. It's a small suite, 313 square feet, a 36-month lease commencing March 12th of 2016. It has a face rate of $22.32 with no free rent, so the effective rent is the same as the face rent, $22.32. So that the weighted average of these 3 leases is $21.80. And it was deemed that $1.85 or $22.20 was an appropriate fair market rent for the subject property as of the lien date. Then referring the board back to page 4 of applicants 1. As mentioned, the aggregate net rentable area is 50,025 square feet. the monthly rent at $1.85 or annualized at $22.20 gives us an annual gross rent of $1,110,555. We've allowed a vacancy and collection rate of 10% for this property, which we feel is a fair market assumption for the subject property for the market it's in. So that gives us an effective gross income of $99,500. Also, reviewing the income and expense statements for calendar year 15 and 16 gave us some other income categories, including parking income, signage, and then the catch-all category of other income. Based on the actuals for 16 at $600 for parking, $2,415 for signage, and $4,912 for other, which totals $7,927. It was decided to use an other income factor of $7,900. If the board cares to flip to page 3, you can see the assumptions of the direct cap then running down. So as I stated, we had a scheduled gross of slightly over $1,110,000, less the 10% vacancy and collection gave us an effective gross of $999,500. And then we add to that the $7,900 other income. So we get a net effective gross of $1,007,400, which I'm sorry doesn't actually show there, but that's what it is. Then to continue with the assumptions to the direct cap, we then reviewed operating expenses for the subject, which the exhibit on page 7 of applicants 1 shows a review of the year-end actuals for the subject, calendar year 15 and 16. Because we had it, we looked ahead to 17, but limiting ourselves to what's shown, actual expenses for the subject for year-end 15 were $261,368, or $5.22. And then for year-end 16, as of 12/31/16, actuals were $298,929, or $5.98. Based on this review, it was decided that $6 per square foot was a reasonable expense rate for the subject. So then referring us back to our direct cap on page 3, we now take out the operating expenses at $300,150, gives us a net operating income of $707,250, which then in order to capitalize that rate, we have to choose an overall rate. And the applicants 1 has an exhibit on page 8 by which 4 closed sales of commercial office properties in the subject market were reviewed. Overall comparable sale number 1 is the Agora Hills Medical Plaza at 29,525 Canwood in Agora Hills. It sold in March of 2017 for $13.8 million, with an actual overall rate reported by CoStar of 6.57%. That's a 1982-year built building in 51,775 square feet, and it sold with this 90% occupancy. Comparable sale number 2 for overall rates is Camarillo Business Center 4 at 760 Paseo Camarillo in Camarillo. It sold in March of 17 for $10.5 million. It's a 1984-year built property in 71,992 square feet. It's a 4-story Class B office with an actual overall rate per CoStar of 7%. Our third comparable sale is Westlake Village City Center at 31,051 Agora Road in Westlake Village. It sold in May of 16 for $18.6 million. It's a 2001-year built property, sold 100% occupied, 64,520 square feet, and it had a pro forma cap rate per CoStar of 7%. And that's a 2-story Class A office building. And then lastly, comparable sale number 4 is Conejo Business Center at 101 to 145 Hodenkamp Road in Thousand Oaks. It's a 1991-year built office building in 70,302 square feet. It sold May of 2016 for $10 million. That's 3 2-story Class B office buildings with an actual overall rate per CoStar of 5.5%. Based on review of these comparable sales, it was deemed that an overall rate of 6.5% was appropriate for the subject. So looking quickly at page 4 of applicants 1, we can see under rate selection, so now we have an overall rate of 6.5%, 2017/18 effective tax rate of 1.0399% gives us a built-up cap rate of 7.54%. Then referring back to page 3, so our indicated net operating income of $707,250 capitalized at 7.54% gives us an indicated value to stabilize of $9,380,091. The one thing I failed to mention when we looked at page 2, the salient facts for the subject, is you'll note at the top under the picture, we have the occupancy as of the lien date 1/1/2017, which is 65.27%, so that the actual vacancy percentage is 34.7%. The property has historically had a fairly high vacancy, and just for comparison's sake, you can see underneath that the occupancy for 1/1/16 was slightly worse at 60.13%, for a vacancy percentage of 39.9%. Given that, because we're analyzing the property as though stabilized, but it has a greater than market rate vacancy, we've done a review allowing for rent loss to stabilization, which the exhibit shows on page 6 of applicant's 1, rent loss and TI analysis. So you'll note that we run an analysis for 2 years based on the chronic vacancy percentage in the subject. We thought the 2 years was reasonable. There's a 9% discount rate, a 24-month absorption period, our market rent at $1.85, and then there's a fairly token TI allowance of $5 per square foot, so that we get an indicated loss to lease up of $388,580, which is then brought forward again to page 3. So our indicated value as though stabilized at $9,380,091, less a rent loss of $388,580, gives us an indicated value of $8,991,511, or $8,990,000 rounded. That concludes the applicant's presentation.
Okay, thanks, Mr. Schubel. Any questions from the assessor to the applicant?
Thank you, Chair. I do have a few questions. On page 8, is it 8, I believe? Yes, page 8 of your presentation. These are your comparable sales?
For overall rate comps, yes.
For overall rates. But you have no market grid, market sales. You're basing all this on income?
That's correct.
Okay. The property is currently listed, is it not?
That's correct.
The value that you're appealing is what value?
The current roll value is the Prop 8 value at $10 million even.
And the property is currently listed for what value?
I'm told that there's an asking price on a marketing brochure of something around $11.8 million.
Okay. You're using, in your analysis, the effective rent of $1.85?
That's correct.
The sales price, do you know how they determined not sales price, how they determined the asking price?
I do not know that.
Okay. Are you of the opinion that they would have used the effective rent, or they would have used the contract rent to justify an asking price in a pro forma stance?
In my experience, I would think they would have used a pro forma rent, an expected market rent, not a contract rent.
Okay. No further questions from the assessor.
Okay, any questions from the board to the applicant?
Is there a management issue in this property? Thousand Oaks office, pretty strong market there. why this is running 65%.
I understand your question. I don't know the answer. It is an experienced owner. I think this is the only property they have in Ventura County, but they have a large number of commercial real estate holdings in Los Angeles. I don't think that it's a poor management. I just don't have an explanation for why this property is with such a high vacancy.
Okay, Mr. Schubel, the subject property is 2 stories, is that correct?
That's correct.
I saw that there's not a lot of information on the property itself, but I saw that it's noted as Class C. Is there an elevator that serves the second floor?
I'm sorry, I don't know the answer to that. So just to be clear, the subject is 2 buildings, each of which is 2 stories.
Right.
I don't know if there's an elevator.
Do you think that if there are second floor offices with no elevator, that it could affect the rents that are generated?
That I would expect definitely, although I don't know how it would be. I don't know how the ADA compliance works, whether you could even have office building without elevator.
Okay. Do you know what at the lien date, do you know what the occupancy on the first floor versus the second floor was?
I'd have to refer to the rent roll, but I could do that if you would like.
It's up to you, whatever information you'd like to submit. In terms of vacancy rate, you use 10%. Is that derived from any market data?
There's no market data evidencing that in this exhibit. In our office, we use for this area of Ventura County, we use 10%. Another to say that it's our experience and judgment. That's the only thing I have to say.
Okay. I don't have any other questions right now.
The picture that we have, this is the office building?
Yes, so the way I'm sorry there's not an aerial to show you. My understanding, though, is the way it's, the disposition is that there's one building toward the street front and another behind it. So this would be basically the view from the street of the front building.
So there's 2 buildings. I'm assuming the other building is similar?
It looks almost exactly the same.
Okay.
There's, so 501, which is the front building here, is just a little bit bigger at 28,929 square feet. And the back building, which is 509, which I'm sorry that wasn't laid out here, is 21,309 square feet.
It's aged 1986. So is that would be, compared to the other buildings in the area, I think that would be older?
I mean, yes, there are newer buildings. I don't know whether there's a time that nothing was built prior to 80s. I'm not that familiar with the market there.
Sure. All right. Thank you.
You're welcome.
I did have one other question. Mr. Schubel, on the page 8, you show comparable sales for the purpose of cap rates, and the range of the sales seems to be between 5.5% to 7%. And then I believe you use 7.5% for your valuation. Is that is there a reason, or is there a difference in the comps? But this, maybe I'm confused. On page 8 on subject, it says overall rate is 6.5. Is that without the tax component added?
That's correct. That would be the overall rate, and then we would add the effective tax rate.
Okay, I understand. So the rates shown on page 8 should add 1% to be equivalent to the rate that you used in your valuation?
That's correct.
Okay, got it. Okay, I don't have any other questions. Anyone else? Okay, so let's go next to the assessor's presentation. Thanks. Go ahead whenever you're ready.
Good morning, Board. Steve Bates with the Assessor's Office. This appeal is an office building in Thousand Oaks, located at 501 and 509 Marin Street in Thousand Oaks. The subject property was appraised for the purposes of this appeal. consisting of 50,234 square feet of office building sitting on 193,842 square feet of land area in Thousand Oaks. Subject property is a Class C office building with multi-tenants such as PathPoint, Center for Autism and Related Disorders, and Thousand Oaks Hospice. Pursuant to R&T Section 51A, the assessor is required to enroll the lesser of a property's factored base year value or its full cash value as of the lien date. As of January 1, 2017, the enrolled decline in value was $10 million. The total factored base year value for 2017 was $12,128,229. Subject property is currently listed through Lee and Associates for just under $12 million. Per listing agent Scott Silverstein on September 11, 2018, and per site check on September 28, 2018, this is an active listing. The assessor has provided a market approach and an income approach and is recommending that the board sustain the enrolled value of $10 million as of 1/1/17. And as you can see on page 2, the factored base year value being $12,128,229. We have on our tax roll $10 million for 2017. We are recommending $10 million. And per the applicant's appeal application, we have a total of $6 million that the applicant felt that the property was worth. The assessor's evidence includes a comparative sales approach and an income approach. For the comparative sales approach, all comps used are major office buildings within the Conejo area. Subject's current listing price of just under $12 million is used as a comp. For the income approach, subject's most recent negotiated lease effective September 1st, 2016 for $1.95 contract rent was used as rent. Asking rents were and continue to remain at $2 a square foot. The appraisal prepared as part of the appeal case concludes a market value of $10 million. And on page 3 is the sales comparison market approach. As you see here, all comps 1 through 4 are multi-tenant comps within the Conejo area. Comp number 1 is subject's current listing. Comp 2 is located at 141 Triunfo Canyon Road in Conejo. Comp 3 is located at 4035 Thousand Oaks Boulevard in Conejo. And Comp 4 is located at 4580 East Thousand Oaks Boulevard in Conejo. All comps selected are close in time to lien date January 1, 2017. We have here comp 1 being the listing. Comp 2 sales date is January 17th, 2017. Comp 3 we have December 20th, 2016. And Comp 4 May 18th, 2016. I just want to go over the occupancy for Comp 1. For Comp 1 being the subject's current listing, per the January 1, 2018 rent roll, not much had changed at that time as far as occupancy, so we have that as also 65% occupied. Comp 2 was, per CoStar, was 100% occupied. Comp 3 was 96% occupied. And Comp 4 was 76% occupied. And in just a second, I'll discuss the adjustments that were made. In an attempt to set up a value range on my grid with regards to adjustments, the assessor made upward and downward adjustments. respective adjustments made to comps based on characteristics. Starting with comp 1 being the subject's current listing, we made an adjustment of a downward adjustment of 15%. For comps 2, 3, and 4, we did make adjustments based on age, class, building size, land to building ratio, and vacancy. The total range between comps 1 and comps 4 is $9,706,674 to $10,514,161. Square foot value range being $193 a square foot to $209 a square foot, and our value conclusion brought us at $200 a square foot to reach the value conclusion of $10 million. And I just wanted to address the question about the elevator. I did site check this property, and there is an elevator in both buildings at 501 Marin and in 509 Marin. So I went ahead, I just wanted to address the 15% adjustment that was made for the active listing was a pretty generous adjustment just based on the fact of negotiations that the price could actually sell for less than what the active listing is. And even with that 15% adjustment, the value was still above the $10 million that's being disputed today. And if we go to page 4, I just want to go over, these are, per my site checks, I just want to go over, this is comp 1, subject's current listing, has a for sale sign in the front. Comp 2, this is a photo of 141 Triunfo Canyon Road. Next page, comp 3, 4035 Thousand Oaks Boulevard. And comp 4, 4580 East Thousand Oaks Boulevard. And on page 6, I just want to go over the income approach. The date being January 1, 2017. And if you notice here, rents used are based on the most current contract rent signed closest to January 1, 2017. And that would be the Center for Autism and Related Disorders. And that was September 1st, 2016 at $1.95. Vacancy used was 11%, and the vacancy that was used was based on CoStar, the first quarter market vacancy for major office buildings. Expenses reflected on this sheet are in line with other full-service gross properties. And the cap rate utilized was 6%, plus the tax rate component of 1.04%. And due to the vacancy concerns, an absorption allowance was included and a lump sum adjustment was subtracted to capture the vacancy. And you'll see that at the bottom here, $780,000. And that was to capture the vacancy concerns. The assessor made a lump sum adjustment for rent abatements based on rent rolls for January 2017, and that totaled $36,259. That was subtracted from the value. And we arrived at a value of $10 million, which falls within the value range of the market approach and is the value under appeal today. And if you could turn to page 7. The absorption allowance worksheet. As of 1/1/2017, the vacancy was 35%, and the absorption allowance addresses the vacancy concerns. Page 8, you're going to see the overall rates within the Conejo area. all within the Conejo area, that range from 5.20 to 6. And as you know, we used a 6% overall rate, so ours fell in line right here. And these are Agora Hills, Westlake Village, and Thousand Oaks. And if you could turn to page 9. This is just the lease rate comparables you're going to see, with rents ranging, and these are all within the Conejo area. Once again, signing dates ranging from February 2016 to March 2017. And these are, most of them being full service gross. And this ranges from $1.97 to $2.35. And if you turn to page 10, this is just, this is not the sale listing. This is actually the rental rate that shows on the bottom right, $2 a square foot. This is a current one on CoStar. And if you could turn to page 11, I got some photos here. First one being subject's frontage. And then page 12, just a couple more photos here of the exterior of 509. If you turn with me to page 13, these are a couple of photos of the exterior of 501 Marin. And then on page 14, these are interior photos of 509 Marin. And this is the first photo is the lobby, second one being the hallway. And then if you could turn to page 15, I took interior photos of the Center for Autism and Related Disorders, which is the tenant that I use the $1.95 rent on my income approach. Right here, you'll see the front office, hallway. Page 16, office and conference room. If you could turn to page 17. This is actually Path Point. This is one of the suites in 501. And this is the conference area and front entrance. And then if you can turn to page 18, this is an aerial photo of the property. And then on page 19, this is the current active listing that I obtained from CoStar. And as you see here, the purchase price of $11,855,224 is the asking price shows a total of $236 a square foot. And if you notice, the assessor has $200 a square foot on our valuation for the $10 million. So this is roughly about 18% higher than the $10 million. And it's not noted on here, but the property as of today has been on the market for 125 days per CoStar. And on page 20, this is just for hypothetical purposes. As you see, it's written across right here. Rent was based on what the agent had initially told the assessor, $1.80. Holding all other variables consistent with our income approach, we would have to equate to at or around 4 to 4.55% in order to achieve the owner's asking price, presuming there will continue to be rent abatements and vacancy concerns. And then in comparison, it made the assessor's 6% that was used a bit more reasonable. And like I said, this was just for hypothetical purposes that we did that. And then on page 21, This is the Revenue and Taxation Code 501. And page 22, the Sims versus Pope. And the only info received by the agent was rent rolls for 2017 and 2018. End of year income and expenses for 2016 and 2017. Based on 501 supported by Sims versus Pope, the assessor made a value conclusion based on what was in his possession. No analysis was ever received, only a verbal review of a market not a market. Well, yeah, I'm sorry, there was a verbal on a market and an income approach, although I don't see the market one in the presentation. And this concludes my presentation.
Great, thank you. Any questions from the applicant to the assessor?
Just a few, Mr. Chairman. Thank you. Thank you, Mr. Bates, for your testimony. Could I just ask you on your page 3, your market grid? So the column that you have labeled sale 1 is not a sale, of course, right? That's the listing of the subject property?
It is, correct.
Okay. In your analysis, did you give it the same weight that you gave the 3 other closed sales from the market?
Well, as you see here, the value here is $10,076,940. I did not use that. I still stayed with the 10 million that was within range. There was also comp 3 that was 10.5. I did not put weight as if it was a sale, but I did feel that it was important to list it, being that it was the subject property.
Understood. Thank you. Okay. And then in your, just to make sure I understood correctly, in your adjustments under the category vacancy, so you adjusted comparable sales number 2 and number 3 downward because they had the superior occupancy compared to the subject. Is that correct?
I did, and I actually based my adjustments on the value from the absorption allowance to be able to capture the same.
Okay, thank you. And then if I may ask a question on your page, make sure that, page 6, which I believe is your income analysis worksheet. So I don't see it here, but did you review any other leases? You mentioned the Center for Autism, which is also, I believe, in the applicant's exhibit. So you reviewed that lease. Was that the only lease in the subject that you reviewed?
No, I actually received a copy of this lease, and I also received a copy of the Thousand Oaks Hospice. But also, if you take a look at page 9 here, the actual rents here were $1.97 to $2.34, so the $1.80 appeared to be, was not within that range.
And to be clear, so your exhibit on page 9 where it says lease rate comparables, these are other properties in the market?
These are other properties that sold close to the January 1, 2017 date within the Conejo area.
I'm sorry, we're on page 9.
Oh, you know what? I'm sorry. These were not sales. These were lease rate comparables.
Right. Okay.
Yeah. And that signed close to the lien date. I apologize for that.
No problem. Thank you. So these are not asking rents from a CoStar or whatnot. You actually had access to the leases or the, how do you know this information, in other words?
So this was actually from CoStar, so I don't have the copy of these leases.
Oh, so they're CoStar indicated.
Right.
Okay. In your experience with CoStar, do you ever find inaccuracies in what they state are signed rents?
Yes, CoStar can be off, both upwards and downwards. With the range of rents that Mr. Bates reports on page 9, there is a range. And we believe that the 195 that he used for the current contract rent is at the bottom of the range, and represents market rate, especially since the asking rent right now is $2 for the subject.
Understood. Asking rents being what they are. Mr. Bates, in your opinion, since you saw the property, do you think the actual rate in the building being at the low end of the range for your market comps, do you think that's appropriate? I mean, how does that building compare to these buildings? Did you see these buildings? I'm referring to the ones on exhibit on page 9, lease rate comparables.
I did not see the properties that are here on the lease rate comparables. However, I do feel that the fact that the property's asking rents were, as of 1/1/17, and currently are $2 a square foot for asking rent, that the $1.95 that was used was reasonable.
Okay. Do you know, were there any leases signed at $2 in the subject?
Not that I'm aware of.
Okay. And then in the Center for Autism and Related Disorders, the lease that you reviewed, you were aware that there was 4 months of free rent in that?
Yes, and that was accounted for in the lease rate abatements in the income approach.
That's on your page 6, which is...
That.
So is that the $36,259 shown there under the line item less rent abatement 2016? That's not exclusively for autism, or it is?
So this is for all the tenants per the rent roll for 2016. I took a look at every single tenant that had rent abatements, and I totaled those what those rents were for all tenants.
Understood. Thank you. Let me see quickly. Okay, and then referring to page 8 of your exhibit, am I correct? This is your review of closed sales for overall rate comparables?
Yes.
Okay. In your opinion, we have some of the categories, characteristics of the properties here, the comparable properties. Location-wise, would you say they're all more or less comparable with the location of the subject?
Yes, they would. They all are within the Conejo area.
Okay.
I chose to stay out of other areas and just stay within Conejo.
Okay. On the one, it's not labeled, but it's the third one down, 31,365 Oak Crest Drive. There's then the word bulk in parentheses there. Do you know, was this a portfolio sale? Or what is the...
This was, yes.
Okay. Do you know how many properties?
I don't have that information in front of me, sorry.
Okay. Thank you. I have no further questions. Thank you.
Okay. Any questions from the board to the assessor? Okay, Mr. Bates, I have a couple of questions. Okay, let's see. In terms of, let's start with the assessment of the market lease rates. You showed the current asking rate for the subject as a comp, right? $2?
I'm sorry, are you on page 9?
Well, you've discussed the current asking rate.
Oh, page 10. I got it.
As relevant to the market rate, right? You discussed $2 a foot?
Yes.
Okay. And the other properties, you had stated that you believe all of the commercial properties in the Conejo Valley area are comparable to each other in terms of lease rate? I'm just curious because you said you had not visited any of the other properties on the lease rate comparables sheet on page 9.
Correct. I did not visit the properties here on the lease rate comparables. However, the fact that they were in the Conejo area, I felt that they were the best comps available to show here.
So the subject property on Marin, in terms of visibility from a major street, can you tell us how that compares to the comparable lease rates on T.O. Boulevard and Hillcrest and Agora Road?
So based on my site check on the subject property and the comps that were used on my market approach, subject property is located very close to Lynn Road, the mall. However, you could see on one of my photos that there are, on the Comp 1 subject's current listing, there are a lot of trees that are in front of the property. If you notice on Comps 2, 3, and 4, those properties do not have trees in the front.
Okay. The applicant had listed in his presentation 3 executed leases at the subject, all in the range of $1.75 to $1.86. I guess that's effective because one of them had a concession. So, and did you say that you had studied all of the tenants in the subject property to come up with a concession amount line item, or was it was unclear to me how many of the actual leases for the subject property you had seen?
Okay, so
the lease rates, maybe not the leases, but
okay. So the actual contracts that I received from the agent, I received 2. One of them being the Center for Autism, which had the $1.95, and then I actually did obtained a copy of the Thousand Oaks Hospice. I did not receive any other leases for that property. When I mentioned earlier that I did review all the tenants on the rent roll, that had to do with the lump sum rent abatements. What I did is I just reviewed every single tenant on there that had that lump sum and totaled it.
And then when you reviewed all the tenants on the rent roll, did the rent roll also show their lease rates?
The rent roll would have shown the lease rates, and they also would have shown when the rates went into effect. Mr. Bates went more towards the most current rate that was on, that had been signed, and that's why he utilized $1.95.
So the rate for, I guess, Thousand Oaks Hospice, the applicant shows as $1.75 a foot. Is that what you also found?
The information I had was $1.80, and I think what I was looking at was the contract rent. So this amount you see here on effective rent for $1.75, that I believe was accounted for in the lease rent abatement or the rent abatement.
Okay. I guess I have similar questions related to the comp rate or the cap rate comparables and how, let's see, that's page 8, I believe. Does that sound right? Yeah. And so the overall rates shown for the comps are between 5.5% to 6% without the property tax component being added. In terms of those locations or quality of the buildings compared to the subject, do you have any comments on that might or might not affect those cap rates? I'm just asking because they're all consistently lower than the cap rates that the applicant submitted. So curious about what information you might have.
I would say given that the subject property is per our records and the listing of sale we have as built in 1982, and the year built for these we have 87, 2001, 1990, and 1985. And based on that information.
So just the year of construction?
Yes, and then the fact that most of them were multi-tenants.
Okay. Okay, last question. In terms of using the subject property's current listing 17 months after the lien date, which sounds like has been on the market for 125 days, do you think that is relevant to the value at all?
I do. The fact that the owner felt that the property was worth just under $12 million approximately 4 months ago, I do feel that that's important information.
Okay. Thanks. Thank you. Any other questions from the board to the assessor?
I have one question on your leasing there. You're saying 3-star and 2-star. What is that designation? I think it's on page 9.
So this is actually, this is from CoStar, and yeah, this information is from there. However, I put it on a Word doc. Also, going to, just to mention, I don't know if I addressed that on my market approach. I actually did make adjustments for the fact that subject property is a Class C, and the comps that I used were Class B. I did make an adjustment to address that on my market approach.
How big square footage is the Center for Autism?
So that property, I can probably obtain that information in just a second. I do know that based on my site check that the building manager who actually gave me a tour had, excuse me, it's actually 2,002 square feet.
So it's a big.
Yeah,
big
and
area. Okay.
yeah.
Thank you.
I have one more question. Sorry. I think I said my last question was my last question. What's the difference between Class B and Class C?
It would actually be the construction.
So I would assume that Class B, is the higher construction would lease for more. Is that the assumption?
Correct.
Any other comments related to the comps being, I know you made an adjustment, but I'm curious about how you arrived at the adjustment.
Right, and that's the adjustment that I made, the 5% downward for the class, for comps 2 through 4.
So does that relate like directly maybe to lease rate? So if Class B were $2 a foot lease rate, maybe a Class C would be $1.95?
It's possible. And then it also depends on the effective year, being that Comp 2 was built 1970, remodeled in 1995. Comp 3 built in 1985, and then Comp 4 was actually built in 2005. And I actually did adjust downward for the age for Comp 4.
Okay.
Who exactly determines the classes?
The class classification?
Yes. County or CoStar or who?
It goes to it goes to the builder. It's how the construction is built. There are certain classifications that have been set up, A, B, C, and it's however it was built. There's steel construction, there's wood construction, there's concrete tilt-ups. So however the builder comes up with what they want to build, then a designation is made to that.
Gotcha. Can you take a Class C and crank it to a Class B or A? Or if it's Class C, it's pretty much...
You're pretty much stuck
locked
with what you have.
Gotcha.
Safety makes that designation.
I'm sorry?
Says building and safety makes that designation.
That too, yes.
Okay, thank you.
Okay, any other questions from the board to the assessor? Okay, we'll go to closing summaries. We'll start with the assessor and end with the applicant.
Thank you, board members. The assessor put together not only an income approach, but also market comparables. The first comparable is the listing. How much weight should be put on really is going to be determined by the board members, but making an adjustment from list price downward to potential sales price, that value falls within the range of the other three comparables. The rent that was used was the most recent contract rent. We made adjustments for vacancy based on market, used a market overall rate, and further addressed the vacancy issues that have gotten, the occupancy has increased. It's gone from 60 to 65. Right now it's currently around the same rate. And Mr. Bates also made an adjustment for rent abatement. Comes up with a value of $10 million. That $10 million also falls within the market comparable range. The lease rates are all higher than the 195 that he used. So even then, he's coming down at the bottom end of the range. I believe our valuation of $10 million is solid, and the value should be sustained. Thank you.
Okay, thank you. Now we'll go to the applicant.
Thank you, Mr. Chairman, members of the board. Thank you for hearing the applicant's testimony. I do think it's important when we're looking at a property to know what the metrics are that inform it. To the discussion that was happening regarding building class, I don't think anyone actually knows. There's different ones, to be frank. There's the one the assessor uses, perhaps the one building and safety uses. CoStar seems to have its own system that sometimes kind of mirrors the assessor and sometimes it doesn't. Is it a function of, as I think Mr. Horn testified to, the building structure type? Is it a wood frame building? Does it have masonry walls but a roof that can burn? Different things can affect. I mean, everyone knows the best top shelf office tower is Class A steel, so that's easy. When you get into other properties, it's harder to know exactly. And yet when we're valuing them, when we're comparing a subject to other properties in the market, I think it's important to know, are we comparing apples to apples or apples to something like an apple but isn't quite an apple? It's hard to make the adjustments. Since investors buy properties that earn income for that income, we think that valuing the subject property by the income approach is the most telling approach. But yet, as we know, all income approaches, direct caps, have a number of moving parts. So the assumptions that you make, a minor change here or there, can affect the indicated value. We think the applicant took a good approach by looking at, there's not a lot of new lease activity in the subject. So we looked at what there was. The assessor looked at the largest of the three leases, didn't give any weight, as far as I can tell, to the other two. But then again, the assessor made a fair attempt at valuing. Going to the market, or when we look at things that are market-based, such as overall rates, I think it's important to know how comparable is that sale, whether it's for an overall rate or for a comparable sale per square foot. How like the subject is it? And when we don't know or we can't really make reliable adjustments, I think it lends less credence to that approach. That being said, in my opinion, and it's purely my opinion, but when I look at this building, it doesn't look like typical office buildings to me. The assessor referred to it as major, and maybe in the sense of its total area, it would fall into the category of major. To me, it looks like a less good type of property. I can't say that's the reason why it has such a high vacancy, but when we look at some of the pictures in the assessor's presentation of the comparable properties, those look like good office buildings to me. It's what you would expect to see in the Conejo Valley market. And then we see the subject, and it maybe has a certain kind of charm with that Monterey type thing with the balconies and the wood. But yet that's not going to be everyone's cup of tea. You know, maybe it is appropriate for, you know, a PhD or a psychiatrist who's taking a small suite to practice in. Maybe something like the Center for Autism and Development is appropriate for the building, but it's not the whole market. So I do think that that's taken into account. It's reflected in both the vacancy of the subject and the lease performance. And the last thing I'll say is sale prices, as we all know, well, I think all of us who deal with commercial real estate know, everything sells when the price is right. Where the asking price came from, I don't know. We know it's been on the market for a long time. We don't know the motivations of the current taxpayer, although we do know it's a legal entity that owns it. Perhaps there are, you know, warring partners. One wants out, the other doesn't. Put it on the market if it sells. I don't know. But the same is with asking rents for leases. You can ask anything you want, but it stays, when it's an asking rent, it doesn't matter until someone actually negotiates a deal. So I think that should be taken into account. Thank you for hearing the applicant's testimony.
Okay, we'll close the hearing of public testimony, and I think we'll do two things. Number one, we will deliberate in closed session at the end of the day because we have several other things to hear today. And so, Mr. Schubel, you can check in with our clerk and or a minute order will be sent out with a decision.
Thank you.
And also, I think we'll break for lunch until 1:30, and which is 45 minutes, if I can see that far. So we'll be in recess.
Mr. Clerk, do you want to remind the board that the cafeteria is closed?
That's what I was going to say. Because it is Columbus Day, the courts are closed. And downstairs below us, the snack shack is open. But if you don't want that, you may have to go across the street for food.
Okay.
I'll let everyone know.
Thank you, and thanks for everyone else's patience who hasn't gone yet.
Thank you.
Okay, we're back in session 135. We're hearing item 83 on the agenda, application 17-10667. Applicant is VMD Aviation LLC. And we have Mr. Flannery at the applicant's station there. Let's see. Looks like we have an aircraft and a penalty assessment related application. Why don't we, if we could, just hear a brief overview from the assessor of what we're looking at, and then we'll determine how to move forward.
Good afternoon, Efren Ascora with the assessor's office.
Hi.
Hi. Yes, so the subject today is going to be a 2000 Cessna Citation 750X jet aircraft. Because the applicant is appealing the value for Lien Day 2017 is a regular declining value. So in this case, the burden of proof lies with the applicant. And just like the clerk of the board mentioned earlier, we'll discuss the 10% penalty applied, and that will explain that the burden of proof will lie with the assessor.
Okay. And is it the assessor's understanding that the burden of proof is with the applicant?
For the declining value, yes.
Okay. And so it sounds like, again, we have a valuation issue and a penalty issue both, and it's best to hear them separately. Is that what I heard?
I think what we're going to do is Mr. Flannery has requested to move forward with the valuation portion.
Okay.
And we'll take care of the valuation portion, and then we'll follow that up with the penalty portion.
Okay. Great. So then I think we'll start with a presentation by the applicant go through the process of asking questions. Then we'll hear the assessor's presentation.
They're two separate. Here, give me this now or not?
Yeah, so whatever you want to present for your value hearing is what I need now.
They might be a little bit mixed up here. Let me
You
see.
can do everything right now if you want.
Let me see. Assessment. Yeah, they're a little bit tied together, but this is the first part that I'll discuss.
Okay. Okay. Just let me know when you're ready to hand out the second part, and I'll go ahead and take that.
Did we lose Mr. Horn? Are we ready? You ready to move forward? Okay, go ahead whenever you're ready, Mr. Flannery.
I don't know whether it's appropriate or not. Can I give you a little background on me? Because I'm not a professional attorney or tax accountant or anything.
I understand.
So putting all this paperwork together is a little confusing to me.
Sure.
Okay. When I was 15 years old, I quit high school and moved out of my parents' house, and I've been on my own ever since. I worked for a newspaper for a number of years. I was drafted into the U.S. Army for 2 years, and when I went out, I got back to work for the newspaper. I started a little business in my garage in Simi Valley in 1968, and it grew pretty big. I printed community newspapers in this area, in the L.A. area, Southern California, basically. The business grew in about 1999. I got a malignant melanoma on my face, and they took out a third of my face, and I retired that day. And I'd been fairly successful in business, and when I retired, I'd always wanted to buy or build a home in Maui, Hawaii, which I started doing. And with that, I bought a brand new Citation 10 jet to fly over there and other places, and I retired. So for the last 20 years, I've been retired. This last August, the cancer came back, and they took out another third part of my face. And I have a home in Maui, Hawaii that I spend most of the winter at, and I have a home in, I can't even think, Coeur d'Alene, Idaho, that I spend most of the summer in. So it's sometimes difficult to get back and forth with your assessor. That's why I came in Monday. I'd been in Idaho for 3 months and wanted to talk to him and go over these evaluations. He was too busy. We didn't get a chance to do that. So I talked to him this morning, and I have the total evaluation that he's reduced the tax bill down to or agreed to, but I don't have the breakdown of why or how he did it. So with that, I'll go forward. I probably have, over the last, since I bought the plane, I probably have 1,000 pages from your office here over tax issues and things. It's very hard for me to go through all that and sort it all out. The way you put your tax bills in 2017, 18, and you don't count them for, I just get confused as to what year you're really trying to tax me on. And you valued on the previous year where the plane was, but you tax for the next year. So it gets a little confusing with all the paperwork. With that, I'll start. I get a little nervous about this too.
It's okay.
Each year, in recent years, we've got a tax bill that I believe is wrong. And each year, I come into the assessor's office and we go over it and they reduce it. But then when I get the bill the next year, it's back up to the same amount it was the period before. And that's been going on for 3 or 4 years now. And each year when I come back in to deal with somebody in the assessor's office, it's a different person. It's been explained to me that you're training different people and you want them to do different positions, so every year you have a different person that I'm dealing with. And each year when they assess the plane, they don't go back and look at the previous records of what's happened. So they just assess the same old value every year. So every year I have to appeal it. Right now, I have 3 appeals going on with you. This one, the other one that you were going to hear this morning, and one for the following year. And with that, With that, I'll go on to the value part of the plan. I tried to put this together and attach these little statements here to each thing. The first one is let's go different. When I bought the plane, and I got it in 2000, I didn't know anything about airplanes. I'd never flown an airplane, or I'd never been involved in airplanes. And so I looked around to see what I could get, and they told me the only plane that I could afford that would go to Hawaii was the Citation 10. So I bought that plane, and I didn't know anything about managing it or pilots or anything. So I hired a company called Del Mar Jet, which Cessna recommended, to manage the plane for me. They hired the pilots. They paid everything, every monthly bill, all the gas, everything they paid. And once a month they sent me a bill, and I would pay them. So 2 years went by of doing that, and they have what they call corporate care. Rolls-Royce engines are on the plane. They have corporate care that you pay into about $200,000 a year. It's like an insurance policy, so if anything happens to the engines, they will fix them free for you. So every month, Del Mar Jet charged me for that, and they were supposed to pay it on to Rolls-Royce. Well, for 2 years, they didn't do that, and I didn't find out about it. So I'm 2 years into it and $400,000 into a corporate care program that I had paid for, that the company I paid it to didn't pay it on to Rolls-Royce. So I ended up without the corporate care program on the plane. It still does not have the corporate care program on the plane. When the assessor makes an evaluation on most of the planes, they have that. On my plane, they do not have that. And it's my understanding that the assessor looks at that and says the value of the plane is reduced by some amount because you do not have corporate care on the plane. So every year, they value it as if I had corporate care on the plane. Every year I have to come in and talk to them, and they've acknowledged that they'll reduce that. That's on Exhibit A. I got a letter from one of the reductions. The board acknowledging a reduction on that year's tax evaluation from, I don't have the amount, but it was around $50,000 down to $1,500,000. That's from your board. That's Exhibit A on what I gave you. Oh, it was from $4,257,000. Yeah. I think. No, that wasn't. It was that's a different year. That's Exhibit B. It was about $52 million originally. They have that. Exhibit A on the exhibits that I gave you.
You gave me the yellow tabbed ones?
Oh, I'm sorry. I gave you the wrong ones then. Oh, I picked.
So you want the board?
Oh, wait. I picked up the wrong ones. I'm sorry. I sat them over here to give you, and then I picked up the wrong ones out of my file.
Okay, so you don't want the board to have those yet? Is that correct?
It doesn't matter to me. I don't care. It doesn't matter to me.
Okay, I'll go hand them out. That way the board has everything.
Okay.
So you don't have to worry about it.
I got that messed up. Okay. Exhibit 1, I numbered these differently, is a letter from Rolls-Royce stating that I've never had corporate care on the airplane.
So we're looking at the yellows, is that right?
Yes, we're looking at the yellows. Exhibit
Okay.
1 of the yellow.
Got it. Exhibit 1 in the yellows.
Sorry for the confusion.
That's okay.
Okay, so I've never had corporate care. Rolls-Royce acknowledges it. Number 2 is because your office has acknowledged that they give a deduction for that, and they have in the past, then the question came up of how much that deduction is and how it is arrived at. So your office asked me to get some proof on that. Exhibit 2 is a letter that I received from the sales manager in the West Coast from Rolls-Royce saying the buy-in to buy into the corporate program now is $3,544,000. Based on a minimum they have on this particular plane of 300 hours per year. Normal rate on that on each engine is $331.81. So I brought that into your office and showed it to your assessors, and they said they never heard of such a thing. They said they've never heard of a 300-hour minimum requirement. They only go by the rate of $331.81 per engine for the hours that are operated on the plane. And my hours on my plane are very, very low because I don't fly very much anymore. When I first got the plane, I used to fly about 200 hours a year. Now, because I have the plane and the home in Hawaii and in Coeur d'Alene, we usually only go to those two places, and we're only flying about 65 hours a year. So there's around 2,500 hours on the plane right now. And so when I told your office, when I gave them this letter, they said, well, that salesman might be a good friend of yours, and he might just be making something up to help you out. And I go, I don't even know this guy. I've never met him, and this is what Rolls-Royce says, and that's what it is. So they asked me for more proof of something in Rolls-Royce's writing, not a letter from a person, but in their writing that states that there is minimum hours required per year on their corporate care program, because most planes lease out and they fly a lot of hours. But some planes, like myself, I don't lease my plane out. I only use it myself, and we have very minimal hours. So Exhibit 3, they sent me from Rolls-Royce. I highlighted the area that pertains to this. It says there's a minimal annual utilization requirement. Oh, it asks the question if there is. The answer is yes. Corporate care assumes that operators will accumulate a minimum annual utilization of engine hours per year depending on the engine type and the maintenance program. So I brought this into your assessor's office, and I showed it to the assessor, and they said that's not good enough. It doesn't say what the minimum is. So I went to Rolls-Royce back in Washington, D.C., I think it is, New York or Washington, let's see. I'm not sure where it is. And I asked them how I can verify. The assessor still doesn't accept the fact that there's a minimum of 300 hours per year charged to be in the program. And I said they want to see something in writing. What does Rolls-Royce have in writing? And the person that I talked to here said, I'll do you one better. The assessor's office uses a airplane blue book to assess values of the planes. And he says, I'll send you a copy of the page of the blue book that explains it. So he sent me a copy of the cover of the blue book to prove that the page came out of the blue book, which is Exhibit 4.
You're on Exhibit 4.
Exhibit 4?
Mm-hmm.
And that's on the letter, on the inside of that letter attached to it, there's a picture of the cover of the aircraft blue book.
Yeah.
For the year 2018. And on Exhibit 5, he sent me a copy of the blue book that your office and Rolls-Royce told me you used to determine the evaluation on the planes. And under my engine type, AE 307C/71/ looks like C2. The top line is the United States of America and Mexico, Canada and Mexico. And the first line that I highlighted there is
minimum 300 hours per year. It's based on 300 hours per year. That's what Rolls-Royce charges you. So then, somewhere along the years of dealing with the assessor's office here, I was looking through my files and I found an exhibit that I have as Exhibit 6 here, and it had a statement on the bottom of the page because the assessor's office told me they'd never heard of anything like that 300-hour minimum, and they're not going to accept that value for the reduction of the plane hours. So I took this Board of Equalization statement that I had received in the past, highlighted the bottom part of it, and asked the board that they take consideration of that. Is there any questions from the board about anything?
Is that all the information related to valuation?
Pretty much. The other one might go into it a little bit, but pretty much that's it.
And does your application state what you think the value?
Well, I didn't have
is?
this information when I put the application together. So I think I don't have that in front of me. I think I put an evaluation of $500,000. The board has come with $1,300,000. I mean, when you take the $3,500,000 off the evaluation of the plane, it comes down to zero. And the board doesn't like that because they think the plane is worth something. But my opinion on that is that the plane is controlled by the FAA as far as maintenance. I don't control the maintenance on the plane. They have rules that I have to bring it in every month. I have to do this and this and this and this. One of the requirements is when the engines get up to, I believe it's around 4,000 hours, you have to rebuild the complete engines. They're approximately $2 million a piece to rebuild those engines, and that's why Rolls-Royce charges the amount of money that they charge for their maintenance program, because it's a lot of money to do all this stuff. And in trying to sell the plane, if I tried to sell it, which I've looked at recently because my business is almost going broke now after 50 years of being in business, it's not worth hardly anything because I don't have the corporate care program on it. And it has such a debt-ridden maintenance on top of it. Just this last year, I had an engine go out, a laptop computer. They were talking off in San Diego to come pick me up here, and an engine went out, and they had emergency land, and they had a fuel pump go out, and they had a laptop computer go out. They wanted $500,000 for the laptop computer. They wanted $250,000 for the fuel pump that went out. So that's why people carry these corporate programs to take care of those kind of costs. And I didn't have the money. The plane sat for 4 months in San Diego while I was searching around to get around Rolls-Royce and their high costs, and I ended up getting it from a secondhand dealer someplace. I think I paid about $200,000 to get that work done instead of paying $750,000 that Rolls-Royce wanted. So that's all I know on that part. The next part, if you have any questions.
Yeah, we'll just wait for you to finish submitting any information you have related to the value.
That's all the next part with the penalty might touch on the value, but that's most of the presentation on the value.
Okay. So then we'll go to questions from the assessor to the applicant.
Good afternoon, Efren Ascora with the Assessor's Office. Thank you, Mr. Flannery, for your presentation, and also for providing us with information about your opinion of value and how you are approaching the issue that we're discussing here today. I know you mentioned it earlier, but could you please remind us why the corporate care but you couldn't purchase the corporate care program when you first purchased the aircraft. Can you please, remind us of?
Yeah, sure, no problem.
Thank you.
Originally, when I bought the plane, like I said, they asked me what my mission was when I was looking at buying the plane, because I didn't know anything about planes. I know they had engines, wings, and that was about it. So they asked me what my mission was, and I said to fly to Hawaii. And they said, well, if that's your mission, we only have one plane that we built that'll go that far because it's the longest nonstop flight in the world, where you get halfway there and you can't turn around and go to some other landing spot. So I ended up buying that plane because I wanted to build a home in Hawaii, which I eventually did. And I didn't know anything about it. And so I talked to Cessna, and I said, how do I deal with this? I don't know anything about pilots or corporate care or anything else. And they recommended a person that was taking care of Qualcomm's planes, management company, and they recommended that I hire him, and I did. And I used him for 2 years, and I paid him every month for the pilots and the insurance for the pilots and the hotels where we flew and everything. And he billed me once a month. Well, he didn't take that money and pay it into this corporate care program. He pocketed it. And I didn't know that for 2 years until I talked to Cessna, and they wanted to know why I didn't have corporate care on the plane. And I go, I do have corporate care on the plane. They said, no, you don't. And so that's how I found out that he had been pocketing the money.
Thank you, Mr. Flannery. By any chance, do you file a lawsuit against this company? Or?
I did. It went to arbitration, and there was a lot of other factors involved, and it didn't end up that well for me. But he did the same thing with Qualcomm, and Qualcomm sued him and put him in jail. He was taking care of 2 of their Citation 10s.
And then after this period of time passed, the 2 years, once you were aware of the situation and the issue with the corporate care, did you make any attempt to purchase into the program from following a different company or?
I tried to deal with Cessna Aircraft to have them be somewhat responsible for the 2 years that I had paid, because they waited 2 years before they told me they weren't getting their money, and they wouldn't accept that. So I never purchased a corporate care program from anybody else. No. The only only one I know of that you can purchase it from is Rolls-Royce. You can either go, I found out later, you can either go direct to Rolls-Royce, or you can purchase it through Cessna, who I purchased the plane for, and they build the plane, and they have the Rolls-Royce engines on the plane.
Okay, I'm sorry, I wasn't. So you did make the attempt to go through?
I did try to, yes.
Cessna, but they turned you down, or they?
They said the money I paid was lost, and they weren't having any responsibility for it, and I'd have to repay it, start all over. And I didn't choose to do that at the time. I didn't realize how much all this was going to cost, and I didn't know whatever. I'm 80 years old now, and I didn't know how long I was going to live to be able to have to pay all these costs anyway.
Okay.
Mr. Flannery, the maintenance service program, once paid, does that cover the plane for its total life?
It's charged every year, so you can continue the program every year. And I believe in the papers that they sent me, where I highlighted the yellow lines there at the bottom that explain the program, I think they say if you sell the plane, the new owner can also continue that program. I believe that's what it said.
And the program covers the plane from nose to tail, correct?
No, it does not.
What doesn't it cover?
It doesn't cover anything on the plane. It only covers the Rolls-Royce engines. The program you have listed there only covers the Rolls-Royce engines. Cessna also sells another program called Power by the, no, it's not Power, this is Power by the Hour. It's called, I forget what it's called, but they charge you another $72 an hour on top of the $300 and some dollars an hour to buy what's not covered outside of the engines, or outside of the engines. And that's not included in any of these figures I gave you.
Okay, how much does a Rolls-Royce engine cost?
I don't know. It costs almost $2 million to rebuild. I have no idea how much it costs. These engines are the biggest. This plane is the highest flying, fastest non-military jet in the world at the time I purchased it. These are the largest engines on any corporate plane in the United States. Flies at 92% the speed of sound, and they're big, powerful engines.
Have you had any work done by Rolls-Royce?
No.
And the reason is because cost?
Because I have maintenance companies that I take it to that do all the monthly maintenance on the plane, and the person that does it worked for Cessna for 30 years, and so I find that he runs a company in Santa Barbara. He used to be here in Ventura that does wonderful maintenance at less costs. And on top of it, I don't have to take it back east or to some repair center. It's right here in Santa Barbara, and it's much more efficient.
With you not utilizing Rolls-Royce, their care program, their mechanics, the cost of the program, although, and I'm not going to say not expensive, 3.5 or whatever the number was. The plane is how old? How many years?
The plane is 18 and a half years old. I bought the plane in 2000.
And I'm just trying to wrap my head around getting a quote from Rolls-Royce for their maintenance program and showing how cost prohibitive it is, and why the value of your plane should be lowered. Meanwhile, at no point, and you provided the letter, did you ever join Rolls-Royce and try to benefit from their expertise in keeping, I guess, the life of the plane going? Is there, again, I'm presuming it's just the cost that you're talking about that kept it going, or kept you from doing it, but at the same point, you continue to pump money, like you said, into an asset, and that's what we'll consider the plane, that you believe is zero or close to zero.
I didn't know what the plane was worth or what I always thought the policy costs the amount that's listed in your blue book times the hours that I flew the plane. That's what I always thought. And that's what you have always thought. And that's the way you've billed me in the past for it. But when you wouldn't believe me and you kept questioning me on getting information, I started digging into it. And when I called Rolls-Royce, and they said the best information you can get, even though your assessor's never heard of it, is the blue book that he uses to assess the plane. I had no idea they had a 3-hour minimum until 2 weeks ago when I dug into this. You know, it's like It's right there in your assessor's book. I'm not taking it from anyplace else.
So the maintenance program is something that they typically sell with new planes. Is that correct?
99.9% of the time, yes.
And when they transfer, they've got the Rolls-Royce seal of approval on it. And when you value a plane further on down the road and you look at the years of how old it is and how many miles are on the engine, one of the things that you're going to see typically is the service program. And that's going to factor into the value based on what you said that they transfer.
Well, you know, the service program is not controlled by Rolls-Royce or Cessna or me. It's controlled by the FAA. And the FAA has a computer schedule that they print out and give to my pilots, and they give to me, and everything that they require at a time that they required, or they ground the plane. So you have no control of what maintenance you do on the plane because it's all controlled by the FAA, not controlled by Rolls-Royce, not controlled by Cessna. They don't want planes falling out of the sky. They want and injuring other people. They set up the program for every type of plane that flies, and you have to go by their schedule.
Oh, okay, again, just why would you consider to continue to put money into an asset that you feel is worth nothing?
You know, I'm 80 years old. I worked hard to get a business started, and I have a wonderful life. I've been very, very fortunate. I continue to have cancer problems, and I'm trying to enjoy my life to the best of my ability.
If for some reason you decided to stay in Hawaii and sell the business, like you said, what price would you put on the plane?
You know, I still have the business. I print community newspapers, and the business grew and grew and grew for years, and it was one of the most fortunate things I ever did. But now with the internet, newspapers are not worth hardly anything, and my printing business has dropped down to 1/10 of what it used to be. I still own it. I don't work there. I haven't worked there for 20 years since I had the cancer, and I bought the plane. And the value of the plane is what is my comfort. Okay, it was a dream, something I did, I enjoy. I've saved enough money to be able to afford it, even though it's a stupid luxury that costs way too much money. I only have so many more years.
Okay, I understand that the business is, the print business is going down. I was just looking for a number that if you were going to put it on the market, what value you would.
Well, I have other letters from people when I started looking into this that I didn't bring today because I didn't think it mattered because of the numbers that are already here. They would put the plane on the market for, they say, somewhere around $1 million and hope to get something less than that. But I don't want to put it on the market.
All right, no further questions.
Okay, thanks. Any questions from the board to the applicant? I don't have any. Okay, thank you. Let's go to the assessor's presentation.
The only other thing I would say is my eyes drain all the time because they took out this whole part of my face, and I always am wiping my eyes. Okay.
Okay, no problem.
Okay. Done with that. Oh, assessors.
Okay, Mr. Horn, go ahead whenever you're ready.
Again, good afternoon. Efren Ascora with the Assessor's Office. Again, in regards of the declining value, if you turn to the Exhibit A, which is what you have in front of you, a typical procedure for the appeals, for the applicants, is to request documentation via 441 dealer that we mail to all applicants across the county, across the nation. And Mr. Flannery was kind enough to provide us with copies of his aircraft logs, his expenses, and he did provide us with an email from the Rolls-Royce representative regarding a proposal to purchase into the aircraft corporate care maintenance program. He also provided a copy of a VREF aircraft guide for 2017, for December 31st, 2017. He provided that as well, you know, to help him to support his opinion of value. Okay. It is my understanding of just by reading the application that he initially filed is that for lien date 2017, his opinion of value was about $1 million. Okay. There was no indication that a component for sales tax was added or a 10% penalty was included just for not filing an aircraft property statement timely for lien date 2017. Okay, so the aircraft logs did show airframe hours being low at 2,425, you know, as of lien date 2017. The average airframe hours for a similar aircraft are 6,800, according to the VREF guide. Okay, the VREF guide is a guide that we could use to value aircraft, but the Assessor's Office has that option to using that. If you turn to Exhibit B, I have included a copy of the Exhibit B.
Hang on. Or Brenton, Efren.
Oh, sorry.
Here, let's just, you know what? Let's just do all of these instead of doing piecemeal. As B. Oh. It's E. No, you can just load them up. That'll keep you in your seat. No, I'm talking about him, not him. Because he didn't file a property tax statement.
Okay, if you turn to Exhibit B, I have included pages from the Aircraft Blue Book, which is the other guide that the Assessor's Office uses to value aircraft. And then you flip that page, you will see the VREF a copy of the VREF calculations. The VREF guide shows a retail value for the subject aircraft of $3.4 million. The aircraft blue book shows a retail value of $4 million. If you turn to Exhibit A, which is the one that we're looking at, to page 8 and page 9, you will see copies of the VREF guide showing, proving what I was mentioning. In our calculations, we are required to add a component for sales tax in consistency with the Revenue and Taxation Code, Section 110, Rule 10, and the court case Xerox versus County of Orange, which we usually present that every time there is a valuation for aircraft or boats or personal property. We are required to add a component of sales tax. Also, the taxpayer did not file an aircraft property statement for lien date 2017. Since the cost of the plane was well over $100,000 per Revenue and Taxation Code 441 and 463, we were required to add a 10% penalty as well to the assessment. We cannot circumvent that. We have to add it. So the assessor came out with a range of value for lien date 2017 of $1.28 million to $2,089,000, for the subject, for the aircraft. Again, with these values were calculated based on information from the VREF guide and the aircraft blue book guides, and the information that Mr. Flannery provided with his logs. Okay, and you can see in page 2 of my presentation that how we compare both ranges for value. In regards of the value guides used, again, we use it in compliance with Section 5364 that, the board has approved the Aircraft Blue Book Price Digest as a primary guide for valuing general aircraft, and the VREF aircraft value reference as an alternate for aircraft not listed in the Aircraft Blue Book. We use the winter edition, which is the closest one to the lien date 2017. And however, the assessor took a more conservative approach when looking at both guides. For lien date 2017, in spite of this aircraft being listed in the Aircraft Blue Book, we did consider the VREF guide as a conservative method, to value the subject aircraft. Again, we were required to add a component for sales tax, and I just mentioned the Revenue and Taxation Code, Section 110, full cash value or fair market value means that the amount of cash of its equivalent that property would bring if exposed on the open market on conditions which neither buyer nor seller could take advantage of the exigencies of the other. Property Tax Rule 10 delves more into the component of sales tax. If you go to page 3, the second paragraph, it says full economic cost, which is replacement of reproduction cost, includes costs typically incurred in bringing the property to a finished state, including labor, materials, freight, or shipping costs, installation costs, and there it is, the sales and use tax that we're required to add, and additions for market-supported entrepreneurial services. Okay? The Assessor's Handbook 577, which is the one that pertains to the evaluation of aircraft, talks about the requirement of a sales tax. It mentions that it's not included in the VREF or the Aircraft Blue Book guides. It's not included. We have to include it. And again, this statement is based and supported by Xerox versus County of Orange County. So we ended up applying or adding a 7.25% of sales tax to this component, to this aircraft. And this is everything that I just mentioned pertains to the valuation issue that Mr. Flannery wanted to dispute today. We do have a section that talks about a penalty, but I wanted to make a pause in case Mr. Flannery or the board has any questions.
So the $1,281,000 is the new assessed value that you want to charge me now instead of the original value?
Well, yeah, what happened is that since there is another issue that is being disputed here, which is a 10% penalty. Okay, I didn't go to the bottom of this, to finalize this valuation. But in the end, after we discussed the issue of the penalty, the 10% penalty, then yeah, in the end it will be about $1.28 million.
Why is the original bill every year sent out at over $4 million?
I'm sorry, can you repeat that?
Why is the original bill each year sent out at over $4 million? I have to appeal it to get it back down to this number. That's what I don't understand.
You're talking about the annual assessment? The annual assessment that it goes into your tax bill?
Yes, the tax bill you send me.
Yeah. Yes. Well, the assessor's office has different sections. Right now, I'm with the appeals section. We handle under our management all the appeals as they're filed with us. We ourselves have no control on the annual assessments that are prepared by a different section. They're the personal property section or business division. They handle all of the personal property and trade fixtures assessment, and that includes the aircraft, jet skis, boats, yachts, all of those type of property. They're being handled by the business division, specifically by the Marine and Aircraft Division. So they have a different management, they're different executive management. So I'm not saying that they don't look into their paperwork, but sometimes as appraisers, there could be some disagreements of opinion. Okay, as far as I know, this is the first time that we that I know that we come to an appeal discussion in front of the board for this particular aircraft. So I don't know that they will have any other information from us from the appeal section because there is no resolution, there is no stipulation yet. So I don't see what other information they could follow. That question we could probably answer better by management or by the lead appraiser on that section, because once again they're the ones who prepare the annual assessments. We don't prepare any assessments annually. We just come and review the information that you give us, and then if there is a possibility of get to an agreement, we'll do that. If there is still discrepancies, then we come here to the board that we discuss about it. But once again, the annual assessments that are prepared by the different sections, they're sent to the information is sent to the to the auditor controller, then to the tax collector, and they're the ones who send you your tax bill.
So what is the value you're recommending the board find?
Well, at the end of the presentation, or right now, yes, it's $1,281,000. $1,281,000. That's the value that we have. But I haven't gotten into finalize that yet because there is the issue of the penalty that I haven't explained yet. I just made a pause here just to answer questions.
Go ahead and just keep going.
Okay. So, do you want me to continue with the 10% penalty?
Can I respond to that?
If you have a question based on what he's presented.
Yeah. The thing I don't understand is last year we went through this same thing. And not the people that send me the tax bill, but your office. And they reduced the value of the plane that year down to $1,500,000 from $52 million. So I don't understand, and I have 2 more years coming up after this where they valued the plane between $40 and $50 million. So I don't understand why every year I have to come back and go through this. I don't understand it.
I'm sorry. Like I said, this is the first appeal that I'm handling. I wasn't sure. You're talking about year 2016, or
they reduced the value from $40 or $50 million to $1.5 million your assessor's office, your predecessor. Every year I deal with a different person in your office. I don't understand it.
Yeah,
It's inefficient for you, the board, for me.
Maybe that's something that could be discussed once we're done today. It does sound unusual. But in terms of moving forward, I think we should get through this presentation. It's a good question from my perspective. But why don't we just keep moving forward with today, and then maybe that could be investigated afterward.
All right. So I'm going to comment on that, the addition of that 10% penalty. Okay. So Revenue and Taxation Code 441 talks about the requirement that each person owning taxable personal property.
Hold on one second.
Sure.
Before we move on to that phase, because that's a different phase, I had a question for him on what he was stating about the value of the plane. Can I do that later, or should I do it before we move to the?
Okay, thank you. So the rest of your presentation is just related to a penalty, is that correct?
That 10% penalty, yes.
Okay. So, Mr. Vlahakis, when we started talking about this, we talked about a separation of valuation and penalty, or is it all just one?
Yeah,
we're not making two different decisions, right?
Yes and no. They are separate issues, so you can make a decision all at once, I guess. You're going to decide what the market value of the property is, and then whether or not to include a 10% penalty, which if you include the penalty, it just is whatever the assessed value, market value you determine is plus a 10%. So it can go, the difference is the burden of proof on the value, the applicant had the burden of proof on the penalty. The burden of proof starts with the assessor, and then then it switches to the applicant to overcome. Whenever there's a penalty, it's a moving burden of proof. So that's the main difference.
Okay, Mr. Flannery, if you have a question related to the valuation, go ahead.
Okay, my question is, you use Rolls-Royce's number of 331, whatever it was, per hour for each engine. But right in the same blue book that you get that number from, it says that there's a minimum of 300 flight hours per year to that cost. I don't understand why you don't use that section of the blue book when you use the section for the hourly rate. I don't understand it.
Can you point, are you looking at your presentation, the page?
Yes, Exhibit 5 on the yellow pages.
Yes. So when the assessor's office looks at this at a corporate care, we understand that there are different markets for aircraft, meaning that it was the intention for a typical buyer of this aircraft to purchase, just like Mr. Flannery said, the corporate care program for a brand new plane. Okay, a brand new plane is going to cost more than the $5 million or $4 million that the VRF guide gives you for a retail price. The price, if I'm not mistaken, it would be between $15 or $14 million. So when they add the maintenance program, it makes sense to purchase into that program and spend that amount of money for a brand new aircraft. Whereas Whereas Rolls-Royce is offering you an estimate to buy into this program, which it is my understanding that it hasn't been an attempt to purchase into this program. Mr. Flannery hasn't made an attempt to buy it because it's not cost effective. The aircraft is 18 years old. It's not a typical purchase. They wouldn't, for an old aircraft, you wouldn't purchase that corporate care program. Is more expensive, and it is not, once again, it's not your typical buyer. If we take into consideration that reduction that of 3.4 or $5 million that the corporate care program is charging into this, and you compare to what the VRF guide says as far as the value of the aircraft goes, we come up with almost like with a zero value, and we do understand that the aircraft doesn't have a zero value. We understand that the aircraft is being used, being flown, and it still has a value that is not zero.
Okay.
Sometimes these calculations may come up even negative, but as far as market value goes, those deductions we cannot make. There's no zero value or even a negative value. I don't remember that this was the case, but as far as market value goes, so market that doesn't exist. There should be some value to the aircraft.
I don't understand. The answer to the question was why, if you use the per hourly rate listed in the Blue Book for the hours charged, which you do, and you say there's a deduction for that, why don't you use the same information that says it's required a minimum of 300 hours per year when Rolls-Royce gave me a quote to buy into the program based on that rate? I don't understand. Why don't you use both? Why do you pick one and then apply it to something that doesn't apply?
Well, there we go. In reference to the Rolls-Royce, that doesn't apply because you're not enrolled in the program. So an argument could be made that way as well.
But I don't understand. The Blue Book says that that's the requirement. You use one, I don't understand. You use one part of your manual you use, and you don't use the next line in the manual. I don't understand it.
It's because it doesn't make sense to have a negative value on a plane, on an asset that is still functioning. If we did a calculation and came up with a minus $1 million, you're not going to run out and pay someone $1 million to take the plane off your hand.
Okay, I think we understand the information submitted and the answers given. We have enough when we are in our deliberations to.
Okay, the last thing I'll say on this line is, I understand their argument that the plane should be worth something, but at some point it's going to cost me way more money to keep the plane than what the value of the plane is. I mean, so I just don't understand why they don't use both values. And I tried to make some compromise in between, because there must be some value today, even though it's going to cost me way more in the future, and they wouldn't budge on the compromise. So that's.
Will you accept that $1,281,000 that they're offering today?
No, I won't, because I think there's a minimum on the hours, and I think it's worth less than that. And on top of it, I don't accept the principle of the penalty also, but we'll get into that.
Okay, let's move forward with whatever other information the assessor has, and then we'll wrap it up.
Just for clarification purposes, if we're done with the valuation portion, we'll move on to the penalty? Okay.
Basically, the assessor's office is required to apply or to follow the property tax rules and the revenue and taxation code, specifically sections 441 that talks about the requirement for all property that has an aggregate cost of $100,000 or more. Whoever owns or possesses this type of property, tangible personal property or aircraft, in this case, they're required to file aircraft property statement in this case. Failure of the assessor to request or secure the property statement does not render any assessment invalid. The assessor has to add a penalty, and the applicants or the taxpayers are required to file. If you go to in page 3 of my presentation, letter B, the property statement shall be declared to be true under penalty of perjury and filed annually with the assessor. And it gives you the penalty provided by Section 463 applies to property statements. If you flip to page 4, and you look at Exhibit C, Exhibit C. This is a copy of a memo that I believe was done for this case like this one. Maybe that's the one case that Mr. Flannery is referring to. Years ago, it talks about how he appealed the 10% penalty again for back in year 2010, 2011, and that's true. That was probably my predecessor that handled that case. If you see one of the previous assistant county counsel ruled or made a recommendation in regards to this hearing, when specifically talks about the 10% penalty. So we do believe that the applicant was aware of the requirement because there had been an appeal previously for the same type of property. So there was knowledge about how there was a requirement to file an aircraft property statement. Furthermore, per annotation 100.0040, the taxpayer has a responsibility to file a signed property statement with the assessor, regardless of whether the assessor makes a request for such a statement, and that's annotation 100.0040. The State Board of Equalization has found that even if the taxpayer is unaware of a filing requirement, ignorance of the law is not an excuse for failing to file a timely return. In consequence, the assessor's addition of the 10% penalty was done in conformity with property tax law. Talk about Revenue and Taxation Code 405. The assessor shall assess all taxable property in his county to the person owning, claiming, possessing, or controlling it on the lien date. Again, California government sections talk about how there's a requirement for courts to apply and enforce compliance with property tax rules. So the assessor's office cannot abate that penalty. We are required to add it, even if the taxpayer was unaware of the requirement, although, once again, based on the previous case that was brought before back in 2011, again, this is Exhibit C, we do believe that the applicant had a knowledge that there was a requirement to file a property statement. And that's concludes my presentation in regards to the 10% penalty.
Okay, and Mr. Flannery, did you have an additional exhibit? Is that the blue tabs related to the penalty?
I do, yeah.
Why don't we go ahead and, let's see. Before we do that, let's go through any questions that you or the board has based on that section of what the assessor just talked about regarding the penalties. Do you have questions related to that?
I have questions of him, but whether you want me to explain my view of it or ask him about it directly, I don't know.
I guess, why
don't we go forward, and then if I have questions, can I ask him?
That's fine.
Okay, so the way this comes down every year is I get the bill, and it's the same as it has been for all the previous years. Then I come in and I discuss, this is the first year I've dealt with Efren, but every year there's a different person than previous years. So he is right that when we took over the management of the plane in my office, rather than hiring a professional to do it, we weren't aware of that statement. I came in front of the board and I presented for a reduction of value and explained the penalty. And the board was kind enough to listen to me and deduct the penalty from that year. And I became very, very aware of that form that comes out every year. And I went to my office and I told the people in my bookkeeping department to get all my mail. My office is in Silmar, California. I don't go there much anymore. I told them, make sure you do this every year, every year, every year. So I come and have a meeting with the guys about this year, about the value of the plane, and they say, oh, by the way, you didn't file the statement for this year also, so there's going to be a penalty. And I go, you got to be kidding me. So I went to my office, and I about killed the people at my office, and they swore that they didn't get a statement. They filled it out every single year and turned it in every single year. So then I come back, and after talking to my office, I come back and I talk to Efren and Jesse Metcalf, who I've dealt with every year, who's a wonderful person, about this. And in the meeting, Jesse said to me, well, you know, if you've checked and your people say they didn't get it, I remember there were some glitches in the computer system this year, and maybe it didn't get sent out. So he said, let me check, and we'll check and see what happens. So I come back for another meeting with Efren and Jesse, and they tell me that there was a mistake in the office, and they didn't send the statement out. But then Efren tells me, well, it doesn't matter anyway, because it's your responsibility to come in and get the statement and fill it out if we don't send it to you. And I go, but every year in the past years, since we did this before, you've sent it to my office and we fill it out. It didn't come that year, and I didn't know anything about it, and I didn't know that I was supposed to come in and get a statement to fill out if you don't send them to me, because you should send them to me every year, and we'd fill them out every year. So that's what happened as far as, and yeah, that's what happened. They didn't send it out, and they've acknowledged that. So then the next thing here in the exhibits is Exhibit A here. It said these might kind of go together. Is the one I started to explain before. It's a value from last year's statement where they went from $40-some million to, or $52 million down to an adjusted amount of $1.5 million. That's Exhibit A. Exhibit B is another year that they sent out a tax statement for, oh, this one's a funny one. This one's maybe why they didn't send out this statement to me, because I think this is the year that they missed sending me a bill. So I not only didn't get the statement, but I didn't get the bill for it. And that one they assessed again. They sent me an escape. Yeah, that's right, because they just sent this to me on May 14th of this year for a tax year of 2016. Because that's the same year they didn't send me the notice to fill out that they want to penalize me for now. So they've gone back and retaxed me because I brought up not getting the statement to fill out. Then when they went back in and looked into the records, they forgot to send me the total tax bill for that year. So then this is another year of tax bills where they assessed me for $44,985. And then this is a bill when they assessed me for $52,770,000. $52,700,000. No, I don't know. Oh, that's not right. I can't even read that. $5,277,000. No, that's not right. It's $52 million. That's what they assessed me for that year. And then the last exhibit is something that I found someplace, I don't know, about the penalty. Oh, yeah, this is the one that says that if I failed to file the paperwork that they wanted, that failure to file statement was due to reasonable cause and not willful neglect, that the board could abate the penalty. And I didn't willfully neglect anything. We tried to follow every rule that you have, and I sent them in every one of the previous years after I found out about it. That's all I have.
Okay. So let's see. I want to go back to make sure that we have questions asked of the assessor based on the penalty portion, which we didn't get to for either the board or from the applicant. Mr. Flannery, do you have any questions from the assessor's presentation, the second part about penalties?
I guess I would just ask why you sent it out every year except that 1 year. And do you acknowledge that you didn't send it out that year?
Mr. Flannery, did you inform Jesse Metcalf that you were changing the situs of your plane from Ventura County down to San Diego County?
No, I didn't do that. I didn't. I never did that. I mean, I never told anybody that I was changing the location of my plane to San Diego. I did say I was changing it to Maui, Hawaii, where I have a home there, and we argued over that. It cost me $35,000 in attorney's fees to present my side of that argument to you. You presented your side, and I decided that it was costing me so much money in attorney's fees that it wasn't worth pursuing him saying that he was right and you saying he was not right. And I was caught in the middle of it.
I think the original question was just related to the all of the applicants' exhibits in Exhibit 2 with the blue tabs related to whether or not there was a notice sent out.
Yeah. I apologize, Chair. It was a question answering a question. It's my understanding that our office was notified that there was going to be a change of situs for the plane from Ventura County to another county. So we took it off our books. When we take it off our books, we don't send out a property statement. It's my understanding that we sent notification down to another county. That county never received a property statement and kicked it back to us, which is part of the reason why there may have been a lag for the 2017. This really does address the 2016, but there was a residual ripple effect into 2017.
Okay.
I don't believe you're right on your statements. At 1 year, I was having some maintenance done in San Diego, and they assumed that I had moved the plane out of the county to San Diego. I never put any paperwork in that said that, but they assumed that. So they sent it to San Diego. And San Diego called me back, and I explained to them the plane was only there for like a month or two doing maintenance on it, and they washed their hands of the thing. I didn't know that any communications had gone further than that. One of the previous years, I did try to transfer the plane's tax base to Maui, Hawaii, because my attorney argues that it's taxed on where the plane is on January 1st.
Okay.
Every year I go to Hawaii in December and I stay for the month of January there. So the plane's always there in January. So my attorney's opinion was that Ventura had no right to tax me anymore. We came in and had a meeting with them, and they said no, because you have a business here and you have a home in LA County also, that you spend part of the time there. Your main residence is here, and we're going to keep the assessment, even though the plane isn't here.
Okay, thank you. Do you have any other questions related to what they presented?
Not that I know of. I just don't feel the penalty's fair, that's all.
Okay. Questions from the board to the assessor on the penalty phase? Okay. So now let's see, are there any questions from the assessor to the applicant based on his presentation related to penalties?
No questions.
Okay. And from the board to the applicant? Okay. I have one question, and it really could be for either, but for the personal property taxes or the unsecured taxes related to the year when the penalty was the tax paid, or is it still not paid? There's a penalty.
The penalty was in regards to the statement not being filed. Whether or not the applicant has stayed current on taxes, I cannot tell you.
Okay, I understand.
I can tell you, and I'd like to, because when I had a meeting with Jesse, the previous time this happened, I paid the full amount, okay? And then when they changed the amount, I got a rebate for it. But it took me about almost a year to get that rebate. So this year when I went in to talk to them about this situation again, Jesse says there won't be any penalties if you don't pay the full amount because it's the assessor's mistake for assessing you the 52 million. It's their mistake, and so when they changed the assessment, I wouldn't know any penalties on that. So I did not pay those taxes yet. I will pay, but I didn't because I was informed by your office that I didn't have to because it was their mistake on the assessment.
Okay, thank you. So I think we're all done with questions, so let's end with just a closing summary, if any, from the assessor, and then we'll end with the applicant.
Okay, just for the record, the assessor never assessed the applicant $52 million.
I think we understand that it was $5 million.
There was a decimal.
It does look funny on the form. I think everybody's on the same page.
For people watching and listening, I really need to make that clear.
Okay. If that, Mr. Horn, if that's the case, then why don't you clarify what you're talking about and what the correct number is?
The number I believe the applicant was talking about was the total tax due on a on a 2018-2019 secured tax bill or unsecured tax bill of $52,773.02 was the amount that was due. And that was
based on the value of what?
That was based on the value of $4,257,000.
Okay, thank you.
Okay. The assessor does take into consideration the maintenance service program, and it's a far easier calculation when it's actually attached to the plane instead of having to make an adjustment. Mr. Ascar went through the VREF and provided his analysis and his appraisal, making the proper adjustments, taking into consideration in essence, prorated portion of the maintenance service plan. The said plan, as the applicant provided documentation for, it's never been enrolled. It's good enough to bring in front of the board as a logical deduction, but it was never good enough to go back and enroll this on the subject property. We've tried to adjust for market conditions for hours on engines and what have you. And with regards to the penalty, the applicant has stood in front of this board before and requested a statement or a penalty be abated, and the board complied and was happy to do so, and that's fine. But Mr. Ascar provided citations that said it's the owner's responsibility to file the paperwork, and it shouldn't be contingent upon whether or not the assessor sends out a statement. Thank you.
Okay, and any closing summary, Mr. Flannery?
I guess the only summary would be I presented the facts on the value. They're in their assessor's blue book. The board has to make a decision on whether that should be taken into consideration or not. I can't do any more than present it. I had no idea about that in the past until we brought it up this year, and Jesse Metcalf kept asking me for more information to support those figures, and that's how I found out about it. I didn't know it in previous years, or I would have brought it up then. On the penalty phase, I've explained to you, I didn't get the thing. They acknowledged I didn't get it. Then they brought up a part that I'm supposed to find out about it. And the only thing I can say is the Board of Equalization, I presented on Exhibit 6, says that the Appeals Board has an opportunity to look at the facts and make a judgment in their mind whether it's fair or not fair, whether it's willful neglect or whatever it says here. I didn't know, or I would have done it. I'd done it every year previously, and I did it again on the 2 years after this. That's all I have.
Okay, thank you. So we'll close this hearing to public testimony, and the board will be deliberating later. And Mr. Flannery, you'll be able to either check in and inquire about a decision, or a minute order will be sent out as soon as we make a decision. And then findings of fact, I believe, will be prepared as well and submitted. So thank you for your time. Thank you.
Thank you very much. I didn't understand when you thought that might be prepared.
In terms of a decision, depends on the rest of our day today, whether we'll be able to deliberate today or if we have to schedule a different day for deliberations. But immediately after that, a minute order would be sent out with the decision.
So is that, if it isn't today, is that a month or 2 months from now or a week from now?
If it weren't today, I would guess it would be sometime within the next month or two. It depends on when we can all get together.
Okay,
so it's a hard one to answer.
Thank you for your time. I appreciate it.
Okay, thanks.
Sorry for being kind of disjointed, but it's not my normal work. I
Understand.
Ran printing presses.
I understand. Thank you. Okay. Mr. Vlahakis, we have, looks like next, number 86, is that correct?
That's correct. That's what I have.
Okay, and we'll, while we're getting ready, we'll take a 5-minute recess. So item 86 is next, application 1710727, Atzinger Aviation LLC.
The only other thing I would say on the way out is, even though we used to be a lot, their people have always been very nice to me.
That's right.
I see a lot of mistakes. They're very nice.
So we're in recess?
Yeah, 5 minutes. Okay. Okay, we're back. It's 10 after 3, and we're hearing item 86 on the agenda, application 1710727. Applicant is Atzinger Aviation LLC. And this is an application related to an aircraft decline in value. So why don't we start again? Oh, by the way, we've received a packet from the applicant. We'll call applicant's Exhibit 1. And let's start with a real brief overview of the application, please, from the assessor, and then we'll determine how to move forward.
Good afternoon. This is Efren Ascora with the Assessor's Office. The subject is a 1982 Gulfstream 3 jet aircraft. It was used as a charter during the calendar year 2016. The applicant is appealing Lynn Day 2017. it was chartered over 51% of its flight hours. So it met the test that it's conducted to verify that it was in fact, a charter plane, was a common carrier. And then that way, when we do the evaluation, I'm not going to jump into that, but pretty much what it means is that we're not required to add a component of a sales tax for the evaluation because it was being chartered, by the applicant.
Okay, and is it my understanding is that this would be the burden of proof would be with the applicant? Is that the understanding of the assessor and the applicant?
The applicant originally appealed the regular enrollment for lien day 2017. So after that, there was a correction done to the roll when the assessor actually went back and lowered the original assessment, okay, via a correction. So, but the appeal is still active. So at this point of time, I guess since the application was filed based on the original enrolled value, I guess, yeah, the burden of approval lie with the applicant.
Okay, and applicant agrees with that? Yes. Okay, great. So then what we'll do is start with the applicant's presentation, go through the same process of asking questions from the assessor and the board, and then we'll hear the assessor's presentation and do the same. So whenever you're ready, and it is Mr. Maloney, is that right?
That's correct.
Go ahead and begin.
Thank you, Mr. Chairman, and let me apologize to the board in advance for bringing up another airplane with engines and overhaul cycles and lots of things that not too many people understand. However, having said that, just briefly on my background, because it's relevant to where I'm coming from with this presentation, is I'm a retired Navy pilot. I'm a retired commercial airline pilot. After getting out of flying, I took a job running a company that does nothing, or that did nothing but appraisals and valuations. So it's important to note that while I am not an accredited appraiser, I understand it as well as anybody in the building probably, and better than most, and I used to do this for a living. So I want to put that out, but again, I am not an accredited appraiser. You should have in your packets 3 sections with a top sheet, which is nothing more than a Excel spreadsheet printout here. I'm just going to walk through this item by item. You see on there an A, a B, and a C. We'll go through those 3 items, and I will be done. So item A, the base average value, which according to the Aircraft Blue Book, which is the standard that the county uses, if you go to the second page of this document, the big colorful one, right, the first one. Second page, there's a highlighted number, which is Q1 of 2017, corresponding to the lien date of January 1 of 2017, indicating a value of $550,000 as the base average value. If we take away the 10% state mandate, at that point, we are at a value of $495,000. Now, going back to the top sheet here, you can see that there are some adjustments for reading down the sheet: times and cycles, damage history, paint, interior. These are somewhat subjective, and because of the extremely low dollar value of these adjustments and the fact that if we could agree on everything else, I'm sure I could work out with the appraiser's office what those values really should be. I'm not going to touch on those because it's just not worth talking about for that small amount of money. But if we continue down now to the piece where it says maintenance due, we show a value of $1.9 million. So where does that number come from? In the second stapled together item in your packets, the proposal for Rolls-Royce engines from Dallas Airmotive is included in its entirety. If you look at what in your packet should be the last page next to B, you can see that that Dallas Aeromotive flat rate price per engine, which is the overhaul that is due, or that actually was due last month, I'm sorry, the month before last, August of 2018. The price to do that would be $975,000 per engine. Add those two together and you come up with a...
Can you clarify one more time what page?
Sure.
Which?
I am on it's page 5 of 6 of that packet from Dallas Aeromotive.
Got it.
And there should be a B at the bottom, sir, that says
Yep.
right next to the $975,000.
Thank you.
Okay. That is the price per engine to overhaul the engines that were on this aircraft. If you multiply that times 2, you get $1,950,000. Now, a lien date of January 1 of 2017 was 20 months prior to the date that the overhauls were due. So you have to prorate that number back to January 1 of 2017. And to do that, I took 220 months out of the 240-month overhaul cycle. It's every 20 years you do an overhaul on these engines. Every 10 years you do a midlife inspection on them. But this is a full overhaul that's due. And that's where I came up with the 92%, or $1,787,500 for engine maintenance due within 20 months of the lien date of January 1 of 2017. Below that, you can see also a number for $150,000. There was a 72-month inspection due in also in August of, in June of 2018. So by the same methodology, I took 54 months, out of the 72 months, and prorated that to 75%, percent, and came up with a number of $112,500. And if you add those two numbers together, that is where I came up with the $1,900,000 of maintenance due within 20 months of the lien date of January 1 of 2017. I hope that's clear, but because I understand it doesn't mean the rest of the world does. Okay, I'll continue on until you interrupt me then. The last thing that I have to show you is some simple looking papers. They are stapled together from a gentleman named Norm Hill Aviation. And you should also have behind that, there'll be a document where I did report, and that even though this is post lien date, it will become relevant momentarily. So just bear with me for a minute. Even though it is post the lien date, as of 26 September of 2017, this airplane was moved out to California City, and I think it's Riverside County, but don't hold me to that. It's out of Ventura County, certainly, and it is under consignment sale with Norm Hill to be parted out. So, coming back to my top page again, where the math all comes together nicely, I hope. If you do all the math and take all those adjustments into account, I end up with a negative value of $1,472,457. So, the point here is that, and I have had this discussion with Senior Appraiser DePoyen as well, is that it's still an asset. As we discussed in the last valuation discussion, there's got to be some value that you can put on something that is still flying and could theoretically generate cash. So in looking at that, what we did was the scrap value is really the only thing that we could, in good faith, assign to that aircraft value. Nobody is going to pay $550,000 for an airplane with $2 million worth of work on it. It makes no sense whatsoever. You can't get out from under that. There's no alternatives. The maintenance has to be done. As of August of this year, the airplane was essentially dead. But for scrap value, well, two things happened in 2017 that address the scrap value, which could theoretically be relevant on January 1 of 2017. Number one, we did try and sell the airplane. There were no takers. There was a couple of nibbles, a couple of people that may have had engines sitting in a warehouse someplace that could replace the engines without having to overhaul them. But no serious buyers emerged in the 9 months that we had it for sale. So the other thing that we did was we decided to actually scrap that airplane out. So we moved it on September 26th to the desert, and Mr. Norm Hill, who is in the parts consignment business, and Exhibit C, which is the one we talked about before, illustrates the amount of parts in, the last just about 1 year that have been sold off of that airplane to other G3 owners. If you do that math, it comes up to a fraction over $15,000, and the owner of the airplane gets 60% of that. So it's not a lot of money. There's not a lot of scrap value. I don't know, I have heard anecdotally, but cannot definitively prove that there are only approximately a dozen of these airplanes flying anywhere else in the world. So there is no market for it for sale. There is no scrap value because there's no airplanes that want the pieces that are on it. They have their own pieces. And in my opinion, per the appeal filed, the airplane has no value whatsoever and should be assessed as such.
Okay. Any other information?
No, sir.
Okay. Let's go to questions from the assessor to the applicant.
This document, the proposal contents,
Yes, sir.
the assessor hasn't seen this document. This is brand new to him today.
Okay, but the number has always been in the information that I've exchanged with Senior Appraiser Dupoyen as we've discussed this.
But this is information that substantiates that number and should have been disclosed.
Okay, well, I apologize, but it was never asked for. It was taken on faith that that was a correct number, and I provided the number and the calculation to the appraiser's office.
The assessor is asking for a continuance under 441H because we want to take a look at this.
Do you have a copy of your letter where you requested this specific document to provide the board?
The 441D letter?
Correct. Do you have?
I can rip it out of one of our exhibits. How many copies do you need? I can, do you just want to pass?
If the board wants to pass the letter to examine.
This is my day.
So to the assessor, what you're thinking as far as the continuation? Request for the continuation?
That's in date?
No, I mean just.
Why?
Yes.
Because you can give me a number and say, oh, well, I feel an adjustment should be made for this. And then when you've got something from Rolls-Royce, which is, as we saw in the last hearing, legitimate, it's something worth reviewing and considering. So
Yeah, I'm good.
under 441H, the assessor can ask for and will be granted a continuance based on the fact that there's new evidence that's being provided to the board to consider.
Mr. Chairman, if I may,
Go ahead.
this spreadsheet, the top sheet that you had in your packets, is what I provided to the assessor's office and Senior Appraiser Dupoyen as we've discussed this. The $2 million number for overhaul has been on the table for months. There's never been a request to justify that. It's not a surprise. It's not new information. It is now documented and verified as would be required for you folks that don't know anything about this case.
Thank you.
Any comments from the assessor?
Any further comment? No.
And for the benefit of the board, Mr. Horn, do you have 441H in front of you?
And I'll try to bring it up on the screens for everybody too.
I have a copy of it here, which I could share, but I just want to make sure we're all looking at the same thing.
Regular language, yeah. Yellow.
Since our legal counsel isn't here, I'll just take the role of reading this just so we have benefit of talking about it together. Under 441H, it says if a taxpayer fails to provide information to the assessor pursuant to subdivision D, which is the request letter, and introduces any requested materials or information at an assessment appeals hearing, assessor may request be granted continuance, et cetera. So looks like there are two tests here. Number one, that the taxpayer did not provide information to the assessor and introduces materials at the appeals board hearing. Looks like he provided the information but not the substantiation for the information and included that in the hearing. I'm not sure if that is exclusionary or not, or if that triggers 441H. Sounds like the assessor's opinion is that it does. Okay. And the applicant's opinion is that it does not?
Absolutely not, sir. Everything that I've just presented to you was in the hands of the appraisers.
And so so to the applicant, it sounds like the assessor's claim is that this packet is just being introduced today for the first time. Is that correct?
Yes, sir. In preparation for this, I obtained a written estimate of the work, so that wouldn't just be an opinion of value.
Okay. And so to the board, any comments in terms of interpretation?
I think the language is pretty clear that the assessor has been presented new evidence, and I think he should be granted the continuation.
Okay, Mr. Curtis.
Well, as the applicant said, I don't know if it's new information, it's just supporting documents. That said, it sounds like the assessor needs to rejigger his valuation. And I would leave it up to the chair to decide where we should go from here.
Okay, well, if we called our counsel to check it out, it would mean that we wouldn't get an immediate answer to begin with, right?
Correct.
Which might have the same effect. And so
right.
I would be okay with granting a continuance based on that, although I prefer not to, rather move forward.
I think in the past, with our counsel being here, what would happen is that if we're at this point, we would end up in a continuance anyway.
Yeah.
Understood, sir. If I may, I would like to respectfully request that I hear the assessor's case, because they've heard mine. Without hearing them, they're at distinct advantage at this point, so that I can properly prepare for the next hearing.
Understood.
I have a feeling the assessor probably doesn't want to.
2 points. The assessor's case may not be valid anymore based on the new information, so I'm sure as heck not going to proffer anything up to the board or submit evidence. based on the new information that I received, or the supporting documentation that I received. So I respectfully decline to enter any evidence into submission.
Understood. Based on that, unless are there other questions for the applicant or to the assessor from the board?
Well, I do think this
How
will.
long would it take you in your continuation to?
If the board wants to push this to December 3rd, I have no problem with that. If they prefer a different date, they can offer it up, but, it's not going to be within 15 minutes. I've got another 2 cases that are hanging out there today.
Understood. Okay.
And Efren's in one of them.
Understood. So, was there any other questions from the board to anyone? Okay, and 1 second, please.
Any other comment from the applicant?
Yes, sir. My question is there a formal protest regarding the procedures?
Well, my understanding is that you can certainly state that you object to a decision. However, I think the board has the authority to make the decision based on our experience and what the information that's presented to us. Mr. Vlahakis?
That is correct. At this point, the assessor has requested a continuance under section 441H. The board can grant that, or the board can disagree and deny it and move forward with the case. So that right now is that discussion. So that would be his opportunity to present any information.
And Mr. Maloney, understanding that you firmly disagree with a continuance, should the board decide to continue, would December 3rd be a date that the applicant could be present?
If you could give me a minute to check, just so I'm not saying something that's not true.
I understand.
Do you think we should probably take a vote there?
You can decide whether or not to grant the request, and then we can discuss a date if that makes it easier.
Okay, well, that makes sense. So while he's doing that, we can decide whether it's effective or not. So, first of all, before there's a motion made, is there any other discussion? Be interested in anyone's.
Well, I would tend to side with the applicant. I think the information has been presented by the applicant. He's only giving the assessor supporting information. I don't think we need to drag the applicant here. He might have come from, God, I don't know, maybe Florida or from across the world for this hearing. I don't know if we need to have him come to a second hearing. I don't think it's that big of a deal that he's given the information and here's just the supporting documents. So I think this is not, this is not brain surgery. I'm sure that the assessor has some other kind of information, and the assessor in the previous hearings seems to have similar information and similar access to this information. So I would vote to move ahead with the hearing.
Okay. So then, in terms of action, in the event that we, all three of us are not, don't have the same opinion, we'll, let's see. If we move, there's been a request for a continuance, so I guess I'll ask if there is a motion to continue, right? Would be the next logical step in terms
Correct,
of.
either to grant the request to continue or to deny the request to
So
continue.
I'll just ask if there, obviously, Mr. Curtis probably is not going to make the motion, so I'll ask Mr. Crow.
Yeah, motion to continue till December the 2nd. And I'm not really sure that the applicant needs to be at that hearing. If you make a decision that, there's no case, he doesn't need to be present, does he?
If after reviewing documentation, correspondence continues, and we mutually agree to something, no, he doesn't have to be there.
Okay, so, Ms.
Can I just rephrase, Mr. Crow? Your motion is to approve the assessor's request for continuance, correct?
Correct.
Okay, thank you.
I'm just going to take a moment to read that rule again, which I have here.
And I can put it back up on the screen if you'd like.
Either way, just have it.
I think he's got it on the screen up there.
D, which discusses the assessors initiating the request, and H, which says if they don't comply with D, the assessor gets a.
Uh-huh. Can you go back up to D?
Yeah, right there.
Okay. So I will second Mr. Crow's motion, although I understand Mr. Curtis's statement as well. So,
just list your votes on that.
I believe the motion, I think you said December 2nd, but I believe the date is December 3rd. Is that correct?
Well, when I restated the motion, I took the date out because I know we need some discussion on that still. So at this point, the board is just approving the request to continue, and then we'll discuss the date.
Okay, so let's vote on our screens.
Is it not working? Oh, there we go.
Okay.
Okay, and that motion does pass 2-1.
So, now, having said that, we'll need to discuss the date, December 3rd. Mr. Horn said for the assessor is okay. Mr. Maloney?
Yes, sir, December 3rd will be fine.
Okay, thank you. Okay, that's where we are.
Okay. So I'm just gonna, I think we can do that without a motion. Without motion, we're gonna continue the hearing to December 3rd.
Okay.
Mr. Chair, if I could offer 2 more comments?
Sure.
First is, number one, in spite of the technical differences we have with the assessor's office, I'd like to go on the record talking about how professional and courteous they are. They do a wonderful job here in the county. Second comment goes back to Mr. Flannery and his minor complaint about how values are determined to begin with. And if the assessor's office was to take the Blue Book value each year, subtract the state mandated 10%, I'm convinced that a whole lot of assessment appeals would go away because it gives you a much more accurate starting point, and it doesn't seem to happen. I know the people that do the original values don't talk or perhaps don't communicate well with the people that do the appeals, but I think it would be a valid suggestion for reducing the number of appeals filed in the county for aircraft anyways.
Thank you.
Thank you.
Thank you. Okay.
So that takes us to 105 and 106.
Okay, so our next items are 105 and 106, applications 17-11040 and 41. And 2 different applicants, right? Site Server Inc. and Mark McDonald. Are they related, Mr. Vlahakis?
Yeah, Mr. McDonald is here for both of those.
Okay.
Board members, clerk of the board, can we take 5? We're having a discussion with, hi, welcome. Mr. Escort is clearing up a point that may end up not making all of this necessary.
Okay. Well, let's move to our next. Who from the assessor will be representing the next item?
So if we move to the BOE 100B one, Mr. Salman Drinkus, are you out in the lobby? Hopefully, this is broadcast into the lobby, so I'm hoping he will hear. If we want to stop real quick, I will go try to find people. Oh, there he is.
There he is.
We'll jump to your case if you want to come take a seat.
So we don't, do we have findings on this one, Mr. Vlahakis?
Yes.
Okay.
You're free to stand, or you can take a seat, whatever you're more
thinking of you.
comfortable with. Okay.
Do we on both?
Okay. Application. Just keep going, he said it, so it isn't. No, this is not. This is the apartment. There's a copy of your application. And
10% penalty on this one, huh?
And do you have your documents to present? You have just going to do oral testimony? Okay. This one is, it's a state ordered penalty on whether or not to abate the penalty, so.
Understood. Yes, in this particular case, the assessor has no discretion. The penalty, and it's only up to the board to decide whether to abate. Oh,
Okay.
I get it.
Go ahead and tell me when we're in session.
Okay, apparently I never.
It is related to a penalty assessment. So could we just start with a super brief overview from the assessor of what we're looking at, and then we'll determine how to move forward.
Yes, Chairman Stern, Travis Ekema with the Ventura County Assessor's Office. We have two applications in front of you here today, which is 17-11450 and 17-11460. These are two assessor parcel numbers for one property. The State Board of Equalization determined there was a change in control of the legal entity, and the State Board requested the assessor to issue a penalty due to the change in control late filing. So the applicant, I believe, is appealing the penalty assessment regarding that change in control penalty.
And so based on that, it sounds like the burden of proof is on the applicant. Does that sound correct?
Actually, in penalty cases, the assessor has the penalty of the justification for the penalty. So the assessor would present first and close, if that's fine with the applicant, which I believe it is.
To add to that, Mr. Ekema, once you prove it, though, then the burden bounces to the applicant, correct?
That's correct. To debate a penalty, the abatement, the applicant would have to meet its burden to show that there's a reason for the penalty to be abated after I prove the justification for issuing the penalty.
I'm sorry I asked.
I know it's a little late in the day now, but yeah.
So in terms then, I just want to make sure that everyone agrees in terms of how we proceed with the burden of proof. You're saying, Mr. Ekema, starts with the assessor and ends with?
So overall, the burden of proof is just like we had regarding kind of the change of ownership. So the burden is for the assessor to establish the justification for the penalty. Okay. Now, after we justify why the penalty was placed on the property, the applicant then would have the burden, or would need to meet the requirements under the law to have the penalty abated, and meet those requirements.
Understood.
And then, of course, the board can make the determination whether or not he's made those requirements to have the penalty abated.
Okay,
so overall, the assessor has the burden.
If it's helpful, we are willing to concede that there was indeed a change of control.
Yeah.
Okay. So then we'll start with the assessor's presentation, go through the process of asking questions, then go to the applicant's presentation, do the same, and then with closing summaries, we'll start with the applicant and with the assessor. Okay. Go ahead, Mr. Ekema.
I have two sets of exhibits here. I'll tell the board one. Make sure. There's our first name. This one is not within the public inspection. But then this one is within the okay.
The whole document is not?
That's correct, yes. So the assessor has basically two packets that are being sent out. The main package are the assessor's case, as well as some additional information. The second packet is regarding the BOE 100B, and that's the change of ownership statement filed with the State Board of Equalization. That document is not open to public inspection, so we had it as a separate document so that the board could see it, but it potentially could not be put in the public record.
Okay. While we're getting these, I apologize. We're gonna have to take a recess for just 1 minute, if it's okay with everyone, and I will be right back. Okay, we're back in session, hearing items 138, 139, and the assessor has presented 2 packets. We'll call those assessor's exhibits A and B. Does that sound?
Actually, my first packet is there's exhibits A, B, and C in the first packet. The
and then
separate
D.
packet's exhibit D.
I see that.
Yes.
Okay. Thank you. Go ahead.
No problem. So let's go over on page 3 of the assessor's main packet to give you an overview of the case. KDF Parkland Limited Partnership filed with the Board of Equalization statement of change of control and ownership of legal entities, which is also known as BOE 100B, on July 26, 2016, for a change of control of the legal entity that occurred on June 30th of 2015, which was approximately over a year prior to the filing. Therefore, pursuant to Section 482B, penalties to be applied due to the late filing, which is they have to file within 90 days of the change of control. The Board of Equalization notified the assessor of the change of control event, which we established a new base year for the property, and requested the assessor to issue a 10% penalty based on the taxes applicable to the new base year value pursuant to Section 482B. As stated in the beginning of the hearing, pursuant to Rule 321C, the assessor has the burden of establishing the basis for the imposition of a penalty assessment. On the following page, I've given some information regarding the partners, one of the general partners of the legal entity, which is KDF Parkland. They are very active in the affordable housing arena. I believe they've been around for approximately the last, since 1996. They have over 5,300 rental units and 44 properties throughout California. So this is a very knowledgeable player regarding real estate in the state of California. If we go over to the page 5, these are some of the key personnel regarding KDF for their staff and so forth. Also on page 6 is one of the other general partners, which I believe the applicant here today is part of, which is Affordable Housing Access, which is another general partner. You can see Mr. Salomon Drakis is one of the senior vice president and general counsel of that entity. On page 7, this is a business search on the California Secretary of State. I believe KDF is involved in approximately, I think there's about 48, if I remember off the top of my head, entities within the state of California. So they have various holdings of real estate in the state of California. On page 8 is the actual amendment to the Certificate of Limited Partnership that was filed on June 30th, 2015. I have the full exhibit attached as Exhibit B, which indicated changes including a new address for the limited partnership, a new agent and address for service of processing, and a new general partner and a disassociated general partner. The changes of this triggered the change of ownership event in which they reported to the Secretary of State on, again, June 30th of 2015. On page 9, we'll go over the penalty assessment and what the requirements are to file. So a person or legal entity that acquires control of another legal entity is responsible for filing a change of ownership statement within 90 days of the event that triggers the change of ownership in the legal entity, where the entity or subsidiary owned or held California real property at the time of the change. So if you own property and you hold in a legal entity, there's a change of control, you're required to file within 90 days. Now, for the failure to file, if you don't file timely and you file after 90 days, then a penalty of 10% of the taxes applicable to the new base year value is required to be added to the assessment roll pursuant to Section 482B. And so in on page 10, we just want to reference the new base year value. The property has currently, I believe, a welfare exemption on the property because it does meet those standards to be exempt from taxes for the welfare exemption. However, the penalty requires us to penalize based on the base year value. And the base year value is referenced in Section 110.1, and it states that whenever a property has, it's either the 1975 lien date, or for a property purchased or newly constructed or changes ownership after 1975, it's the date on which the purchase or change of ownership occurs, or the date on which new construction is completed, and if uncompleted, on the lien date. And pursuant to B, the value determined under subdivision A shall be known as the base year value for the property. So on June 30th, 2015, we had a change in control of the property. We established a new base year of that property. The new base year for the APNs are below. APN ending in 260, we established a base year value of $16,810,000. And for APN ending in 320, established a base year of $85,000. It's a small sliver parcel. That's part of the appraisal unit. And so that was the new base year established on the property, and the assessor requested the auditor to issue the 10% penalty based on those values. On page 11, to have the penalty abated, it's found in Section 483C1, and it requires three elements. First, you have to file with the Board of Assessment Appeals Board, but they would have to establish that the late filing was due to reasonable cause, the late filing was due to circumstances beyond the assessee's control, and the late filing occurred notwithstanding the exercise of ordinary care in the absence of willful neglect. They would have to establish that with the board to abate the penalty. One thing we'd like to note is in our Exhibit D, KDF Park Glen, like I said, owns many different properties. And if we go to the last page of Exhibit D, there's actually 14 properties there that KDF is a part of, in which they've been penalized 14 times since 2010 for late filing of the BOE 100B form for various other properties. So they're aware of the filings. They've been penalized before on the filings. It comes to this point that they're aware of it. It's just they decide not to do it until the Board of Equalization appears to request them to file on that. Continue on regarding reasonable cause. We have an exhibit from the Franchise Tax Board that establishes, of course, the burden of proof is with the taxpayer to establish reasonable cause. It's the taxpayer's responsibility to file a return. Even if the taxpayer is unaware of it, they're supposed to be aware of it. Difficulty obtaining information or documentation needed is not an excuse either. We have that full exhibit in our Exhibit C for your review. So just in conclusion, the assessor, again, was notified by the State Board of Equalization. Change of control occurred. The filing was beyond 90 days, which was approximately, I believe, a year after the change of control event. The assessor doesn't believe that the abatement can be applied here, especially regarding one of the general partners has been habitually late filing regarding other properties they have for the last 8 years. So the assessor would request the Assessment Appeals Board to determine that the penalty should stay on the property and that the new base year value is what the penalty should be based upon pursuant to Section 110.1. And that concludes the assessor's presentation.
Okay, thanks, Mr. Ekema. Does the applicant have any questions of the assessor based on the presentation?
Yes, there is one issue I think that may be significant. Is it the assessor's view that the change of ownership was the change of the general partner? Because that is not what is reflected in our filing.
And that's correct, yeah. The assessor's position is not the general partner, it's the limited partner that changed. That's
correct. Correct. The change of the general partner is actually no change at all. They're a wholly owned subsidiary of Affordable Housing Access. So it's the identity of ownership there.
Yeah, but pursuant to the amendment to the certificate, I was just stating that the general partner did somewhat change, but
Yeah.
How you guys tier
That's
everything,
how
it gets
the
really
BOE
kind of complicated.
Yeah, that's how the BOE got notice.
Yes.
Yes, okay, okay. No further questions.
Okay, any questions from the board to the assessor? I don't have any right now. Okay. Now we'll hear from the applicant.
Good afternoon. As the assessor has pointed out, the assessee here is KDF Park Glen Limited Partnership, California Limited Partnership. I'm the general counsel of the Limited Partnership's managing general partner, now Park Glen MGP. This particular limited partnership owns an affordable housing community in Camarillo. It's Park Glen Apartments, 150 units. It serves tenants who earn 60% of AMI or less. And it does receive a welfare exemption, 100% this year, approximately 98% last year, and I believe a similar number for the prior base year. We are asking for relief from the abatement on two grounds. One is 483C, excusable delay, and also 482B, and that we believe the penalty amount is actually zero in light of the welfare exemption, and we'll talk a little bit about how the code reads. We disagree with the assessor's reading of 482B. It's helpful to have a little bit of understanding of how these low-income housing communities work. They are primarily financed with low-income housing tax credits. These tax credits are consumed by tax credit investors. And a tax credit investor is typically allocated 99% of the equity ownership, as far as the Revenue and Taxation Code is concerned, in the entity so that they can claim the tax credits, get the tax losses. That is a financial construct. In every practical sense of the word control, the limited partner tax credit investor really has no control. And so folks forget what Revenue and Taxation Code control means versus practical control. Practical and legal control of the limited partnership rests with general partners, including the nonprofit managing general partner, which we are. When the assessor points out that there is a pattern of failing to file BOE 100, that is because the low-income housing tax credits are earned over 15 years, actually 10 years, and then there's an additional 5-year compliance period. So when you get to year 15, the tax credit investor is looking to exit. And that happens through a redemption or a buyout by the co-GP, or they might sell to another party. Sometimes the co-general partner doesn't even know that the limited partner is selling its interest to a third party. They don't have restrictions on their ability to sell. And so what has happened is KDF, if you look at the date of formation of all these entities on their exhibit, page 7, Assessor's Exhibit A, formed a number of these deals and did tax credit syndications at or about the same time. They have recently, over the last year and a half, redeemed many of the limited partners in those deals. And unfortunately, they've made this mistake for failing to file a BOE 100 repeatedly. This is not my first appearance trying to fix these issues in a variety of counties, I'm sad to say. And so we're at where we are today, which is folks messed up and failed to file the BOE 100, not fully understanding that control, as they understand it in the practical and legal sense, is not control as the assessor sees it under Revenue and Taxation Code. And so as soon as we were notified by either the BOE or the assessor in this case and a variety of other cases, we immediately filed and notified folks of the change of control as it's specified under Revenue and Taxation Code 482. Where we are asking for relief is in that if you look at the penalty under 482B, the language says penalty for filing is 10% of the taxes applicable to the new base year value. And where the assessor is making a key omission is 10% of the taxes applicable. And we argue that because we have a welfare exemption, that there are no taxes applicable. We're exempt from taxation. And so even if there is a penalty due, 10% of zero or close to zero is zero or close to zero. So that's our first grounds for asking for relief. Our other grounds is 483C,
in which we need to demonstrate that it was due to reasonable cause. Here, I think you can imagine the confusion that control concepts has caused with sophisticated parties, no doubt. Not willful neglect. As soon as we found out, we, jumped on it and have made these filings and are here today. That's the sum of it. At the end of the day, this is an issue that has no harm or foul for the assessor because we don't pay taxes. Change of control is supposed to create an opportunity for reassessment. And what does a reassessment do here? Well, it increases the base value, but there's no more taxes to pay. We don't pay taxes.
Okay. Any other information you'd like to present?
That is it.
Okay. Any questions from the assessor to the applicant?
The agent or representative talked about a number of things. Was there any paper documents that you wanted to pass out for review?
No.
Okay.
The tax bills are clear.
I just wanted to make sure, because we submitted exhibits, and I just want to make sure the board had documentation to review if necessary. And I wanted to make sure the agent didn't walk out of here without providing that information.
I do have copies of the prior to tax year bills if you want to see the welfare exemption, but it didn't seem necessary to show that to you. It's clearly on the assessor's rolls.
Okay. Any questions from the assessor?
I have a couple questions. Are you aware of R&T Code Section 64 C and D regarding what states a change in control?
Yes, I am.
And when it talks to change in control, what does it mean for limited partnerships?
It is a transfer of more than 50% of the profit and loss ownership.
Okay, so it's not control, it's a profit and loss, correct?
That's correct.
Okay, and in this limited partnership, who has the majority of the profit?
In these partnerships, the profits are split actually in a waterfall. It's not actually very clear.
Well, who has, in that case, who has, what we're trying to determine here, you agree that there was a change of control, correct? And so the confusion is not in the law. The confusion is by the professionals in this.
I would suggest that there would be opportunity to debate whether 50% of the profit and loss has changed hands.
Okay, but that's not a question that you've appealed or you're questioning.
It's not, because frankly, I don't think we need to make a Supreme Court case out of it, because the tax credit partnership accounting would take a day of time to discuss and debate. We need to, if you really want to think about profit and loss in a tax credit partnership, you need to consider the value of the tax credits, the value of the tax losses, then you need to consider cash flow, then you need to consider capital events. And so if you were to ask me, what is the share of profit and loss? It will differ from year to year depending on where you are in the tax credit partnership's life.
Yeah, and that's reasonable, and that's typically how these are.
So you can imagine the
standard.
opportunity for debate.
Yes.
But, frankly, I don't think it's necessary to discuss that. We're willing to concede that there's a change in control on the notion that, relief be granted on these other grounds.
Okay. The next question I have is regarding the base year value. So you believe it's the net assessed value that should be penalized then?
It is 10% of the taxes. I'm reading directly from the statute. 10% of the taxes applicable to the new base year value.
Okay. So but in that code section, to your knowledge, there's no reference regarding exemptions at all, correct?
It is 10% of the taxes applicable. Okay. It says no more, no less.
Have you been aware of any legal opinions by the State Board of Equalization with that opinion?
I'm not.
Are you aware of any court cases with that opinion or any letters to assessors?
Are you aware of any to the contrary?
Unfortunately, no. The plain reading of the law seems to be that the new base year value is addressed here. Are there any other code sections that you would like to reference to the board or to myself that would establish your opinion regarding that?
Nope. I'm reading it plain as can be on the text of 482B.
Okay. So in your opinion, that since the property is 100% exempt, there would be no penalty whatsoever. So any entity that has an exemption on file for that year the base year was established, there would be no penalty ever issued, correct?
That is
That's your opinion, right? So, with other cases I believe we have some personal property cases today where they might qualify for an exemption. However, that 10% penalty will not be exempt. Are you aware of that?
I don't know the facts or circumstances or what code sections you're referring to.
Okay.
If you're trying to argue by analogy, you'd have to give me the facts and circumstances specific there. I know how the welfare exemption works under 214G, and I know 482B is clear writing. So.
Okay. And does 214G ever reference anything regarding penalties?
It does not.
Okay. And are you aware that when the assessor applies an exemption, the state makes up for the differences for that? So it's saying that the county doesn't get any money back, or there's no contribution from the state regarding any exemption issues. That's why that's why the county assessor is audited to make sure that we're doing the exemptions appropriately.
Mm-hmm.
Okay. No further questions.
Okay, any questions from the board to the applicant?
The other counties that you've been late on filing today, have you been assessed a penalty?
I have had 2 hearings on several parcels in Orange County where they were abated. In fact, it was a rather cursory hearing. They looked at the exemption and were really more concerned that the filing had been made and that everything was squared away. I have had an appeal recently in San Bernardino County that was filed late, in which we were denied appeal because the appeal was filed late. And I have appeals currently pending again in San Bernardino, and I believe that's it for right now.
As far as the tax penalty, I don't understand if you feel that there isn't any tax penalty for filing late. It wouldn't give you any incentive to file timely then, if there was no tax penalty.
That's true, but the reason for filing is to capture increased assessment.
Sure. From the state, correct?
Well, from the taxpayer.
Sure, but if there's no tax penalty, I would always file late. Right?
Why would we motivate to do that?
There's no incentive. The only incentive is that there's actually a tax penalty.
Well, our incentive is to file timely so we don't have to keep appealing these.
Right. You don't have to see us.
It's not an insignificant inconvenience or time and cost. It's not how we do business. We're in the business of running affordable housing, not appealing tax penalties.
So is this the list of?
I'm not sure what this is a list of. It appears to be a list of KDF entities and affordable housing communities. I'm familiar with some of them, not all of them.
So to the assessor, what is this list of 14 from Kathy Lynch as the filing party?
Yes. So Kathy Lynch, as noted regarding KDF Community Properties, she's the CFO. And these were the State Board of Equalization runs the legal entity ownership program. And so they collect all the information, the change of ownership statements, requests for the BOE 100B form. They make a determination whether a change of control occurred. Then they notify all the assessors in various counties. So we get usually a monthly report of every entity that either underwent a change of control and should be reassessed, and whether or not a penalty applies. So going back through our records that we had since 2010, these were 14 entities where the entity name was KDF and the reporting party was the CFO of KDF. And each time the filing was late, approximately, you can see the dates between, sorry for my acronym, so CIC is change in control date, so that's the date the entity underwent the change in control, and the date it was the BOE 100B was signed. One of the applications didn't have a signed date, but it was beyond the 90 days, so the Board of Equalization requested the assessors to issue a penalty pursuant to 482B. We do have another property in our county that will be doing the change of control and issuing a penalty for is KDF Citrus Tree LP, and then also KDF Santa Paula LP, both which underwent changes of control and they were late filing. So we have or we're in the process of either issuing an assessment rule change for the change of control, as well as issuing the penalty for the late filing.
So of these 14 late filings, a penalty was assessed 14 times?
The board requested a penalty to be assessed, yes. Now, whether the Board of Equalization requests the assessors to issue the penalty, yes.
And how many times was it appealed, and how many times?
I don't have
sustained,
the
or-
information because these are, of course, in various counties and so forth, but this is the first appeal in our county regarding a KDF property, to my knowledge.
Okay.
For the penalty.
All right.
Brendan, do I have a copy of that? 14?
Pardon me?
Do I have a copy of those 14?
Sure.
Part of this packet?
Yeah, it's in the Exhibit D.
It's the very last page of the yellow document.
Oh, thank you. I apologize for interrupting.
No other questions, thanks.
Mr. Crow, any questions?
No.
Okay. I have two questions for the applicant. Number one, I just want, for the benefit of all of the board members, you referred to 60% AMI, and I just want to make sure that everyone understands what that meant. So if you could just elaborate a little bit on that, please, what that means in terms of the nature of the property.
Certainly. I apologize for my shorthand. We use it quite a bit in the business. It's when we speak about area median income, those are numbers that are researched and published by the Department of Housing and Urban Development in the federal government. Those AMI numbers are used to figure out what people are earning on a county-by-county basis. And what HUD has thought is a reasonable amount of rent for folks to pay is about a third of what somebody earns. So when we do a tax credit subsidized affordable housing community, there are certain levels of income and rent limits that the IRS wants to see before you get the benefit of tax credits. They want to see that you're serving people that are broke, really broke, or dirt broke. And so the metrics are folks who earn 60% of area median income. And so that is an income limit. If you make more than that, you cannot live in the community, at least initially. You can grow, your salary can grow up to 140% of AMI. We don't want to penalize people for being successful. And so the metrics are typically 60% of AMI, 50% of AMI, and downwards. And then the rent that can be charged to a tenant at 60% of AMI is approximately 1/3 of the area median income, and that's determined, again, on a county-by-county basis. So these are working poor.
And so just to clarify, the justification or the reason for the tax credits for the investors is that what's being provided is low-income housing.
Correct.
Okay.
Yeah. The investors are financially motivated.
Mhm.
They are also motivated by, if they're a federal financial institution, they need community development credit from the FDIC.
Okay, thank you. And just to clarify, does the property owner pay property tax?
The property owner does not pay property tax. In this particular area, we paid zero. We were assessed a 100% exemption.
Okay, and so that's where your statement comes from then, that the penalty is 10% of the tax, which is zero? Okay, thank you. Yeah, I don't have any other questions. Thank you. Any other questions from the board?
I have none.
Okay. So let's go then to closing summaries, and we'll start, thanks, Mr. Ekman. We'll start with the applicant and end with the assessor.
I think it's helpful to point out that in some respects this has become an adjudication of KDF's poor behavior in filing BOE 100s. I don't think that's the issue that's on appeal here today. The issue that's on appeal here today is the partnership which I represent and am the general counsel of its nonprofit managing general partner, and that is KDF Park Glen. I've tried to explain how this has become a systematic issue for KDF. I can't say it hasn't happened for other parties because the allocation of profits and losses is a complex matter on the tax credit syndication. And people get it wrong. They forget the revenue taxation code. People see it in a very black and white way. When you see a 99% partnership interest transfer, well, you better file a BOE 100 to be safe. That's it. That's all I've got to say. I think I've said everything else.
Okay, thank you. And closing summary from the assessor.
Yes, the assessor again would just like to reiterate that the filing was over a year beyond the change control date. The filing was only done at the request of the Board of Equalization. This shows, even though KDF is still a general partner in the limited partnership, and so that is one of the. It's just like when you own property in tenants in common with various owners. It's kind of very similar. You have multiple partners in there that are dealing with the property. Unfortunately, the filing requirement affects them all, not just a single person. And so these requirements have been in place for many years regarding legal entities. The complication of the ownership, it does not, again, complicate the law that's in front of us here today. They filed late. The law clearly states that it is the taxes applicable to the new base year value. That new base year value is what we establish at the fair market value of the property. It's not established to the net assessed value in that case. It'd be very similar to when we have restricted value properties. We don't look at the restricted value when we're doing any type of exclusion. We look to the full base year value or the fair market value pursuant to Section 110.1 when determining that. So the assessor would request, again, the applicant provided no basis or any other documentation in any legal opinions, any annotations, any other information to dispute the plain reading in the law that the taxes, the penalty should be based on the new base year value of the property, not the net assessed value that they get after an exemption is processed. To my knowledge, when the assessor approves an exemption, the state's mandated to cover loss of revenue to schools and so forth. So when they're saying that the county does not, or the taxpayers in general do not receive anything from it, they do. There is a mechanism there, so we have to fairly assess. Because if that argument's the case, then we should just put zero on all these properties that are fully exempt. Why even assess the property? Why go through our waste of time of creating a fair market value of the property if there's no effect to anybody? And that's just not the case here. There is an effect, and as Mr. Curtis mentioned, why would you ever file then? What's the reason to file? Now, if the law said that if you're an exempt entity, there is a limit to the penalty, in which there are limits to penalties in other code sections. However, this code section has not been amended whatsoever to include anything like that. And so I believe Affordable Housing Advocates is a very large organization, and they maybe should advocate for changes to the R&T code so that they can be fairly represented and that it could be applied potentially differently to them. But in this case, it should be applied equally and equitably to all taxpayers that have undergone a change in control. And that concludes the assessor. Thank you.
I have one question of the assessor, and if this causes for other questions or clarifications, we'll make sure everybody gets their information out. It's just the same question I asked the applicant. Just to clarify, does the applicant not pay any property tax?
When you say doesn't pay any property taxes, I think we need some clarification to that because there are special assessments that would still be paid that aren't part of the ad valorem taxation. You probably could confirm that. I believe currently right now we did pull it up, and I do believe that they do have a full exemption as of the last closed roll. Could you pull up 2017 real quick? And in 2017, they had a partial exemption. And I believe you said it was about 98% exempt.
So, yes.
So that's what it appears to be jiving. If need be, the assessor can provide the clerk of the board the assessment numbers for that roll year. Because the change of ownership event, again, occurred in, I believe, June of 2015. So the first year that it would have been technically on the roll would be 2016. So we can look to the 2016 assessed value and provide that to the board and give a copy to the applicant as well, so you can have that in the record, if preferable.
Mr. Stern, you seem to have, was that answer sufficient to your
I guess
inquiry?
I think so, but I guess the question is in the row year that
Well, and
we're
I guess-
discussing right now, was
So-
there any property tax that was?
So it can vary
Or paid.
depending on if it meets the certain requirements. It can vary from year to year, and so it just depends on the requirements that are under the exemptions. So it's not always the same. It's not always the same. It can be. It's not a rule necessarily. So.
And Mr. Solomon Dracus, do you have any clarification or?
I know there was some note of special levies and whatnot, but that doesn't factor into 482D, which speaks clearly only to 10% of the taxes attributable to the base value. Those levies are outside of this discussion entirely.
Yeah, and the assessor does agree. I just want to. There might be a tax bill that shows some taxes, but it's not part of the ad valorem tax.
Understood.
Yes.
And there is opportunity in some years for a welfare exemption to go below 100%. For example, if a number of units were to catch fire and be out of service, a certain portion of the property may not be eligible for an exemption. If that was the case, and let's say 50% of the property was exempt, then I'd be asking for a 50% abatement.
Understood.
If that was the only basis on which you chose to grant an abatement.
Okay, thanks. If there are no other questions, then we'll close the hearing to public testimony, and we'll deliberate as soon as we can within reason, and welcome to check in with the clerk, or if not, a minute order will be sent out immediately after our decision. And then we did not have, we did or did not have findings? We did have findings, so we'll follow that process as well. So thank you for your time.
We have 3 more.
We have one.
That's it?
Yeah, one, right? Sometimes things just. Okay. Right. Last but not least, we have items 105 and 106. Applications 17-11040 and 41. Applicants are Site Server, Inc. and Mark McDonald. Thanks for your patience.
No problem. Thanks for yours.
Sorry? Are you still requesting findings of fact on the?
No, it's fine. After talking about that friend, I think we're good.
You're not going to request findings?
Yeah, no, it's okay.
All right. Okay, that's good to know.
And before we jump into Site Server, no, we're not. Can we take care of
the reschedule
106 first?
That was
because
suggestion.
Then we can.
Sure. Okay, so this is your residential property. 2. All right. So. Okay, I'll discuss dates off record with them.
I'm going to decline.
Yes, we are. Sorry.
Right.
Okay. Why don't we get a brief overview from the assessor, if we could, about the type of application, and we'll go from there.
Good afternoon, Efren Ascora with the assessor's office. The subject is another jet, an aircraft actually, 2007 Diamond Star. The applicant did not file a timely 2017 aircraft property statement. The applicant also indicated that the aircraft was used for personal and business purposes. They are appealing an escape assessment for lien date 2017, so the burden of proof lies with the assessor.
Okay, is there also a decline in value element of the application?
Yes, originally the applicant had appealed the original value of $200,000 roughly. Then there was another raw correction that lowered it to $24,000. So that's what the applicant is appealing. They still believe, if I'm not mistaken, that the value should come down to zero for Ventura County.
Okay, and is it the assessor's position that the burden of proof is with the applicant?
The assessor's opinion is that the burden of proof is with the assessor as we issued the escape assessment, and there's a penalty involved, or a penalty assessment involved.
Clarify. This appeal is for a regular assessment. So you're saying you did an escape assessment after the fact, increasing this number?
There was a raw correction where we reduced the original assessment.
Okay, but raw correction is different because there's no appeal rights on that. So you just reduced it after?
After it was enrolled.
Okay, so there was no increase in the assessment, though?
No.
Okay.
So you're agreeing with the applicant's opinion of value?
No, we're not.
Okay.
That would have been easy. I have slight concern on the burden of proof issue because escape assessment is different legal terminology than assessment roll correction, where assessment roll correction has no appeal rights. So
I was going with what you said, that this was an escape assessment. Which is it?
It was a raw correction. It wasn't. We reduced the value. We didn't involve any escape. We reduced. The assessor's office issued a raw correction to reduce the original assessment.
Okay, so are you still of the opinion that the burden of proof is with the assessor?
We'll take the burden of proof.
Okay, so we'll start with the assessor's presentation and then go from there with questions of that from the applicant and the board.
Okay. So you got everything? Is that okay? There are multiples here, and there we go. Let's burn this.
all right, start top. Thank you. Okay.
Okay, go ahead whenever you're ready.
Thank you. Again, Efren Ascora with the assessor's office.
Oh, wait. It's all right. You can wait.
This is the last one.
Does the applicant have all of
I
the
gave
exhibits?
all of them.
Good.
So on page 6, the board can see how we sent a copy of a 441D letter. We will request documentation from the applicant to support his opinion of value. The applicant provided copies of the aircraft logs and copies of some maintenance estimates for early 2017, showing where the maintenance of the aircraft takes place. So again, the applicant's opinion is that the whole assessment should be removed for lien day 2017. Okay, we analyzed the aircraft logs. We determined that the aircraft spent enough time in Ventura County during calendar year 2016 prior to lien day 2017 to establish CITES. We have an FAA registry on Exhibit B, showing that the aircraft for lien day 2017 was registered here in Ventura County. Originally, the original assessment was $207,020. That's in page 4. That's the summary. There's a raw correction, like we mentioned earlier, that lowered this assessment based on an apportionment. What it is that from that full value of the $207,000, we only determined based on the time that the aircraft spent in Ventura County, that only $24,400 were taxable or applicable to the Ventura County. After the applicant gave us more information to the appeal section, we determined a value of $10,800. Basically, we're following the Revenue and Taxation Code 110, Rule 10, and Sears versus County of Orange to add a component of sales tax as determined by the Assessor's Handbook and by the Board of Equalization. The taxpayer did not file an aircraft property statement for lien day 2017. However, since the original cost of the plane was well over $100,000, the Revenue and Taxation Code 5365 and 5367, a 10% penalty was added. We were required to add a 10% penalty to the assessment. If you go to the Assessor's Handbook, page 20 and 21, they talk about CITES and apportionment of aircraft. Okay, the rules of CITES apply to general aircraft as they do to other property. If an aircraft establishes tax CITES both in California and outside of California, apportionment is necessary between California and other jurisdictions. We have handled this. This is the regular approach followed by the county assessors across the state. And the rulings were established in the ISCAPACE Inc. versus County of Los Angeles. As far as apportionment goes, that was a court case. So for movable personal property such as aircraft, the amount and nature of the contract or property and its owner with the state is necessary to establish a tax CITES is a factual determination. So in general, we consider relevant factors such as the domicile of the aircraft owner, the aircraft's length in time in the state. So we did test that. The applicant was kind enough for giving us his logs, the aircraft logs. Again, we went over those and we determined how long the aircraft had touched the Camarillo Airport. The applicant owns another property that the other appeal that we were discussing earlier about postponing is another a residential property that he has here. So he has a property in California. Once again, based on the logs provided and a time test, the aircraft spent about well, actually, there's a typo. He says 12%. It should be about 7% of its time. Apologize about that. Okay. So based on that, we determine that the valuation based on Revenue and Taxation Code 110. Okay. Property Tax Rule 10 talks about adding the component of sales tax to the valuation of aircraft. You know, to, the assessor handbook 577 in Chapter 3, page 14, delves into the comparative sales approach and talks about the sales tax. Sales tax not included in values shown in the value guides. Pretty much we have to add a component for sales tax, also based on supported by the Xerox versus Orange County court case. The assessor ended up applying a 7 1/4 sales tax. Since the applicant didn't file a statement with the county, we were required to add a 10% penalty. The Revenue and Taxation codes that rule this penalty are 5365, 5367. They talk about what happens when they fail to file the statement. In annotation 100.0040 establishes that the taxpayer has a responsibility to file a signed property statement with the assessor, regardless of whether the assessor makes a request for such statement. So, you know, the assessor has to comply with the law. And the State Board of Equalization has found that even if the taxpayer is unaware of the filing requirement, ignorance of the law is not an excuse for failing to file a timely return. And we have the reference of J. Morris and Lila G. Ford's case. So once again, the assessor added a 10% penalty in conformity with property tax law, Revenue and Taxation Code. We are required to assess the aircraft, and the California Government Code Section 11344.6 requires courts to apply and enforce compliance with property tax rules. So we estimated the value again to be $10,800. And that includes sales tax and 10% penalty. And that concludes my presentation.
Okay. Does that include everything related to the other exhibits?
Yes,
Okay.
yes. The other exhibits, Exhibit C would be the logs that the applicant was kind enough to provide.
Okay.
And Exhibit D, we just wanted to include a list of all the law references that I'm making. You know, they're included in the body of the presentation, but for your reference, you can, hopefully will make it easier for you to review. And
Okay. Thank you. Let's see. Are there any questions, Mr. McDonald, of the assessor based on that presentation?
Any questions? Not per se. I guess I have some objections to what was said, but not questions per se.
Okay. And you'll have plenty of time to express whatever you want. Any questions from the board to the assessor?
So we're talking about a value of $10,800, is that correct? Okay. Instead of the 207.
And to the applicant, how much did you think your airplane is worth?
I mean, I'm fine with even the purchase price. I guess the purchase price, where is that? The purchase price is $158,000 or something. The problem is it's an out-of-state plane. My primary residence is Oregon. It was purchased in Minnesota, flown to Oregon. Its hangar is in Oregon.
Okay, we'll get to that. I just wanted a number from you.
Oh, yeah. About $150,000. Yes.
But as far as the recommended roll value, they're saying it's $10,000 because it was out of the state quite a bit.
Right. Yeah, and yeah, I mean, it was in the state.
It's zero.
It was in the state less than 5% of the year. It was 4.6% of the year. It was in California.
Okay.
Very, very minor.
Okay. No other questions.
Okay. Mr. Crow? Okay. Go ahead with whatever you'd like to present.
So part of this is it's not. I guess part of it is not so much the dollars and cents. It's the process that everybody has to go through. I have friends that fly and they go through the same thing that are from Nevada or different states. But to put it in perspective, is this a point when I Counter?
Yes.
Okay.
Any information you'd like to present?
Okay. So I guess the main thing I have an issue with is they're quoting, code that says, oh, if you don't know and you still need to file and you still need a penalty, and if and that we need to file a form if the plane touches down in Ventura County. And I'm referencing BOE Part 10, which is specific. What he's referencing is general property tax assessment, and there's a section under Part 10, aircraft assessment and taxation, Chapter 3, Section 5365. It says only upon request of the assessor of the county in which the aircraft is habitually based, the owner shall file a statement with the assessor, et cetera, et cetera, et cetera. If you're flying a plane down as a pilot, and this is my plane's worth what one of these guys' fuel pumps is. I mean, it's nothing in comparison. It's nothing. But I mean, you can be flying down the state and stop at 6 or 8 airports along the way if you want to. I mean, you can take your time and do that. And based on what they're saying, I would have a penalty and a tax bill at every single one of these airports for those wheels touching the ground in any of those airports. And I think that's why the BOA wrote this specifically for an airplane. It would be the same thing as taking your car to Nevada and them sending you a tax bill and saying, oh, you were here and you have a penalty and you owe property tax on it. I guess that's the frustration. And so I came back and I figured out what it was. It was here 4.6% of the year, and it should have a valuation of $63.96, and then it almost doubles in property tax. Sales tax and penalties, and I think it's just silly for even going through this, I guess, is my take on it.
Okay.
I think that the BOE code is very, very, very clear on what it takes to establish a situs in a habitual location for an aircraft, which Camarillo is certainly not. And
so 4.6% of the year, about 17 days during the year it was in Camarillo?
Yeah.
Okay.
Where is it, Norm? Where is it?
Bend, Oregon is where its hangar is.
Your domicile is at Simi?
What's that?
You live in Simi?
I live in Bend, Oregon.
Oh, you live in
Bend, Oregon?
I saw, what was the Simi Valley?
That's a home I own here. It's a rental property.
Okay.
Yeah, I just flew down here yesterday.
But the mailing address for the ownership of the plane is that Simi Valley?
Yeah, the mailing address for the plane is that's where our accountant is based out of Simi Valley.
Oh, got it.
But,
Okay.
all of our kids are enrolled in Oregon. My whole life is in
Understand.
Oregon.
Okay, so let's go to questions from the assessor to the applicant.
Mr. McDonald, thank you. Mr. McDonald, on your application, it has the Simi Valley address.
The 4514 Ish Drive?
Yes.
Yeah, that's an office address for Site Server.
Okay. The property for item 106 or 106, do you have a homeowner's exemption on that?
What's a home?
Homeowner's exemption is the primary residence within the state where someone says, yes, I plant my flag, this is home, and you get an additional $7,000 in taxable value taken off when you.
I don't think so. Not that I know of.
Is that a commercial address in Simi?
Isn't it an office?
Office?
4514 Ish Drive is an office building.
Not item number 106 is a residence.
Yeah, that's a
288
residence.
Valley Gate Road in Simi Valley.
That's a residence, but that's not anywhere on the plane, correct?
I just want to make sure I understand. When you say item 106?
We're on item 105, correct?
On the agenda.
Okay.
Aren't we on 105?
Correct. But 106 is also his property, which is also under appeal. And Mr. Clerk of the Board, what was the
288 Valley Gate Road, Simi Valley.
Valley Gate?
Right, and that's my property as well. That's item number 106.
And that's rented?
What's that? Simi Valley.
How long has it been rented for?
2.5 years, something like that, 3 years.
And did you live there before?
Yeah, I've lived there before. I grew up in Ventura County. I was born in Ventura County.
Do you have a homeowner exemption on that property?
I don't know what that is. I've never heard of that before. What's a homeowner's exemption?
That at one time that you declared as your home, that as your primary residence?
Probably not that one. It's probably on another home that I own
According
here.
to the county tax collector's website, he received a homeowner's exemption for 2017.
On 288 Valley Gate?
Correct.
Oh, okay.
That's according to the county tax collector's website.
Okay. Yeah, no, my primary home is in Oregon. I mean, if you want to take that off, you can.
So I'm just curious, you flew down here just for this appeal?
Yeah.
From Bend, Oregon?
Yeah. Okay. From Portland. I drove to Portland and flew down. Commercial. I didn't take a plane.
Oh, okay.
Commercial. The little planes, you can't fly through this stuff. It's cloudy and windy and rainy and whatnot.
Okay.
But, yeah, I can show you my ticket if you want.
So this, we're on item 105, right?
Correct, sorry, didn't mean to throw everybody off.
Okay.
So you're of the opinion that the value should be zero?
It can be 0 or it can be 6,300. I guess I just, more of a principle, I don't like that there's a penalty added because a plane touched down in Camarillo. I just, as a pilot, it's a bad thing. It's just not a good thing.
And I understand your concern. The Revenue and Taxation Code has set up language that allows planes to be worked on, to be to stop off and fill up with gas just because you touched, just because wheels touch down and you fill up with gas,
right,
doesn't mean that that airport gets to or that county necessarily gets to get taxable money out of it.
Right.
And the reason for that is because that's what the flight logs are for. If you can show, oh, we landed and we took off the same day.
Yeah.
Do you have, Mr. Horn, do you have any questions based of?
Yeah, how long have you owned the plane?
Since 2015.
2015?
Early 2015.
And in looking at our Exhibit B, you registered, I mean, it's not just the application, but you have the address with Simi Valley with the FAA. Why isn't it the address in Bend, Oregon, which 285 Northwest Scenic Heights Drive?
Because in Oregon they have kind of weird, but they have snow. They will literally stop delivering mail for 2 to 3 weeks sometimes, and we'll miss things. So I have all of our mail. Everything goes to 4514 Ish Drive. If you look at the plane's registration certificate, it does have 285 Northwest Scenic Heights Drive on it.
That's the account.
Everything with that plane, all of its maintenance records, all of its maintenance hangar, everything is Oregon.
And that's an office, not the home, right?
Yeah, 4514 Ish Drive.
Yeah.
Yeah, that's a office. Correct.
So you have an office and a home in Simi Valley?
Yeah.
Okay.
Is it your office?
Yeah. It's a small office. We only have a couple of people there. It's not a big office. It's just for mail and accounting and.
Okay.
I'm done.
Questions? Okay, any questions from the board to the applicant?
No.
Okay.
Chairman, sorry, do you have a question of clarification to the assessor, if I can?
Okay.
You're saying the full market value of the aircraft is $140,927, but you're only fractionally assessing it in Ventura County, and that's how we get
Yeah, the apportionment will be 10,800, yeah.
Just to clarify, we just worked that out today. That was nothing we got before this.
I was wondering, because the part what the board has to consider is the full market value. I don't necessarily care about the after the fact calculation. So you're saying the market value is 140.
146,000. That was the value that he showed us as the purchase agreement.
Right. Okay. I just wanted to clarify what we were talking about.
Yeah. My big thing, I guess, is I mean, we pay all of our bills. If I get a bill, if I get a tax form, I fill it out and send it back in. I just the whole 10% penalty thing is. I mean, any airport you ever touch down at could technically send you one of those and say you didn't file a form. But I think that's why this BOE, Section 5365 specifically says that the assessor needs to request it. And as soon as they did, we provided it. And I don't feel that a penalty should be assessed for. Before we even know that it's being assessed.
Okay, thank you. So we're going to go to closing summaries. We'll start with the applicant and with the assessor. But first, I have a question for the assessor. I'm sure you already covered this, but what triggers, or in this case, what do you think triggers the tax due if the applicant's assertion is that the plane is not based here? Are you saying the plane is based here?
No, we have to apportion the time that the plane is here.
So just number of days in the county?
Of days. Yeah, that we have to apportion it. So we're not saying, we're acknowledging that the plane has other taxable sites outside of Oregon. Like the applicant, for example, has mentioned several times today that it's a concern that every time they touch an airport is going to be taxed, but when we requested tax bills from them, from the applicant, we only received the one certificate from Oregon. I haven't seen any other tax bills from any other jurisdiction. But to answer your question, our Exhibit B shows the registration in Ventura County of the aircraft. Exhibit C shows the logs of the aircraft showing a number of days that they were here. So also, even though we don't have it here, but that's pretty much, we're following the law. I mentioned the apportionment part. We're following the law as far as everything.
So because it was registered in Ventura County?
It's the base. Yes. That's what triggered it, right?
Is it registered in any other county or state?
It's registered in Oregon. The plane is, its registration certificate is in Oregon, not here.
And you're saying it's in Ventura County?
There's an FAA, oh, sorry, go ahead.
The statement for Oregon, what's the date on that statement?
On the registration certificate? It is, where did that go? There's actually two of them in the email. The first one is 2016 to 17, and then the other one's, it's August 2016 to August 2017, and then the next one's August 2017 to August 2018.
Okay. And that was registered?
That has 285 Northwest Scenic Heights on it.
The reason why I'm asking is because those two conflict with the FAA registration.
Yeah, so an FAA registration has two things. You have your plane situs address, which is 285 Northwest Scenic Heights Drive, and then there's a mailing address where they mail all of your paperwork to, and that I have set to 4514 Ish Drive in Simi Valley. And that's just because our accountant is here.
Okay.
So I kind of see the problem is because the mailing address is the problem. Maybe you can mail it to you and forward.
I can do that. I'd be glad to update it.
I mean, you see where they're coming from. We're trying to ferret out what the problem is.
Yeah.
And I see the problem is the mailing address.
Right.
But you're in charge of that.
Right. Well, I can change it. I mean, if that's an issue, I can certainly change it.
I think that's what caused the.
It kind of looks like it is.
Yeah.
You know what I mean?
I can tell you from other airports.
We're trying to be fair. I mean, from your story, it sounds like the county's not fair, but we're trying to get from them.
Oh, no, I think they're fair. They're great to work with. Excellent to work with. I just think they are excellent to work with. And super nice guys. Nothing to do with that. I guess.
Loud, say it proud. It's going to rock me in this chair.
Very nice guys.
Let's just go one at a time. Please, go ahead.
No, like I said, I mean, I heard 3 or 4 different aircraft places in here today talking about that, and I do feel that that's being taken out of context. That if you don't know about it and you land here, you're getting a 10% penalty. I don't feel that that's how the BOE has set up for aircraft. I think it makes a lot of sense. In Las Vegas, I've gotten calls a couple of different times where we landed there and said, "Hey, your tail number's here. Have you moved your plane here?" "No, we're here for a conference or this or that." "Okay, great, no problem. As long as you're out here by this date, it's fine." We're here. It seems like your airplane's there, and you're dealing with paperwork and this.
Okay.
But yeah.
Mr. Curtis, you have any other questions? No. Ms. Crow?
And if it helps, when the plane was actually bought, it was the mailing address too was set up to Oregon, but we missed an FAA filing because they didn't deliver the mail for like 3 weeks, so we moved it down to here. So I think when we got it, I think it was set to 285 Northwest Scenic Heights. We actually moved it to Simi, the mailing address. So FYI.
Okay, so closing summaries, we'll start with, if anything, from the applicant and with the assessor. Or we didn't already do that. Go ahead.
No, I guess in closing, it would be, I mean, prefer to just take it off the rolls. So I can't imagine I don't know what kind of a tax bill would be produced off a $6,300 assessment or whatever, $6,300 assessment, or worst case, a $6,300 assessment for the time that it was in Ventura County.
Thank you. Anything else from the assessor?
Summation, the FAA registration runs from 2015 to 2018. I've got a business in Simi Valley, a home with a homeowner's exemption in Simi Valley. We apportioned the time here, came up with the value. He's claiming he didn't ask for a statement to be filed, but anything over $100,000 in value, the responsibility is his. That's why we applied the penalty. We ask that the board upholds or fines for us in our value. Thank you.
Okay, so we'll close the hearing, and we'll be deliberating as soon as possible. Our clerk will send out a minute order as soon as the decision's made. You're welcome to check in if you don't see anything.
Okay.
And thanks for your time.
Great, thank you.
Okay. So before we adjourn for deliberations, let's just get through our...
Doesn't he have an SFR?
Pardon?
I thought he was appealing something else.
Oh, the second item that he had was it continued?
Yeah, we just took over the reschedule. So
Yeah.
we have item 140 next. The findings of fact. I need a motion to receive and file the findings of fact issued since your last meeting.
Okay, and so we received those via email, and I believe we've all approved via email, right?
Yeah, it's been
Okay, so then-
several months, but they've all been
Right.
issued.
So we need a motion for item 140 to receive and file items 141 through 143.
So moved.
I'll second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow. Motion carries. And then last on the list are stipulations. I believe we received all of these ahead of time via email, is that right?
That is correct. They were all routed to you by email last week.
Okay, any questions from the board or comments? Okay, so we'll look for a motion to approve.
Some of them are, wow.
Go ahead,
Get it.
Mr. Crow.
Mr. Pruitt, you've got a question. Now's the time.
Well, there's one of them there that I was looking at it. You went from application.
We're good, right? No, yes, sir. Okay. Have a good night.
Thank you.
427347 went from. No, excuse me. Application 10774. I guess it went from 427,000 to zero. Trade fixtures.
Yes, Mutual Water Company. Reviewing their articles of incorporation, it was determined that the rights of the water company are pertinent to the parcels that the company services.
Okay.
So with that, you bring the value down to zero.
Okay, any other questions?
That's about it.
Okay, we'll look for a motion to approve the stipulations.
So moved.
Second.
Okay, moved by Mr. Curtis, seconded by Mr. Crowe. Motion carries. And so we will adjourn and go discuss deliberations for a moment.